ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ಟು ಸೆಟಲ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವಾಗ ತಗೋತಾರೆ ಸಾಹೇಬ್? ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆ
ಮಾರ್ನಿಂಗ್
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
One matter today not listed.
Wait,
You that kindly do.
wait. Give fresh matters ಎಲ್ಲ ಕೊಡಿ. Earlier memos will have precedence, sir. Yes. ಒಂದು ವಾರದಿಂದ ಕೊಟ್ಟಿರೋ ಮೆಮೊ ಫಸ್ಟ್ ಬರುತ್ತೆ, ಆಮೇಲೆ ಮಿಕ್ಕಿದ್ದು. Wait. Any mentioning, wait. ಇಲ್ಲೇ ಬಂದ್ಬಿಡಿ. Wait, ಏನ್ ಸ್ಟೇ ಇದೆ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಹಾ ಸರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಪೆಂಡಿಂಗ್, ಸ್ಟೇ ಇಲ್ವಾ? ಏನ್ ಬೇಕು ಮತ್ತೆ? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿ. ಎಸ್ ತೊಗೊಳ್ಳಿ. ಸೋಷಿಯಲ್ ಕೋರ್ಟ್ ಗಿವ್ ಇಟ್ 2:30 ತಗೊಳ್ಳಿ. ಎಸ್, ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಯಾವ್ದು ಬಂದಿಲ್ಲ ಇವತ್ತು ಅದೆಲ್ಲ ಕೊಡಿ 2:30. Give all the special court matters which have not come today, though date is given at 2:30. Yes.
Yes. Filing memo with that.
ಏನದು?
Today list, today date is given, but
ಏನ್
not.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರಾ?
House.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್
Yes,
ಮ್ಯಾಟ್ರಾ?
yes, POXO, connected to POXO case.
Boxo,
POXO connected.
it will come buddy. Yes. Settlement.
House.
Boxo settlement.
POXO settlement ಅಲ್ಲ sir.
ಹಾ.
POXO hearing 482 petition.
On ಬರ್ಲಿ, let it come.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು
Wait.
ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು.
ಪರವಾಗಿಲ್ಲ. ಎಸ್, ಮಾಡಿದ್ದೀರಾ? ಯಾವ ವರ್ಷದ್ದು?
ಹ್ಮ್.
3ರಲ್ಲೂ ಹಾಕಿದ್ದೀರಾ? ವೆರಿ ಗುಡ್. ಎಸ್, ಅದು ನೆಕ್ಸ್ಟ್ ಮೇಡಮ್, ಅದು
Special court.
ವೆನ್ಸ್ಡೇ ಥರ್ಸ್ಡೇ ಫ್ರೈಡೆ ನೆಕ್ಸ್ಟ್ ಹಾಕಿ 3.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿ ಕರೆಕ್ಟ್ ಆಗಿ.
Why are you waiting for fresh matters? I am not going to take it tomorrow. Please give all the fresh matter memos. ಕೊಡಿ. Tomorrow.
ಸ್ವಾಮಿ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಯಾವ್ದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್?
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್.
MPM ಮೇಲೆ ಕೊಡಿ 2:30 ತೊಗೊಳ್ಳಿ. ಎಸ್, ಯಾವತ್ ಬೇಕು ಅಂತ ಸೆಟಲ್ಮೆಂಟ್ ಬರ್ದ್ಬಿಟ್ಟು ಕೊಡಿ. When do you want it? So what? Give it. ಹಾ, ಏನ್ ಮಾಡಕತ್ತೆ ಕೊಡಿ. Tuesday.
My lord,
No problem, sir. ನಿಮಗಿಂತ ಮುಂಚೆ ಮೆಮೊ ಮಾಡೋರು ಇದಾರೆ, ಅವ್ರು ಬರುತ್ತೆ.
my lord, 6.
ಯಾಕೆ?
ಸೀನಿಯರಿಟಿ.
Daily you will have some memo, is it? What's the problem? Pending or fresh? Give it.
ಸೀನಿಯರಿಟಿ.
You want your passport to be impounded. Then coming in the way ಅಂತ ಇದೆ. We'll see, give it. ಯಾವ ವರ್ಷದ? Tomorrow? No, sir. Give it.
480 days, my lord.
No way. Give it. Yes. Wednesday, sir. Give it.
480 days, my lord. Settlement report ಗೆ ನಾನು 27th ಕೊಟ್ಟಿದ್ದೆ.
ಆಯ್ತು ಸರ್, ನಿಮ್ಗೆ ಯಾವತ್ ಬೇಕು ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ ಅದು ಬರುತ್ತೆ.
Tuesday ಕೊಟ್ಟಿದ್ದೆ.
ಯಾವತ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರು ಬರುತ್ತೆ ಸೆಟಲ್ಮೆಂಟ್.
My lord,
Give. ಈಗ why are you waiting? That's all right. Why are you all waiting? Give it. Give all matters.
my lord,
2:30 ಆದ್ರೆ wait.
my lord, 6 FIRs have been.
Am I
filed
not
against-
coming here? Yes. Tomorrow. Yes. You couldn't find the interim order? All right, give it, yes. Tomorrow being spoken to that. Kodi sir, freshman. No date, give it, yes. Vacating stay you give, yes. It will come, sir, yes. Kodi it, being spoken to Hakid, urgency there. Fresh, ಬರ್ಕೊಡಿ. ಡೇಟ್ ಇಲ್ಲ ಕೊಡಿ. ಏನಿದ್ರು ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಯು ಗಿವ್. 2:30 ಬೇಕಾದ್ರೆ ವೇಟ್ ಮಾಡಿ ಒಂದು ನಿಮಿಷ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್. ಕೊಡಿ. ಎಸ್, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಜ್ ಎಲ್ಲ ಒಂದು ಬಂಚ್ ಮಾಡಿ ಮೇಡಮ್, ಸ್ಟೇ ಇರೋದಲ್ಲ. ಎಸ್ ಅದು ಕೊಡಿ. ನೋ ಸ್ಟೇ ಅಂದ್ರೆ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ. ಹಿಯರಿಂಗ್ ಡೇಟ್ ವೇರ್ ಸರ್? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? 27th ಹಾಕಿ ಕೊಡಿ. ಎಸ್
Special court matter for 230 minutes.
ಹಾ
27th is the next date of our hearing.
ಆಯ್ತು ಕೊಡಿ.
Isn't it?
ಮೆಮೋ ಕೊಟ್ಮೇಲೆ ಏನು ಮತ್ತೆ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ FR ನಂಬರಾ?
Fresh matter.
ಹಾಂ ಸರಿ. ಫ್ರೆಶ್ ಮೇಡಮ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರ್ ಯಾವ್ದು ಬಂದಿಲ್ಲ, ಯಾವ್ದು 230 ಕೊಟ್ಟಿದೆ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. ಎಸ್
Admitted that she has been convicted, my lord. Prosecution sought and got the permission to cross-examine the child.
ಹಾಂ ವಾಟ್ ಹ್ಯಾಪನ್?
Hearing is on 30th. My mind is here, madam. 28th.
ಯು ಮೂವ್ ಇಟ್ ಆನ್ 27th, ಅದರ್ವೈಸ್ ಮೆಮೋ ಕಳೆದೋಗುತ್ತೆ. ಎಸ್
Lord,
ಅವ್ರು ಆ ಕಡೆಯಿಂದ ಬರ್ತಾ ಇದ್ದಾರೆ, ನಾವು ಅಲ್ಲೇ ಹೋಗಿ ನಿಂತ್ಕೊಬೇಕಾಯ್ತು.
ಹಾಂ ಸರಿ,
ನಿಂತ್ಕೊಳ್ಳೋ ಇವಾಗಲೂ ಹೋಗಿ
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ ಕೊಡಿ ಸರ್. ನಿಮಗಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ ಮೆಮೋಗಳು ಬರುತ್ತೆ, ಇದು ನಿಮ್ಮದು ಬರುತ್ತೆ. ಏನಾರು ಇರ್ಲಿ ಕೊಡಿ. ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ? ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ? ಸೋ ವಾಟ್, ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್. ನೋ ಸರ್, ನೋ ಟುಮಾರೋ, ಗಿವ್ ಇಟ್. ಫ್ರೆಶ್ ಮಾಡಿ ಟ್ಯೂಸ್ಡೇ ತಗೊಳ್ಳಿ ಎಲ್ಲ. FR ನಂಬರಾ? ಆಯ್ತು ಸರ್, ಬರುತ್ತೆ ಬಿಡಿ.
my lord, it's a fresh matter under the 650 Act. Without following the procedure set out.
ಗಿವ್ ಇಟ್ ಸರ್, ಗಿವ್ ಇಟ್.
31st is the hearing date before the trial court.
ಮೇ ಬಿ ಸರ್, ಗಿವ್ ಇಟ್. ಎಸ್
Next week.
ಕೊಡಿ. ಎಸ್
Petitioner filed 4 months old pregnant. If you decide that Aparat, you have to balance this case visa is denied.
ಕೊಡಿ, ಟೇಕ್ ದಟ್ ಟುಮಾರೋ. ಎಸ್
That's, I'm a panchayat member, my lords. I've been to the spot inspection. The complaint has made a modesty and allegations. I got the bail. Now the police is calling me every day to send a report to the SP.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
Fresh matters.
ಟ್ಯೂಸ್ಡೇ,
I moved it previously, my lord.
ಟ್ಯೂಸ್ಡೇ.
ಟ್ಯೂಸ್ಡೇ ಅಂತ
My lord,
ಕೊಡಪ್ಪ ನೀನು
6
ಅದನ್ನ.
FIRs are filed against a company director, my lord. The civil litigation came to a quietus after 30 years. They stopped civil litigation. They filed 6 FIRs in the last 3 months, my lord, against company directors, my lord. The title dispute is settled in Supreme Court.
ಈಗ ಆಲ್ 6 ಆರ್ ಹಿಯರ್, ಇಸ್ ಇಟ್?
Yes, my lord, all 6 are here.
FR ನಂಬರಾ?
Yes, FR number, my lord.
ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿ ಹೋಗಿ ತಗೊಳ್ಳಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮೆಮೋ ಕೊಡಿ ಮೇಡಮ್, ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಗೋಲ್ಡ್ ಕಂಪ್ಲೈ ಸರ್,
Will comply, my lord.
ಕಂಪ್ಲೈ ಸರ್.
I'll-
ಟ್ಯೂಸ್ಡೇ. ಎಸ್
My lord, why not to pay amount 8 weeks and the 10 weeks ago. 2 time memo of the post.
ನಾಳೆ ತಗೊಳ್ಳಿ.
Fresh matter.
ಟ್ಯೂಸ್ಡೇ.
Fresh matter.
ಕೊಡಿ ಸರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
2023 matter, Your Honor, 399 and 402. Petitioner is a convicted prisoner, Your Honor. When he was in judicial custody, the offense 399 402 implicate ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇವಾಗ on board ಇದೆ release ಗೆ due to this pending of the case or tomorrow it may be.
ವೆಡ್ನೆಸ್ಡೇ.
My lord, fresh matter, section 108 of BNS, my lord. There is a threat of being arrested, my lord.
ಟೇಕ್ ಬೇಲ್ ಸರ್.
No, my lord, she's accused number 3 in this case. She has implicated, she has not.
ಸರ್. ಎಸ್
Please, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ, ಅದು ಬರುತ್ತೆ.
Withdrawal, my lord.
ವಿಡ್ರಾಲ್ ಯು ವಾಂಟ್ ಇಟ್ ನೌ?
Once tomorrow or day.
ತಗೊಳ್ಳಿ, ವಿಡ್ರಾಲ್ ತಗೊಳ್ಳಿ. ಎಸ್
My lord, 311 of petition rejected.
ಹಾ?
311 of-
ಯಾವಾಗ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ? 7 month ಅಲ್ಲ, ಬನ್ನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಳ್ಳಿ.
ಹೀರೋ
Give it,
ಪಟ್ಟಣ
give it, yes. No tomorrow.
ಆಗೋಯ್ತು, ಆಗೋಯ್ತು.
Sorry?
ಏಯ್,
There's an urgency in this
ನನಗೇನ
matter.
ಮುಂಚೆ
Tomorrow is a day
ನನಗೇನ
which
ಮುಂಚೆ
has been issued by the court, my lord. for
Go and appear.
The PMLA proceedings, my lord. The other matters are already stayed, my lord.
You Tuesday, yes.
My lord, may I request for the end of the list, my lord.
All right.
Because
This is the matter, third memo is moved. Vacating stay, my lord, 2023, covered by lordship judgment, my lord.
Next Wednesday, but all vacating stays will come.
Passport is not being used because of the pendency. The covered matter on this picture.
ಪಾಸ್ಪೋರ್ಟ್ ಇಶ್ಯೂ ಮಾಡಕ್ ಡೈರೆಕ್ಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಆಯ್ತು ಆಯ್ತು.
Because of pendency of this case,
ಅದಕ್ಕೆ ಅಂತ ಕಾಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
not that. Urgency is that.
ವಿಲ್ ಸಿ. ಎಸ್.
Tuesday, madam. Tuesday.
ಟ್ಯೂಸ್ಡೇ ಇಲ್ಲ, ವೆಡ್ನೆಸ್ಡೇ ತಗೊಳ್ಳಿ.
ಸ್ವಾಮಿ, ರಿಕವರಿ ಆಫ್ ಮನಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
ಪೊಲೀಸ್ ಟ್ರಯಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
ಟ್ಯೂಸ್ಡೇ.
ಬೇಯಿಂಗ್ ಸ್ಪೋಕನ್. ಏನ್ ಬೇಯಿಂಗ್ ಸ್ಪೋಕನ್? ಅದು ತಗೊಳ್ಳಿ FR ನಂಬರ್.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಸರಿ ಕೊಡಿ.
ಟ್ಯೂಸ್ಡೇ ಸ್ವಾಮಿ.
ಮೇಡಮ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಡೆವಲಪ್ ಎಲ್ಲ ಪಿಟಿಷನ್ ಆಗಿರೋದು ಕೊಡಿ. ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಿ seniority wise.
ಅಲ್ಲ ಸರ್ ಸೀನಿಯರಿಟಿ ಅಲ್ಲ.
No, I can't help. Sir, somebody else has moved the memo 1 week ago. What to do? No.
ಎಲ್ಲ ನೋಟಿಸ್ ಮೇಲೆ ನೋಟಿಸ್.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Others cases are also equally important as yours. Last week ಇಂದ ಏನೇನ್ ಮೆಮೋ ಮಾಡಿದೆ ಅದಂಗೆ senior. I can't take 1000 matters in a day. There are 5000 memos pending. What to do then? No, sir. Yes.
Please.
No, sir.
Or Wednesday at least.
No, sir. Bail ಕೊಟ್ಟಿಲ್ವಾ? Bail ತಗೊಂಡಿದ್ದಾರೆ
ತೊಂದರೆ ಕೊಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ
ಎಲ್ಲಾರ್ಗು ತೊಂದರೆ ಕೊಡ್ತಾ ಇರ್ತಾರೆ.
ಮನಿ
ಎಲ್ಲಾರ್ಗು ತೊಂದರೆ ಇದೆ, ಬರುತ್ತೆ ಬಿಡಿ. ಎಸ್
My lordship, being spoken.
ಪ್ರೆಷರ್ ಪೆಂಡಿಂಗ್ ಮೇಡಮ್. Get it.
My
Give
lordship,
it.
being spoken.
Give all the fresh matters, fresh memos.
My lordship,
They will come only according to seniority. Please give.
my lordship, being
Last
spoken,
week memo
surprised.
ಮಾಡಿರೋದಲ್ಲಿ ಹಾಕ್ಬಾರ್ದಾ?
My
ಎಸ್
lordship,
ಗಿರೀಶ್, ಲಾಸ್ಟ್ ವೀಕ್ ಮೆಮೋ ಮಾಡಿರೋದು ಹಾಕ್ಬಾರ್ದಾ?
my lordship.
ಮತ್ತೆ ಎಲ್ಲದ್ರಲ್ಲೂ ಅದೇನೆ
Lordship,
ಕೊಡಿ.
being spoken, my lordship. Hand over the immovable things ಅಂತ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, movable things ಅಂತ ಆಗ್ಬೇಕಾಯ್ತು.
IM ಸೇರ್ಬಿಟ್ಟಿದ್ಯಾ ಅಲ್ಲಿ ಕೊಡಿ.
Your Lordship, one matter, Your Lordship, a 230.
Petitioner is under prisoner as well as a member of a town panchayat. Election is scheduled for tomorrow at 1 o'clock. Therefore, my lords, I seek direction for the
2:30.
Cancellation of bail. Once they have filed.
Let them file, sir. We'll see later. No, let them file. ಆಮೇಲೆ ಮೂವ್ ಮಾಡಿ.
Being to spoken.
ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ ಸರ್. ಯಾವ ಮೆಮೊ ನೀನ್ ಹೇಳ್ಬೇಡಿ, ಕೊಡಿ.
230 matter.
ನಾನು tomorrow I am not taking anything. Tuesday on seniority it will come.
One matter special.
ಏನು?
But she is Tahsildar,
Huh.
but FIR is registered against her on the ground that blood issued fake certificate.
Caste certificate.
Caste certificate.
ಹಾ.
Blood next week, first week, blood. Our brother's son is marriage. That is the reason.
ಕೊಡಿ. Wednesday or Thursday ಹಾಕಿ.
My lord, being to spoken ಅಂತಿದೆ ಸ್ವಾಮಿ.
Being spoken.
ಹೌದು
ಯಾಕೆ?
3949 ಸ್ವಾಮಿ. 392 ಅಫೆನ್ಸ್ ಅದು 9/7 ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ, ಅದು ಮಾಡ್ಲೇ ಇಲ್ಲ.
Being spoken.
ಹೌದು ಸ್ವಾಮಿ.
ಏನ್ being spoken ನೋಡಿ.
ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದೆ, ಅದು 392.
ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Fresh matter. Lordship, fresh matter, the
ಮೆಮೊ ಎಲ್ರಿ? ಮೆಮೊ ಬರ್ಕೊಂಡ್ ಬನ್ನಿ.
Lordship, fresh matter, the police have registered FIR against a sale agreement of 2014, Your Lordship. The petitioner's senior citizens, Your Lordship, is threat of arrest, kindly have it.
Threat of arrest, take bail.
Lordship, kindly have it at 13:30.
Why? What's the problem? When was the crime registered?
Your Lordship,
When was the crime registered?
time registered 1 week ago, Your Lordship.
Then take bail.
You've heard, Your Lordship.
Hey, secure bail, madam. What is this? Yes. Atrocities Act ಇದೆಯಾ?
Your Lordship.
ಇಲ್ಲ ಅಂದ್ರೆ secure bail. Atrocities ಆದ್ರೆ bail ಕೊಡಲ್ಲ. That's why I'll entertain. Yes. Wait.
Once they have filed cancellation of bail and withdrawn, again they are preparing.
ಪ್ರಿಪೇರಿಂಗ್ ನಿಮ್ಗೆ ನೀವು ಹೇಳಿದಾರ ಪ್ರಿಪೇರ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ. No problem. No. Let them prepare and file. Preparation ಗೆ no memo. ಸರಿ ಬಿಡಿ. So what? Let them file another one. Yes. No, sir. No, sir. Let them file, afterwards you move. Yes. ಆಮೇಲೆ ಕೊಡಿ. ಈಗೇನ್ ಬೇಡ. ಏಕೆ ನಾನ್ ಬೇಡ ಅಂದ್ರೆ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Next week.
ನೋ ಸರ್, ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿ.
ಒಂದ್ಸರಿ file ಮಾಡಿ.
ಅದೇ ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ರೆ ನಂಗೆ ಅರ್ಥ ಆಗುತ್ತೆ. ಮೂವ್ ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರು ಮೂವ್ ಮಾಡ್ಲಿ, ಆಮೇಲೆ ಮಾಡಿ. ಅವ್ರ ಆಫೀಸಲ್ಲಿ ಪ್ರಿಪೇರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ನಿಮ್ಗೆ ಮೆಮೊ ತಗೊಳಕ್ಕಾಗತ್ತ?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಮಾಡ್ಲಿ ಬಿಡಿ. ಎಸ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ನೆಕ್ಸ್ಟ್ ಸ್ಟೇ ಇಲ್ವಾ? ಹಾ ಸರಿ, ಟ್ಯೂಸ್ಡೇ ತಗೊಳ್ಳಿ. ಸ್ಟೇ ಇಲ್ದೇರ ಟ್ಯೂಸ್ಡೇ ತಗೊಳ್ಳಿ. ಏನು you're jumping on him? ಏನು? Wait sir. PC Act ಗೆ ಇಷ್ಟೊಂದು ಅರ್ಜೆನ್ಸಿನ? 2 weeks ಬಿಟ್ಟು ಹಾಕಿ, ತೊಂದರೆ ಇಲ್ಲ. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ. ಯಾವತ್ತಾಗಿರೋದು ಕ್ರೈಮ್? ಇನ್ನೂ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ ನಿಮ್ನ? ಇಲ್ಲ, ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ? ಎಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ? ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ. FR ಬರಲ್ಲ ಕೊಡಿ. Not able to get employment. We'll see. Give it. Yes. No, we'll see. Give it. 2:30 ತಗೊಳ್ಳಿ. ಹಾ 2023 ಇದೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ ಒಂದ್ಸರಿನೂ ಬಂದಿಲ್ವಾ? ಐ ಪ್ರಾಮಿಸ್ ಯು ದಟ್ ವಿಲ್ ಕಮ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ. ನಿಮ್ದು ಅದೇನಾ? ಅಷ್ಟೇ ನಿಮಗೆ ಸ್ಟೇ ಇದೆಯಲ್ಲ? ಎಸ್ ದಟ್ ವಿಲ್ ಸಿ. ಎಸ್ ಅದ್ಯಾವ್ದು ಮತ್ತೆ ಇನ್ನೊಂದು? ಎಸ್ ಗಿವ್ ದ ಮೆಮೋ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್
That's actually serial number 67.
ಜಕ್ಕಾ ವಿನೋದ್ ರೆಡ್ಡಿ. ಹಾ
That's it was given on 28th minutes. And I request, I have spoken with the answer. May I have it on 3rd of September?
ಆಲ್ ರೈಟ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
I understand.
ಸೈನ್ ಮಾಡಿ ಅಪ್ಲೋಡ್ ಆಗಿದ್ರೆ ಈಗ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡೋಕ್ಕಾಗುತ್ತೆ?
Because
ಅವತ್ತು
that day, if I-
ಬಂದಾಗ ವಿ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್, ಡೋಂಟ್ ವರಿ.
That's if not, date is not given, sign agide on the 3rd.
ಸೈನ್ ನೆನ್ನೆನೇ ಆಗೋಗಿದೆ ಎಲ್ಲ.
Look at it.
ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್, ಡೆಫಿನೆಟ್ಲಿ 3rd September. ಸೈನ್ ಆಗಿಲ್ಲ ಅಂತ. ಎಸ್
Lordship,
That's
kind
settlement.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವ್ದು ಬೇಕು ಕೊಡಿ ಸರ್.
Tomorrow.
Your Lordship, one matter for further hearing, my lord.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್
Yes, Your
ಯಾವುದು?
Lordship. Caste certificate matter, it was sufficiently heard.
ಎಸ್ ಕೊಡಿ.
Make one mention, my lords.
Pending matter. Serious citizens, says that serious citizens are critical.
ಕ್ರಿಟಿಕಲಿ ಇಲ್ಲ. ವಾಟ್ ಹ್ಯಾಪನ್? ಏನಾಗ್ಬೇಕು? ಏನಾಗ್ಬೇಕು ಈಗ? ನೋ, ಯು ಆರ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್, ರೆಸ್ಪಾಂಡೆಂಟ್. ಆಲ್ ರೈಟ್, ಕೊಡಿ ಅದು. ಅದೊಂದು ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆಗೆ ಹಾಕಿ ಮಾಡಿ.
Your Lordship, may I
ಅದು
request?
ಬೇಡ ಜಂಗಮ ಏನೋ ಇರ್ಬೇಕತ್ತ ನೋಡಿ. ಯಾವ ಜಂಗಮ ಇಸ್ ದಟ್?
Pardon, my lord.
ಕ್ಯಾಸೆಟ್ ಅದೇ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ಸ್ ಆಗಿತ್ತಲ್ಲ ಮೇಡಮ್. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅದೇನೆ ತೊಗೊಳ್ಳಿ.
Next Friday, my lord.
Huh.
Great.
That's one matter. After filing of the divorce petition, the wife files a complaint of poxco and atrocities. my
ಅದು
lord.
ದಟ್ ಈಸ್ ನಾರ್ಮಲ್.
That, my lord, after 1 month, we have got a bail come out. Now, every day, there is a police complaint. Police said, since there is a complaint against you, we will not register any complaint against. My lords, we have filed, it's numbered, thrice we have moved it, my lords, 2:30 if your lordship take.
ವೈ ಅಂತ ಅರ್ಜೆನ್ಸಿ ಏನು?
But because almost every second day, police itself come and take her out from the road at 3 o'clock, she comes, harasses. That's why.
Tuesday will take.
Tuesday, very
Yes. Yes, call the case.
Just one fresh matter.
Serial number 57.
No adjournment. Yes.
G. Bhagwan is.
No adjournment in the morning. We will grant it when it is called. ಏನ್ ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದಾರ? ಆಯ್ತು, ಅಂದ್ರೆ ಆಯ್ತು. 57 will grant, but not now. ಕರ್ದಾಗ ನೀವು ಇರೋದ್ ಬೇಕಾಗಿಲ್ಲ ಸರ್.
Pay to be extended.
ದಟ್ ವಿಲ್ ಡೂ. ಅದು ನೀವು ಹೇಳ್ದಿದ್ರು ಮಾಡ್ತೀವಿ.
Number 1.
The report has been filed.
Not to make on it.
Obviously, now we report will be filed.
Accept.
Accepted also. The learned additional SPP on instructions would submit that the B report pursuant to the investigation, a B report is filed before the concerned court and the concerned court has accepted the B report and the matter itself is closed. In that light, the subject petition in the form that it is pending has rendered itself infructuous, is disposed as having become infructuous.
Number 2.
This my accused have been discharged in this case.
Huh?
Discharged in this case.
The learned additional SPP on instructions would submit that the petitioners, that both the petitioners have been discharged from the array of accused on an application filed by them seeking their discharge from the array of accused. In that light, same order infructuous. Next,
Number 3.
withdraw.
Appear for petitioner, lordship. We are filed, we are withdrawing lordship. The report has filed, lordship.
Yes.
Hello.
Memo ಹಾಕಿದಾರೆ madam?
Memo, we have filed in
In
court.
terms of the
lordship.
memo. Yes, next.
Hello.
Much obliged.
Hello. Check one, sir.
ಹಾ, ನೀವು ಕಾಂಪೌಂಡ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ವಾ?
ಇದು
2012 ಪ್ರೊಟೆಸ್ಟ್ ತಾನೇ ಇದು?
First,
ಹಾ, you did not compound the offense like others?
Your Lordship, I am a sitting MLA, your Lordship.
Fine ಹಾಕಿದಾರೆ ಅಷ್ಟೇ.
ಅದೇ ಎಲ್ಲರೂ ಫೈನ್ ಕಟ್ಬಿಟ್ಟು ಎಲ್ಲ ಆಗಿದೆ.
ಹೌದು.
ಇವ್ರು ಮಾಡಿಲ್ಲ ಅದನ್ನ.
Because I have not attended your Lordship, not participated in.
The government is not even there.
No, but the fact that my co-accused have been
ಅದಕ್ಕೆ
accepted
ಇವರು
the guilt.
ಮಾಡ್ಬೇಕು ಅಂತ.
They have accepted the guilt. My question of quashing
may not arrive.
Two FIR has been filed. I have not.
In both
attended
FIR,
For the same offense.
in both FIR, they have pleaded guilty.
Learned additional SPP is direct, ಆಗಿದೆಯಾ notice?
Notice ಆಗಿದೆ.
ಆಗಿದೆಯಾ? ಇಲ್ಲ ಆಗಿಲ್ಲ, ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ. ಲಾಸ್ಟ್ ಟೈಮೇ ಬಂದಿದ್ದದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ. Additional SPP is directed to accept notice for the respondent. List the matter on 19th September till such time further proceedings before the concerned court quay the petitioner shall remain stayed. Avat will close it.
Five,
Same, 4 and 5 same.
six,
For petition, for 3 weeks time, my lord.
364.
In fact, my lords, magistrate has.
We'll answer the RR first.
The magistrate, in fact, my lords, has not taken cognizance in respect of 364A because there is lack of material.
Where is the order of cognizance?
That's it. We are yet to receive the copies, my lord.
Huh?
Day before yesterday, matter is registered as CC. We are yet to receive the copies, my lord.
364 cognizance ತಗೊಂಡಿಲ್ಲ.
Tಗೊಂಡಿಲ್ಲ. That is my instruction.
Yes, sir.
ಹೌದಾ? No information.
That's what.
I'll collect.
For my lords, my colleagues after 2 weeks.
Pass over ಮಾಡ್ಲಾ? Or
Next week.
next Thursday ಇದೆ ಮಾಡಿ sitting. 29th ಇದೆಯಲ್ಲ. Correct. Then 30th shift ಮಾಡೋಣ. 30th.
Please.
List on 30th. Madam, next week 29th ಇರೋ ಮ್ಯಾಟರ್ ಎಲ್ಲ 30th ಹಾಕೋಣ. ಗೊತ್ತುಂಟು already.
Friday.
Huh?
30th Friday.
ಪರವಾಗಿಲ್ಲ, ಅದು 29th, the other matter is there and already 51 is there. 2:30 I have listed that
Yes.
CM's matter.
It's 29th of this.
Because that may go on for some time.
So these cases may be shifted
To 30th.
seven,
petition is not.
155 2
It's 26.
ಆಗಿದೆಯಾ?
The 155 one violation act.
ಏನು one ಏನು?
They have to refer the informant, my lord.
Then that is no longer a good law, sir. Informant only need not go. I have myself distinguished it.
Word by lordship judgment, my lord.
ಯಾವುದು?
Prakash's case.
Subsequently, Brijesh Pillai after Lord.
Vijesh Pillai, sir. That argument goes. The informant alone need not go to the magistrate. The SHO also.
The order of
The-
my lord,
ಏನು?
the permitting order which is passed by magistrate.
ತೋರಿಸಿ. Yes.
Lord, lack jurisdiction as held, my lord, in
ಏನ್ jurisdiction?
your lordship's, my lord, in the case of
Where is the order permitting the registration of FIR?
26, man.
26.
ಓ, ಇದಕ್ಕಿಂತ ಆರ್ಡರ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
Allala. Oh, my lord, the order, the lordship's, my lord, in criminal petition, writ petition number 18116 of 2024.
ಹಾ.
Not have held, my lord, it was submitted, not the cognizance, my lord, or my lord was taken, lacking jurisdiction.
Why? Who has taken cognizance now?
Allah, here, my lord, 155 mandates that, my lord, the court having the power to either try the matter or, my lord, commit the same. In case of, my lord, special court, my
No,
lord,
who
will
has
have all the-
taken cognizance?
Magistrate,
Ah,
magistrate.
yes.
That my lord, that may not vitiate the entire proceeding because.
No, I will send it back to the special court.
Yes, yes,
I am not going to quash the whole thing. ಇನ್ನೆರಡು stay ಮಾಡಿದ್ದೀನಿ, only to send it back.
yes, man.
Allah, stay, la, fresh matter.
ಇನ್ನೆರಡು ಅಂತ ಹೇಳಿ identity. Yes. The learned additional SPP is directed to accept notice for the respondents. ಇಬ್ರು ನೀವೇ ಅಲ್ವಾ? 171E
ಹೌದು.
respondents. List the matter on 19th September. There shall be an interim order of stay of further proceedings. Query the petitioner till the next date of hearing.
But serial number 43 is also similar matter, my lords.
You
Fresh
mention when 43 comes.
Please. Correct.
eight,
Protest.
Matter is now stayed by the Supreme Court.
Yes.
The criminal petition was dismissed here. It got stayed in
know,
the Supreme
yes,
Court.
yes.
So, my lords, the stay order granted to the other petitioners, it just revives and we stand on the same footing.
Where is that order?
My lords, the Supreme, page 142 is a SLP order.
Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. Co-accused were before this court in criminal petition 7533 of 2023, which comes to be dismissed on 6/2/2024. The dismissal of which was tossed before the apex court, and the apex court has stayed the order of the stayed the order which issued certain directions after dismissal of the petition. The petitioner is a co-accused along with those accused who were petitioners in the aforesaid criminal petition. In the light of the interim order granted by the apex court, there shall be an interim order of stay of all proceedings, all further proceedings before the concerned court quay this petitioner. Objections hakbeka?
Connected matter like it.
In fact, my lords, the coordinate bench should say that you have a right to seek discharge.
Sir, it's
Some-
a non-cognizable.
Someone's case, no discharge, 10,000 cost was imposed.
At that time aware.
Obligement.
38 in a connected matter.
ಅದು ಕೊಡಿ ಮೊನ್ನೆ ಸ್ಟೇ ಮಾಡಿದ್ವಿ. ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ವಿ. ನಂಬರ್ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ ಟ್ಯಾಗ್ ದಿ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಸೌಂಡ್ಸ್.
With the council name Srinivasrao SS.
Huh?
Council name Srinivasrao SS ಅದ್ರಲ್ಲಿ ಇದ್ದಾರೆ.
ಅಶ್ವಿನ್ ತೆಗಿಬೇಕಾ? ಅಲ್ಲ ಸಾರಿ ಇದು ಚಂದ್ರಶೇಖರ್ ತೆಗಿಬೇಕಾ?
ಇಲ್ಲ ಅದ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಶ್ರೀನಿವಾಸರಾವ್ SS ಇದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್. ಅವ್ರ ನೇಮ್ ಪ್ರಿಂಟ್ ಮಾಡಿ ನಮ್ಮ ಮ್ಯಾಟರ್.
Sir, should I take out the name of Chandrasekhar? Then ಪರವಾಗಿಲ್ಲ, ಎರಡು ಟ್ಯಾಗ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಡೇಟ್ ಮೇ ಬಿ
Next.
ಡೇಟ್ ಮೇ
19th. ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ವಾ? ಬೇಡ 26th ಬರಲಿ. ಎಸ್ 26th ಅಲ್ಲ 26th ಸೆಪ್ಟೆಂಬರ್.
10.
It's in 10 lots.
ಅಲ್ಲ this in this is sentence suspended statement. Yes. ನೋಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ. ಓಕೆ, ಇದು Robling sir.
Sir.
This identical order should be passed in all cases.
Yes.
That's what the coordinate bench has done.
But of course, just one sentence I want to say, but subject to what ultimately lordships will say, because I have appeared in that case, therefore I
That's
cannot,
why- that's why
I
it's
do
a
not want to.
practical.
But what happens is not the forest officials go to a particular spot alleging that there is an encroachment of a forest land. But I am a member of the Legislative Assembly. The person to whose house they go comes and makes a representation to me. I go to the spot. Number under the Forest Act Section 61, if there is an encroachment, the forest officer is expected to issue notice here and then pass an order. He, even according to their own admission, tries to remove the encroachment by himself. Who? The forest official.
All right.
But at that point of time, I protest not as a member of the Legislative Assembly. They say you have prevented me from discharging my official duty. The question of law, which I only thought I should urge before your lordship. If lordship feel I should go back to the trial court, I'll do. But it is this not.
No, you can.
The question is this not whether if an officer acts in excess of his duty conferred, whether the provisions of 353 will be attracted. That is the question which I thought I must bring to lordship's notice. But may I request lordships to kindly see the statement made by them about what they were doing at the point when resistance came from
Page
40, 46.
But there are 3 or 4 cases against you which are listed.
Allah, adu one the hate speech. That's nothing.
Allah, whatever.
If lordships, I will not argue further. If lordships feel I should go before
Sir, you
discharge.
are
No, this is the only question of law. I thought I must bring to lordship notice.
Yes,
And
definitely.
not only petitioner, but all of them have been persons who were allowed, driver who had driven his car, all of them have been made as an accused. Page 46.
ಇರಲ್ಲ.
Idralli.
All cases are same.
Alla caseallu our alla followers ella
Accused 13, 15.
Idralli 50 minute and the other one is 37.
ಎಲ್ಲ
All the followers, party bearers, ella. But 46 not just 2 sentences I want. Page 46. ಒಂದನೇ ಆಪಾದಿತರು ಸೋ ಅಂಡ್ ಸೋ ಚಾರ್ಜ್ ಉದ್ದೇಶಿಸಿ ಕೈ ಬೆರಳು ತೋರಿಸಿ ಹೆದರಿಸುವ ಇರಾದೆಯಿಂದ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಅವಮಾನ ಮಾಡಿ ಕರ್ತವ್ಯದಲ್ಲಿರುವ ಅಧಿಕಾರಿ ಹಾಗೂ ಸಿಬ್ಬಂದಿರು ಉದ್ರೇಕ ಉಂಟು ಮಾಡುವಂತೆ ಪ್ರೇರಿಸಿ ಏಕವಚನದಲ್ಲಿ ಏರುದನಿಯಲ್ಲಿ ಬೈದರು. I can't read that much. What he has said, which I will avoid, but what they say discharge of the duties is this.
ನಾನು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಲೋಕನೌಕರನಾಗಿದ್ದು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವಂತೆ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ನಿಲ್ಲಿಸಲು ಬಿಡುವುದಿಲ್ಲ ಅಂತ ಮಾಡಿದ್ರು. He says, I had gone there to remove the encroachment, this forest officials. Now section 61 of the Forest Act. If there is encroachment, 60. But it is he acts as a quasi-judicial authority. And he is expected to issue notice and hold inquiry in case there is an encroachment. Therefore, but admittedly, my lord, even according to them, they had not followed that procedure. They had gone for a forcible removal.
64 inquiry ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
No, the point is not that. The question is, my lords, if an officer not in discharge of his statutory duties, but does something, my lord, in excess of the duty, and if someone protests against
So
that,
you can also do something in excess of law.
no, sir, my lord, just my lord, of course, my lord, the allegation is that, my lord, I went there and
You
that is
stopped the forest officials from performing their duty is what.
is the allegation. The question is not but I'll just repeat once again. Where the forest officials expected to go there and remove the encroachment by themselves when the law requires them to hold a quasi-judicial inquiry. That is the point. In such a situation, whether 353 is attractive. That is the point which I thought I must bring to Lord's.
Yes, sir.
No, but
Allah, you have anything?
I might just
350 judgment.
350, yes.
353 I've seen. Then
No judgment on that. This is the position what I thought I must. But petitioner number 2, my lords, is a member of the Legislative Council. He has got nothing to do with, and others, my lord, of course, even according to the complaint, there is nothing stated.
Yes, sir.
but the order of coordinate bench, my lord, from the same set of facts on same person.
Same.
They
set
are
of-
also same.
Alla,
because
same
they are
set
also,
of
my lord,
facts. ಅಲ್ಲಿ ಸ್ವಲ್ಪ it was more
police station ಅಲ್ಲಿ
police station ಗೆ ಹೋಗಿದ್ರು ಅವ್ರು.
ಯಾರು ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದೀರಿ ಅಂತ ಹೇಳಿ police station ಗೆ ಹೋಗಿದ್ರಿ ಅಂತ ಅಲ್ಲೂ they held a protest in the police station also.
Absolutely.
353 ಅಲ್ಲ?
There, my lords, he had gone to the police station, and of course there was an illegal arrest. He had gone to protest, and they said, "No, this you have come to forcibly prevent us from undertaking the process of arrest, etc." But I agreed there. In fact, it was his submission, and in all fairness, I have agreed there. There is no dispute about it. If lordships feel that this question has to be considered by the trial court, we will go back and urge all these questions. But if this is something which lordships feel requires to be decided here, then we will be.
353. Read 353. Stopping the public servant from performing his duty by usage of criminal force.
Yes.
There should be prima facie material that criminal force is used to stop these people from discharging their duty.
No, but coordinate bench, my lord, the same set.
Coordinate bench
No.
ಬಿಡಿ.
Same set till.
Same set of
Dayvidu
facts.
same.
There also, my lord.
ಅಲ್ಲ, you leave it. We will send it back on. But 353 attract ಆಗಕ್ಕೆ, what is it you tell? 353.
Yes.
If I read wrong, please tell me.
Correct, criminal force.
As far as I have seen, it is so.
Were assaults, sir.
Assault or
What
criminal
use of criminal
force.
force.
The
To any
title itself, sir. Assault or criminal force to deter public servant from discharge of his duty. Whoever assaults or uses criminal force to any person being a public servant.
Or with intent or deter that person from discharging the duty. It's not necessarily criminal force, my lord.
No, uses criminal force any person being a public servant in the execution of his duty as such public servant, or with intent to prevent deter from discharging duty of public servant, or in consequence thereof attempted to be done by lawful discharge of duty. Yes, sir.
Page 46, my lord. Column number 17 in the charge sheet. Lordship speaks all these things.
Anyway, we'll answer it. ಡಿಸ್ಚಾರ್ಜ್ ಕಳಿಸ್ಬೇಕು ಅಂತಾನೆ.
My submission, lords, would be on this question, lord, about that whether it was in discharge of the duty, lord, I prevented them.
No,
But
that,
if-
see,
lord, kindly
discharge of
visualize the
duty,
situation.
discharge of duty, whether it is in excess or falling short of it, is not a matter that can be,
Lord, on the face of it, lord,
if
even
it
for-
was illegal on
instance-
their part. you can
For
take
instance,
action.
lord, if an officer does something, lord, which is not part of his duty, and at that point of time,
It is a part of his duty, but he did not issue notice and remove the
So,
encroachment.
no, in fact, the provisions of the Forest Act, lord, I'll be in a position to bring to lordship's notice.
No, that will be a very dangerous preposition.
No, lord, he, for instance, lord, if he comes without the authority of law and comes to demolish my building, obviously, lord, it is not in discharge of his
So
office.
that doesn't mean that you can take law.
No, I cannot, the question, lord, I have not taken law. I, as a responsible member of the Legislative Assembly, when a grievance is made out, I have gone there and asked them, why are you doing these things?
We'll see, we'll answer this.
Only on this question, lord, I
ಅವ್ರು
want.
ಕಳಿಸ್ಬೇಕು ಅಂದ್ರೆ ಡಿಸ್ಚಾರ್ಜ್ ಕಳ್ಸೋಣ. ಇನ್ನೊಂದು ಯಾವ್ದು?
No, this is the only one.
All these three matters have, this is the
Three are
different
what
matters,
is-
two matters have been sent back
Hmm.
and one matter is pending.
No, this is the only case. There is no other case. ಯಾವ್ದು ಮತ್ತೆ ಯಾವ್ದು ಇಲ್ಲ.
Where hate speech.
No, that is disposed of. That's disposed.
The hate speech, your lordship may see the hate speech also, the whole contention is, I have done this in the past, that I'll go to police station, I'll get case not been filed against you, I'll do that, I'll do this. Don't worry about it, do whatever this
Not
thing.
arguing
This
that
is-
case, not when
no,
it comes to it, let him make submission.
This is exactly the same thing. It is, the officials want to discharge their duty, madam, maybe if it's illegal, my lord, then he can take.
No, that cannot be the ground for you to.
But I'll also
Committed-
show before your lordship, by the charge sheet ever-meant, there was a question of criminal force or bloody, an intent to prevent him. But I just go there and protest. But of course, not today it is easy for them to say, I said certain expletives. But the fact of the matter, my lords, is what happens, my lords, in a situation where the member of the Legislative Assembly is asked to intervene. But it sometimes becomes necessary for me to go and at least ask me. If not, my lord, there would be no occasion. But I have not gone for any personal gain of mine. I have gone on behalf of the people, not when some.
True, that doesn't mean.
No, I'm only bringing to lordship's notice. Kindly see the background. On this question, we'll address your lordship's.
Let me see
Please.
what can be done. Now, ಯಾವ stage ಅಲ್ಲಿ ಇದೆ ಈಗ?
It just, they have filed charge sheet.
It
Someone
can
says-
wait till next week, we will.
Please.
I will answer.
Can it be
this.
week after next month if it is
All right.
convenient?
This is, we'll take it on the 5th. 5th of September.
Yes, please. The interim order is there, but it can be continued.
There it will continue, yes. Let's the matter on September the 5th, 2024, for further hearing. Interim order subsisting shall continue till the next date of hearing.
Order 11.
Police
This-
report
there's
awaited.
some non-compliance they want to pay.
Yeah,
A week's,
ನೀವೇ ಹೇಳಿ.
11th month.
11, ಅಲ್ಲ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ awaited ಇದೆ. Post immediately after, ನೀವು ಯಾರಿಗಾರ?
11.
11. Second list ಅಲ್ಲ, first list.
First list 11.
ಹಾ.
Good. For respondent, I entered to file wakala.
Learned counsel,
Rakesh.
Rakesh Bhatt ಅಲ್ಲ?
Bhatt.
Learned counsel Rakesh Bhatt undertakes to enter appearance for the respondent. Register to print the name of Rakesh Bhatt as appearing for the respondent. Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
That's the matter on 19th September.
12.
Post immediately after service of.
B report ಆಗಿದೆ.
B report. Learned additional SPP on instructions would submit that the police after investigation have filed a B report before the concerned court
Against this petition.
against Quay, the present petitioner. In that light, so and so disposed reserving liberty in the event. ಗೊತ್ತಲ್ಲ madam? Yes. Closed.
13.
ಇದು ಅದೇನಾ?
The awaiting report. There's an interim order granted.
Post immediately after service of notice upon the second respondent. Interim order subsisting shall continue to the next date of hearing. List on 19th September. and ಮಾಡಿ. Yes.
14.
Similar. Awaiting report. In respect of R2.
Same order.
Interim order.
Huh?
Interim order may be.
And?
Please.
15.
This case, my lords. I request my lords meet on 29th, my lords,
Another bail.
bail, my lords, anticipatory bail.
It's a new case,
Huh?
new case.
New case,
New case.
please,
Notice only.
please, ma'am.
Another matter, my lords, 29th. Same
29th,
petitioner,
29th ಬೇಡ 30th.
please.
Yeah, 438.
ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಬೇಲ್ ಇತ್ತಲ್ಲ ಅದು.
Ah.
ಎರಡು ಡಿಫರೆಂಟ್ ಕ್ರೈಮ್ಸ್.
ಅದು
Friend, friends.
ಎರಡು. Less the matter on the additional SPP. Sir, ತಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬೇಕಾ?
Yes.
Learned additional SPP is directed to accept notice for the respondent. Heard the learned counsel for the petitioner and the learned senior counsel, Professor Ravi Kumar, representing the respondent. List the matter on 30th.
Much of
5th September. 5th September.
much of.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಬಿಡಿ. Yes.
Petition 16.
Brave 1 week's time, madam.
ಅವ್ರು ಕೇಳಿ. ಹಂಗೆ ಅಕೌಂಟ್ ಸ್ಪೆಷಲ್ PP ಅಂತ. ಸ್ಪೆಷಲ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್.
I pray 1 week time, my lord.
ಟೈಮ್ ಬೇಕಾ? Cancellation of bail.
My lord, the council on record is,
Well, where is Sarthi?
he's gone to Dharwad, my lord.
ಬೇಲ್ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ. List on 12th September at the request of the counsel for the petitioner.
Much obliged.
Yes, next.
17.
Very good petitioner.
I think R2 my lord requesting for some accommodation.
ಎಲ್ಲಿ ಸಿ ಜಗದೀಶ್ ಬರೋದೇ ಇಲ್ಲ.
ಗುಲ್ಬರ್ಗ ಇಂದ ಈಗ ಬರ್ತಾ ಇದೀನಿ, ಲೇಟ್ ಆಗತ್ತೆ ಬರಕ್ಕೆ.
ಆಯ್ತು.
ಫೋನ್ ಮಾಡಿದ್ರು ಬೆಳಿಗ್ಗೆ.
ಬಟ್ ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ವಾ? ಇನ್ನೊಂದು ಕೇಸ್ ಆದ್ಮೇಲೆ
Please.
ಫ್ರೆಶ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
ವೈ
ಅಲ್ಲ ಅದು
ಅದು ಮಾಡ್ಬೇಕಾದ್ರೆ
ಖಾಜಾ ಪಕ್ಷ ಅದು ಬೇರೆ. This is ಯಾವಾಗ 2018 ಮಾಡ್ರಿ.
ಅದು ಪರವಾಗಿಲ್ಲ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
It's another ಖಾಜಾ ಪಕ್ಷ, fresh ಖಾಜಾ ಪಕ್ಷ.
ಹಂಗಂತ ಯು ಕ್ಯಾಂಟ್ ಸರ್ಚ್ ಅನ್ ಎಸ್ಕೇಪ್ ರೂಟ್ ಹಿಯರ್.
ಅಲ್ಲ,
ಸಿ ಜಗದೀಶ್ವರ್ ಬರ್ಲಿ. Learned counsel C. Jagdish seeks time, yet again, to file his statement of objections or make his submissions as the case would be. Since the matter is of the year 2018, list this matter on 5th September as a last chance. 12th September.
Third week.
19th September. But 12th September is the last chance.
Interim arrest.
ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಹಂಗಾರೆ 29th ಹಾಕ್ತೀನಿ. Yes, 12th September as a last chance. Interim order subsisting shall continue till the next date of hearing.
Much.
15.
Hate speech. Petitioner. Lordship had after detailed interim order, my lords, wherein the lordship had detailedly dealt with the
Yes,
application of the provision.
The FSL report has to yet to receive, Lord.
Yet to receive.
If-
9/6/2023 lo ಅದೇ ಇದ್ದಿದ್ದು.
Lord, we
Public
produced
speech
the
ಅಲ್ಲಿ
entire-
ಏನಿರಲ್ಲ ಅಲ್ಲಿ.
Lord, the entire CD has been placed before the IO. The sum of the part was culled out in the complaint. Entire speech was delivered on that day, was produced before the IO. Lord, the investigation officer has to ascertain whether in the entire speech, there is a prima facie material to continue with the investigation or not. Lord, the FSL report. And there's
ಯಾವ
furthermore direction from this
ಬಂದಿದೆಯಾ
court.
FSL?
Not ascertained. my lord.
ಏನ್ ಕೊಡಿ?
Antecedent of the
But the-
petitioner.
The direction from
Same.
it.
Same petitioner. ಕೊಡಿ.
Yes,
My information is that after registration of this case, there are 4 more FIRs were registered.
ಅದೇ ಎಲ್ಲ ಇದೆ ಸರ್.
ಎಲ್ಲ same after
ಎಲ್ಲ
that.
ಇಲ್ಲೇ.
Same modus operandi, my lords, against this
ನೋಡಿ
person.
ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಈಗ.
ಹೌದು.
ಅದು ನಿಮ್ ಎಗೇನಿಸ್ಟ್.
ಅದೇ
ಕೊಡ್ತಾ
ಎಲ್ಲ
ಇದ್ದಾರೆ
ನಮ್ಗೆ
ಅಷ್ಟೇ.
against ಫೈಲ್ ಮಾಡ್ತಾ ಇರೋದು ನಮ್ಗೆ against, my lord. They are targeting me as if no other person is doing any crime.
ಅಲ್ಲ, ಈ
They are literally pointing it out on me.
That doesn't mean that you should do so.
No, I am not doing,
then-
I'll convince your lordship that
Ah.
in no cases that I've been accused of
ಆಯ್ತು.
committed any wrong.
FSL ಯಾವಾಗ ಬರುತ್ತೆ?
week after next month.
List the matter on 5th September. A learned counsel for the respondent submits. ಅಲ್ಲ, ಅದು ಆಮೇಲೆ ಬರೀರಿ 5th September. Learned counsel for the respondent submits that the report from the forensic science laboratory is not yet received. The same submission was made on 9/6/2023 when the interim order was granted. It is already a year. FSL is not, the report from the FSL is not yet received. Therefore, the report shall be secured on or before the next date of hearing, list on 5th September.
Interim order.
Interim order subsisting
Great.
shall continue till the next date of hearing.
Obliged.
19.
And for the advocate for the respondent number 2 also.
Amit Kumar.
Yes, Lord.
Yes.
Top Panchayat. Top Panchayat.
ಗೊತ್ತಾಯ್ತು 3-1 R&S. Detailed interim order.
ಅಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್ ಸಿ ಇದರಲ್ಲಿ
ಇದ್ರಲ್ಲೂ FSL.
ಅಲ್ಲಲ್ಲ because she married to somebody different caste. She basically my lord that the
In the police station, it is said to have hurled abuses.
because they escaped and they filed a missing complaint. The victim and the her boyfriend was traced.
And it was recorded in the mobile phone which is
Yes,
sent
ma'am.
to FSL.
Yes, my lord.
ಇದು ಅಷ್ಟೇ 23/6/23.
Report has come.
ಎಲ್ಲಿದೆ?
Report has
ಕೊಡಿ.
PD shows, my lords, that there is a tallying of the voice. In fact, your lordships have not been brought to the notice of this court by the petitioners that earlier 482 petition was filed, where there is a finding of this honorable court that there is already a case made out against the petitioner.
Where is that?
That is along with the statement at page number 41 of the statement, my lords will see criminal petition number 101431 of 19, dated 28th of
1414, page 40.
41, my lords, is the criminal petition 101431 of 2019, dated 28/10/2021. The relevant paragraph is para 10 at page 53.
Same petitioner,
Same petitioner, this was at the stage of FIR. Now, my lords, after filing of the charge sheet, instead of applying for discharge, they have come up before your lordships now. Kindly see page number 53.
Where is the petitioner? Who appears to the petitioner?
They gone to Supreme Court. Supreme Court confirmed the order of this court.
Oh.
And in
Page
fact, the bail also,
53, my lords, will see last 7 lines.
It's a detailed order.
Yes.
It's a detailed order. Last 7 lines in page 53, on going through.
Like the two orders of Supreme Court, my lord, your lordship may see the two orders of Supreme Court. One on the bail issue, one on the challenging this issue.
The counsel for the petitioner remains absent. Heard the learned senior counsel Amit Kumar Deshpande appearing for the complainant, second respondent. The learned senior counsel would take this court through the objections filed with particular reference to a criminal petition in criminal petition 101431 of 2019 filed by the very petitioner on the very same cause of action. This comes to be disposed by an order dated 28th October 2021, dismissed by 2021. This is tossed before the apex court in SLP. 1 minute. In SLP 3290 of 2022, the apex court, again by a detailed order, rejects the petition. This was at the stage of crime. The finding so rendered by the coordinate bench is clearly indicative of the fact that further proceedings must go on. Filing of the charge sheet has driven the petitioner again to this court in the subject petition.
May I, my lords, correct?
What is it?
Criminal SLP number 3290 is not out of this criminal petition 101431. That is a matter where an anticipatory bail was filed before this court and it was rejected.
Which is the SLP, sir? Which is the one that was filed against this order?
Yeah, I will provide that also.
Justice Uma order. Adu madidra?
How? There is no detailed order, it's only.
I have it. Last.
One moment.
Last.
Three 3290 ಇದೆ ಇದರಲ್ಲಿ. ಸೇಮ್ ಆರ್ಡರ್ ಇದರಲ್ಲಿ ಇರೋದು ಅದೇ. Tossed before the apex court anta ಮಾಡಿ ಸಾಕು. So in that light, the remedy that was available to the petitioners was filing a discharge application seeking his discharge from the array of accused. Notwithstanding the aforesaid, the petition is preferred and an interim order is granted and subsisting today. There is no representation. As observed, there is no representation on behalf of the petitioner. In the event there would be no representation on the next date of hearing, the petition would be answered on the submissions of the learned senior counsel for the respondent. List the matter on 30th and the fresh matters list.
Like that is not even pleaded.
ಏನು
Petition.
I will reject it, please. But ಇಲ್ವಲ್ಲ ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ನಮಗೆ ಇರ್ಲೇ ಇಲ್ಲ ಕೇಳಿಲ್ಲ. Yes,
Okay,
sir.
great.
Yes, yes.
Hearing for the
For the
petitioner,
respondent.
I seek for a week's time.
Bagair Hukum Sagoli Chit,
It's the
just
first time
like
they
the
are
earlier
taking-
land grant.
My lords, next date we will address our.
Fourth time they are taking adjournment.
Interim order ಇದೆಯಾ?
ಇದೆ sir, 1 year in the operating.
ಇದು ಅದೇ ತರನಾ?
Same all over our case. madam.
ಅದೇ same.
Yes, same madam. 2,750 of acres.
ಎಷ್ಟು 750 acres ಇದು?
Yes, madam. 750 acres, 2,750 persons.
Objections ಹಾಕಿದ್ದೀರಾ?
We have filed a detailed objection along with the committee report. madam.
1 week, madam. Last, list the matter on 30th as a last chance. In the event no submissions are made, the interim order would stand vacated.
Much of.
Yes.
21.
Yes, sir. Back to same submissions. Yes.
Back to square one.
No, you need not go back to square one. Not a new trial.
We can
continuing
take it
trial.
forward from there.
Yes.
Virtually, my lord, I have finished my.
Yes, yes, yes.
It is Mr. Prasad who has to.
ನೀವೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಪ್ರಸಾದ್.
Yes, my lord, they have to finish all other matters, my lord, only Murthy denied to finish the matter.
ಹಾ.
And
ಈಗ ಮೂರ್ತಿ ಸರ್ ಮುಗಿಸಿದ್ದಾರೆ.
yes, ma'am.
The first ground is limitation.
Limitation, my lord, is covered by judgment. It's a 420 is there, my lord.
420?
420 is also there, my lord.
Yes.
That is the reason that and limitation aspect.
ಆಯ್ತು ಮುಗಿಸ್ಬಿಡಿ. ಯಾಕೆ ಶುರು ಮಾಡಕ್ಕೆ
ಅಲ್ಲ
hesitation?
ಅವರು ಎಲ್ಲರೂ ಮುಗಿಸಿದ್ರೆ ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಇನ್ನು ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡಿ.
ಎಲ್ಲರೂ ಮುಗಿಸು ಒಂದೇ.
ಆಯ್ತು ಸ್ಟಾರ್ಟ್
They will raise one more ground, my lord, after that, but my lord again respondent argument. That's why I just.
ಫಿನಿಶ್ ಆಫ್ ಆಲ್ ಇಯರ್ ನಿಮ್ದಾಗಿದೆಯಾ ಮೂರ್ತಿ ಸರ್?
Please, only thing is just to recapitulate.
All
your
right.
lordship.
ಅದ್
Give
ಮಾಡಿ.
me
Yes.
30 seconds, my lord.
Yes.
Apart from limitation, the main ground in all the 16 cases is the.
The filed a synopsis also, I guess.
Yes.
We have filed a synopsis.
ಎಲ್ಲರೂ ಮಾಡಿದ್ದಾರೆ.
All the matters.
We have filed.
ಎಲ್ಲ
the
each
synopsis
case synopsis.
On
It's
28/7.
here, sir. It's.
Yes,
ನಮ್ಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಇದ್ರೆ.
because the petitioner, my lord, is common in all the 16 cases. One common thread, my lord, in all the petitions would be, by virtue of a decree passed by a competent civil court, he has been absolved with retrospective effect. So their, what can be discerned from their objection? I'm sorry, your lordship wanted to say.
No. He has been absolved by a
Absolved of the
competent civil
liability.
court for what?
My lord, there was a suit filed between the two partners.
Which two parties?
Two partners.
Partners, all
Yes,
right.
partners of the firm.
Hmm.
Now, what they would do, my lord, is in the first round, they wouldn't, or rather, I would rephrase it, initially, they don't array the firm party. They don't. Later on, they add the firm on the very same allegations that is fastened on this accused. When the firm was not, my lord, arraigned as an accused, their argument was the allegation between the partner and the firm is distinct. Now, verbatim, the same allegation, it's virtually, my lord, cut and paste, except changing the names. On the very same allegation, now the firm has been arraigned
Arraigned
as an accused. Yes.
All right.
In the first petition, my lord, is it first, right? Today's this, in 5267, the lordship will kindly take criminal petition 5267,
Yes.
which is at item 21.3.
Hmm.
My lord, the operative portion is at page 64. The first page, my lord, of the judgment is at page 38.
5267. Madam, 5267.
Yes, yes.
Page?
Page, my lord, in 5267, page 38.
Yes.
This judgment passed by civil judge Willard Bellari on 27th April 2018. This is between the two partners. The plaintiff there is the petitioner before your lordship.
Hmm.
Kindly come to my lord, page 64.
Hmm.
The suit of the plaintiff is hereby decreed with cause. It is declared that the partnership firm, that is Messrs. Eagle Traders and Logistics Firm, stands dissolved from date of notice dated 2/6/2015. Further, it is declared that this plaintiff is not in charge and responsible for the day-to-day affairs of the said firm from the date of general power of attorney, that is from 16/12/2008.
So all the offenses have sprung after that.
After this. And this has attained finality. This general power of attorney, which is referred to, my lord, by the learned civil judge, was submitted to the investigating
Now their
officer.
defense would be that it is between the partners. We are not bound by it.
But my lord, on 16/8/2008.
Anyway, it's a judicial finding.
Yes, there is a judicial finding, and this power of attorney was submitted to the investigating officer. For reasons best known to him, my lord, and high-handedly, he doesn't even touch it. Because I could have been absolved, and now, my lord, the law is well settled. The Honorable Supreme Court has held. In fact, your
Unless there is
lordships have
specific government with regard to
Yes,
the
that-
day-to-day affairs.
specific government, and also with regard to documents which are deliberately suppressed by the prosecution, which would, my lord, which can absolve the petitioners or the accused, should be looked into. So this is the common thread in all the 60.
So this is the same everywhere, apart from limitation.
Limitation, my lord, only in 3 cases.
Hmm. Limitation which case? Sir?
4.
Synopsis ಅಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ?
Yes. In the synopsis, my lord, that is 1, 3, serial number 1, 3, 5, and 7. That is 5267, 5269, 5265, and 5275.
Limitation.
Yes.
Yes.
Of course, your lordship, my lord, had expressed
That will-
doubt about my
True.
submission.
Let me see.
Yes. Subsequently, the Madras High Court, my lord, has,
Any other judgment after that?
yes, Madras High Court, my lord, has. My
After
contention,
the previous submissions,
yes,
do you have any other judgment?
yes, my lord.
Yes.
This is by way of a reference. The Lordship Justice Ananda Venkatesh has held that it is, the limitation is for the reckoning date is for date of filing of the complaint and the charge sheet, and not for initiation of the criminal prosecution.
All right. Paragraphs?
Paragraph I will below. Delhi. I'm sorry, my lord.
Hmm.
We just mark it and probably.
And the day-to-day affairs judgment?
That entire compilation we have given, my lord, that is by way of an additional compilation. In fact, there are 2 compilations. One on 14/7/2023.
One is on 1923.
Yes, this 1923 is exclusively with regard to
Limitation.
limitation. This 14.7 is regarding day-to-day affairs.
14/7/23.
Yes, well, the compilation dated 14/7/23. In fact, there, my lord, I have included the Supreme Court directions also, just for sake of clarity. Because it was argued that Supreme Court has directed, so we can register the FIR or file the complaint whenever we want. That is not the case. If that is the case, they can sleep over for another 20 years, then file it.
No, that will.
Yes.
Sir,
Because that would be preposterous.
to say the least.
Yes.
No, where is the other compilation?
Madam, this was, my lord, given in Dharwad.
14/7/23.
Yes, this is the main compilation.
Hmm.
First one in the list, my lord.
That is Samaj Parivartana.
Yes, that is Samaj Parivar, first order, because that goes to the root of the matter.
Yes, yes.
By virtue of which, my lord, the investigations were set into motion.
Para 15.
Yes, my lord.
Hmm.
Then comes the second order dated 16/9/2013,
Yes,
whereby the present SIT
is
comes
constituted.
into action. Because the Supreme Court leaves it to the wisdom of the state government
yes.
to decide. State government decides. Then third one, my lord, Samaj Parivartan. This is where the Supreme Court brings the curtain down as far as the investigations are concerned.
Yes.
While dealing with the categories of mines. So here, paragraph 14-15, they are very clear. On page 30.
Yes.
So page 30, my lord, ink page 30 for a moment.
30 of
30 of that compilation, my lord, dated 14/7.
Para 15.
Yes, para 14 and 15.
14 and 15,
yes,
both, yes.
Yes, just to recap.
Yes.
Then, my lord, from serial number 4 onwards of the list, they all pertain to day-to-day affairs. Sunil Mittal has been reiterated in Ravindranath Bajpayee, that is, which is at item 5.
Hmm.
Then that has been reiterated with approval in Narendra Kumar Baldota versus State of Karnataka in 2022 SEC Online 1880.
Yes.
So Sunil Mittal, my lord, has been consistently followed with approval.
All right.
And as on today, that is the law.
What is the law?
My lord, that there has to be specific government and one cannot be fastened with a criminal liability mechanically.
That is Ashutosh.
Yes, Ashutosh, my lord, is with regard to documents of unimpeachable character. I am serial number 4, Narendra Kumar Baldota.
That is 2022.
Yes. In Baldota, my lord, Ravindranath Bajpayee, that is, which is at serial number 5, is followed. Sunil Mittal is followed in Ravindranath Bajpayee.
So nothing beyond, after that, nothing is there?
I will not say nothing. That's a very-
2024 SEC Online SC page 311.
Nothing has been placed by us.
Yes.
I will not, my lord. That is a very tricky question, and especially when it comes from your lordship, it would be very risky to say. We'll look into it, my lord.
No. 2024 SEC Online SC 311. Susila Padmavati. Unless there is a pleading with regard to day-to-day affairs, at 130, those are 138 proceedings, day-to-day affairs, you can't haul them for criminal proceedings.
Please.
That's the latest. ಅಲ್ಲ, 1 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಅಲ್ಲೇ ನಿಂತ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲಲ್ಲ.
What, Jesham?
What?
ಹಾ? Yes. Yes, sir. ಅಷ್ಟೇ ಅಲ್ಲ?
Then, my lord, of course, Deepak Gaba regarding 420, all that, my lord, is same. Ashwini Kumar Upadhyay also I have produced with regard to the special court, because one ground we had urged in the petition, we may not, my lord, argue it. One was the ground was the, what the learned magistrate would do is commit the case to the learned special sessions judge. So our contention was, as urged in the petition, that that is wrong. She takes recourse to section 323 of CRPC. But on further
Pradeep
research,
Poder, I think, protects such action.
yes, not only charge sheet, my lord, she commits it. The learned magistrate would commit it, so a faint, my lord, ground was urged that that is wrong, that exercise of 323
I think I've answered that in one of your cases.
must be.
Last year.
Yes.
Yes.
So later on, we found a judgment of Justice Thomas, that is 2001, where he says that such a procedure is permissible. Just so
Let's not harp on it.
yes.
not
So
necessary.
ground what was urged by us may not, my lord. In fact, that this judgment is against our proposition.
I know.
Yes.
Yes, sir.
Please.
ಅಷ್ಟೇ ಅಲ್ಲ?
21.22.
ಆ ಫೈಲ್ ಕೊಡಿ ನೋಡಿ. 21.22.
22. 21.2.
21.22.
Yes.
Yes.
Criminal revision petition 711 of 23.
Kindly, I'll just put
Yes.
four.
In addition to the legal aspect covered by senior counsel, the only aspect which I would like to invite the attention of this honorable court is kindly come to page number 231 of my compile. Please, sorry.
Last year wasn't there. 230?
231, 231.
ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ.
Yes.
This is deed of partnership in respect of the accused number 45.
Yes.
Kindly come to the next page, my lord, 232. In consideration of the mutual promises and covenants, my lords, the first partner and the second partner agree and hereby constitute a partnership for carrying on the partnership business under the name and style of Bharat Mines and Minerals. This is accused number 45, Bharat Mines and Minerals, accused number 45.
I think we should straight go to clause 15.
Yes, my lords. Management. Now, so far as the management is concerned,
And
out of this.
Clause 17.
Yes. The bothly, my lords, the Dinesh Kumar Singhi, that is accused number 36. Accused number 36 is the managing partner. And the second partner is BMM Ispat Limited. Represented by, my lords, this is BMM Ispat Limited has been cited as accused number 34. 34. Represented by, my lords, the accused number 35.
So what are your grounds?
My lords, now, the management, so far as the covenant number 15 is concerned, it's very clear, my lords, it is the partner number 1, that is Dinesh Kumar Singhi is accused number 36, has to
the manage, and he is responsible for the day-to-day affairs of the entire, the business. My lords, apart from that, my lords, there is no, absolutely, there is no allegation against, my lords, so far as the petitioner is concerned. That is the only one point which I wanted to add. All right.
No specific allegation
No, no allegations at all.
against the company.
It's only against the accused number 45, represented by, my lords, the accused number 36. Accused number 36. There's no allegation against accused number 34 and 35.
ಎರಡು petition ಇದೆ ನಿಮ್ದು?
My lords,
ಎರಡು petition.
ಇಲ್ಲ, ಒಂದೇ petition ಇದೆ, because
Accused number 34 ಮಾತ್ರ ಇದೆ.
accused number 34 is once again, my lords, it's a company. If the company goes, my lords, the
No, the
35,
petitioner is only accused number 34.
34. And the 34 is goes out, my lords, represented by 35. The legal fiction, my lords, he has the representative of 34 has to go, my lords.
That is.
Yes.
Yes.
Plus the other aspect, my lords, the learned senior counsel, Mr. Nayak has covered. I don't want to repeat that.
Limitation. Limitation
Limitation aspect,
and day-to-day affairs.
please.
No allegations on day-to-day affairs.
That is
Act.
absolute.
Yes. Anybody else? No time. No time, no password. Hmm. ನಿಮ್ದು ಎಷ್ಟನೇದು? ಯಾರು ಚಿದಾನಂದ ಯಾರ್ದು? 1 minute, 21.19. That is over. Yes, I've already heard. ನಿಮ್ದೇನು? 17-18. D-Link 21.17 and 21.18. Yes, 21.20.
2, please. 21.2, please.
2 na 20 na?
Criminal petition 2384. 21.2.
Vijayta Nayak.
Please, please.
21.1.
1. Let's I have filed a synopsis. Only on 2 grounds I have taken, please, Millets. One is, please, Millets. The iron ore quantity, which is subject matter of this case, please, Millets. As per charge sheet allegations, which was purchased much prior to the period fixed by the Honorable Supreme Court. Please. Then one more contention, please, Millets. There are 2 charge sheet with respect to same quantity, please, Millets. As per Supreme Court directions, please, Millets. More than 50,000 metric ton of iron ore, the CBI is permitted to investigate the matter.
Yes.
Then below 50,000 metric ton.
SIT.
Same, SIT. Here, please, Millets. I have been charge sheeted by the CBI for the quantity which is
Below
less than 50,000 metric ton in special CC number 15 of 2014.
Then it should go on the face of it.
That is what, please, Millets.
But ಈಗ SIT is in charge.
This
not
is
CBI
also,
level.
this is also below SIT.
SIT ಗೆ
SIT ಗಿದೆ, SIT ಗಿದೆ.
SIT has jurisdiction.
Yes, please.
No, see, SIT is what is investigating it.
Yes, please. One more charge sheet filed by the CBI in respect of the quantity which is below 50,000.
Which is that?
Special CC 15, please, Millets.
Special CC 459.
No, this is 459, please. Millets. This is below 50,000.
ಅದು SIT ಕರೆಕ್ಟ್ ಆಗಿದೆ ಇದು.
SIT.
ಬೇರೆ ಗ್ರೌಂಡ್ ಹೇಳಿ.
Whereas I have been facing two trial in so far as.
Oh, CBI above 50.
Yes, please, Millets.
50,000 metric ton CBI is investigating, and below 50,000.
No, even if it is below in special CC 15, please, Millets, the quantity of iron ore is involved only 17,500.
Correct.
Even if you add two quantity, if it comes below 50,000 only, please.
CBI ಮಾಡ್ತಿರೋದು ಯಾವ್ದು?
CBI
ಎಷ್ಟಿದೆ ಅದು?
17,500.
17,000.
Yes, please.
How did CBI get jurisdiction?
That is what, please, the same ground we have taken here, please.
Which is that petition?
They have to challenge that order, my lord, say, not this order.
Not
So
challenge.
that is,
They have to challenge.
trial is
CBI.
concluded, it is posted for judgment already. Please.
Supreme Court was clear in saying below 50,000 it is
Yes,
only
please.
SIT. How did CBI investigate and file charge sheet?
But interim order dated 13/9/2013.
Yes, correct.
They have to challenge that order,
ಅಲ್ಲ, ಅದು
not this
ಮಾಡ್ಕೊಳ್ಳಿ,
order.
ಮಾಡಿ.
And there is
Literal
no,
jurisdiction
there is
ಇದೆ.
no discussion in the impugned order with regard. I have taken specific contention in the discharge application.
Let us see. ಇದರಲ್ಲಿ ಎಷ್ಟಿದೆ?
ಇದರಲ್ಲಿ 12,000 something.
ಎರಡು
12,000
ಸೇರಿದ್ರೆ 30 ಆಗಲ್ವಲ್ಲ?
ಆಗಲ್ಲ, ಅದನ್ನೇ ಮೈನ್ ಕಂಟೆನ್ಷನ್ ವಿ ಹ್ಯಾವ್ ಟೇಕನ್.
12,000, ಅದ್ರಲ್ಲಿ 17,000 ಇದೆ. ಅದ್ರ 12,000 offence is there. And they are saying it's not double jeopardy because
He is not
17,000.
talking of double jeopardy.
Because 17,000, they have no jurisdiction. On that point of time, 12,000 is concerned, we have jurisdiction.
ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿಲ್ಲ. ಎರಡು ಸೇರಿದ್ರು ಬರಲ್ವಲ್ಲ?
ಎರಡು
ಸೇರಿದ್ರೆ ಬರಲ್ಲ.
ಎರಡು ಸೇರಿದ್ರೆ ನಿಮಗೆ jurisdiction CBI ಬರಲ್ಲ. Yes.
And the quantity, please, lads. As per charge sheet amendments, page number 107.
So what are the other grounds, sir? You leave that because
Only two.
SIT has jurisdiction in this
Yes,
case.
yes. Well, the Supreme Court has fixed a period from 1/1/2019 to 31/5/2010. Please.
Yes, sir.
In page number 107, the
You have
allegation
extracted
of
the order at page
Yes,
13, sir. Supreme Court order.
Please, Maharaj.
13 will extract.
I have extracted.
Yes.
No, charge sheet allegation, please, Maharaj. In page
Page?
number 107, please. 107. Please, Maharaj. In para 2, please. ಆರೋಪಿತ ಕಂಪನಿಯ ದಿನಾಂಕ 1/1/2009 ಬೇಲಿಕೇರಿ ಬಂದರಿನಲ್ಲಿ 2008ನೇ, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಪ್ಲೀಸ್, 2008ನೇ ಸಾಲಿನಲ್ಲಿ ಬಾಲಾಜಿ ಮಿನರಲ್ಸ್ ಅವರಿಂದ ಖರೀದಿಸಿದ್ದ 2015 ಮೆಟ್ರಿಕ್ ಟನ್ ಮತ್ತು ಬಳ್ಳಾರಿ ಮಿನರಲ್ಸ್ ಅವರಿಂದ 2000 ಮೆಟ್ರಿಕ್ ಟನ್ ಓಪನಿಂಗ್ ಸ್ಟಾಕ್ 4015 ಮೆಟ್ರಿಕ್ ಟನ್ ಕಬ್ಬಿಣವನ್ನು ಹೊಂದಿರುತ್ತಾರೆ. As per this awareness, charge sheet awareness, this particular quantity of iron ore was purchased in the year 2008 itself. So whereas the Supreme Court has fixed the date from 1/1/2009 to 31/5/2010. So which was the iron ore which was purchased much prior to the date fixed by the Honorable Supreme Court.
All right, that is on the merit of
Please,
the matter. That will see. Yes.
So far as other.
Anybody else? Dealing ಮಾಡ ಆಯ್ತಲ್ಲ? Yes. Dealing and list on 5th September, interim order subsisting will continue to the next date of hearing. Chidananda, sir, yes. What submissions of yours?
Milad, by and large, Milad, all of them, Milad, one is at Vivek case, Milad, and Milad, even that first blush of the Pradeep Odear case, which your lordships read, Milad. Milad, there are issues. Milad, in this case, Milad, apart from this thing, Milad, in one of the case, 664, Milad.
Just one moment.
Correct, Judge, yeah. Milad, 664, Milad.
Yes, yes, one moment.
The learned judge adds, Milad, 379, which is not even part of the charge sheet.
We have stayed it. Alla.
Your lordships have stated. The charge sheet your lordships get page, Milad. Page 90,
90.
That's only one. It is at page, Milad, just page 133, Milad.
Yes.
409, 420.
120. Where is the order of cognizance?
Order of, order now rejecting, Milad, it is at page 71, operative portion. '71. There are sufficient grounds against the accused for the offences 379, 420, 120B, 41.
Right. What other ground you have?
Well, that is the one main. Well, apart from others, which I don't like to repeat.
Ashala. Synopsis ಹಾಕಿದ್ದೀರಾ?
synopsis, I'll file it, my lord.
File along with the judgments, whatever you want.
Yes, I will file it, my lord.
Heard ಎಲ್ಲಾರ್ದು ಹಾಕಿ, then senior counsel ಮೂರ್ತಿ ನಾಯಕ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು, list on 12th for dictating orders.
Please, I'm sorry, I will not present.
Solid.
Please. 11 paras at 26 and 27.
ಪಾಪ ಅದು. Limitation.
468.
Yes, yes. Don't worry. Yes, sir.
22.
ನಿಮ್ದೆ.
Asmat Pasha.
For dictating ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೇಳಿ, yes.
Limitation aspect, my lord, is covered by
Last time you argued everything.
limitation aspect.
Yes.
In Murthy did I raise one objection saying that, my lord, he resigned. He gave a
21.
power of attorney in the year 2008 itself. And he is not a partner. But in this case, my lord, kindly see, second petitioner, he is representing on behalf of the company. And moreover, my lord,
ಹೇಳಿ.
this is a collusive suit. Page number 61, my lord, in 5265.
Yes.
This is a collusive suit, my lord, sir, at the time of matter of evidence, my lord. At that time, at that point of time, my lord, we can elicit, my lord, that's the reason it's a matter of trial. It has to be considered at the time of trial, not at this stage.
ಆಮೇಲೆ.
And 379, they are saying that, my lord, is a 379.
Yeah.
Only they have pointed out to the 379. Kindly see, my lord, it's a continuation of offense. It's a royalty is not yet paid. And also, my lord, the theft is also there. On that point of time, my lord, the limitation aspect doesn't arise, my lord. It's a continuation of
If it's a continuing offense.
continuing.
Yes. Yes.
He is also one of the partner. He's participated in day-to-day affairs also, my lord. And this question, my lord, is when the matter of trial, my lord, they have to urge all this ground before the trial. And this is a second round of the some of the petition is concerned, my lord, this is a second round of 482 petition. It's not permissible, my lord. They are not at all raised the ground at the initial stage. Now, my lord, they are raising this ground. It's not permissible, my lord.
Yes.
And the Sanjay case and also Pradeep Odear case, all these aspect, my lord, is covered, my lord, limitation, managing the partnership firm as a managing partner.
Yes.
Pradeep Odear also, my lord, is clearly stated he was in South Africa and he was not at all participating in day-to-day affairs. Even then, my lord, the Supreme Court clearly held that it's a matter of evidence.
Yes.
And joint trial also, my lord, some of the cases is a charge sheet as well as MM director private complaint. And 220 CRPCs, my lord, is a joint trial. That is also covered, my lord. And the PN Hegde case, my lord. That is also, my lord, they are saying that, my lord, is not at all managing partner. And some of the person is a managing partner. And he say, kindly see, my lord, in that case, class number 15, my lord, is also clear.
Clause 15 and 17. Sir.
Yes, my lord. In revision petition, my lord, in all revision petitions, all these aspects, my lord, the trial court consider it's a prima facie case is there, my lord, in the portion for framing of charge.
Yes.
And the earlier round of litigation, my lord, I will cite all the decision. This Honorable High Court, my lord, is consider all this aspect. I will cite all the
Justice Sandesh ಅವರು.
No, my lord, Dikuna judge.
ಎಲ್ಲಿದೆ?
It's I will present.
ಕೊಡಿ ಅವ್ರು.
Yes, please.
Yes.
1.4
And
ನಿಮ್ದು ನೀವು ಇದ್ದೀರಾ?
21.4
ಯಾಕೆ?
investigated by CID. Subsequently it was transferred here.
ಆಮೇಲೆ ಅವ್ರು ಮಾಡಿದಾರ?
We have filed a charge.
ಹೌದಾ?
That state dot 21.4, it pertains to Karwar Port. Investigation by CID,
ಅಲ್ಲೂ ಲಿಮಿಟೇಷನ್.
Limitation illa alli because they
day to day.
ಡೇ ಟು ಡೇ ಅಫೇರ್ಸ್.
then MMDR.
My lord is only in MMDR cases.
ಎಸ್, ಕರೆಕ್ಟ್.
A short rejoinder to Mr. Prasad's submission. The
Well,
main contention was.
They're not yet finished.
ಎಸ್ ಎಸ್
Sorry.
I will file the synopsis, my lord,
ಮಾಡಿ.
please.
ಎಸ್,
And
ಯು ಆರ್ ಟೆಲಿಂಗ್ ಅಬೌಟ್ ಪರಮೇಶ್ವರ್ ಸಬ್ಮಿಷನ್ಸ್, ಹೆಗ್ಡೇಶ್ ಸಬ್ಮಿಷನ್ಸ್.
yes,
Clause 15 and 17.
yes, my lord.
Yes.
And what all the grounds raised by the petitioners, my lord, is all
Matter of
aspects,
trial.
it's a matter of trial. And they are raising that, my lord, in one of the case, my lord, they raised the ground, he is not a managing partner, he is only director, he's submitted like that. And then, my lord, the company bylaw says that, my lord, is that particular, that director is in charge of that mines related issue, my lord. On that point of time, my lord, managing director is not a party in that case.
Come again?
Pardon?
Come again?
They are raising the ground in one petition, my lord.
Hmm. ಇರೋದೇ ಒಂದು ಪಿಟಿಷನ್.
ಅಲ್ಲ ಇದು ಇವರು ಪಿಟಿಷನ್ ಅಲ್ಲ.
ಅಲ್ಲ, ವಿ ಆರ್ ಅಬೌಟ್ ಹೆಗ್ಡೇಸ್ ಕೇಸ್.
ಹೆಗ್ಡೇಸ್ ಕೇಸ್ ಇದೆ.
ಅದಲ್ವಾ ಇದು?
ಅದಲ್ಲ.
ಅದಾಗೋಯ್ತಾ?
ಅದಾಯ್ತು.
ಯಾವಾಗ ಆಯ್ತು?
ಅಲ್ಲ, this is 15 and 17 classes there, my lord.
ಅದು ಹೆಗ್ಡೆ ಅವ್ರ ಕೇಸ್ ದೇ ಅದು.
ಅಲ್ಲ, ನಾನು ರೈಸ್ ಮಾಡ್ತಾ
ಅದ್ರಲ್ಲೇ ತಾನೆ ಕ್ಲಾಸ್ 15, 17.
15, 17.
ಅವ್ರದೇ ಕೇಸ್ ಅದು.
ಅಲ್ಲ, ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ ಮತ್ತೊಂದು ಕೇಸಲ್ಲಿ
ಅದ್ರಲ್ಲೂ ಕ್ಲಾಸ್ 15, 17 ಇದೆ.
ಕ್ಲಾಸ್ 15, 17 ಅಲ್ಲ. One of the director, my lord, taken a contention saying that, my lord, he is not a managing director. He is only director. And is a company bylaw, company resolution, my lord, is clearly stated that, my lord, is a managing director is not in charge of mines related issue. Only director, that particular accused is
That's a matter of trial.
That's a matter of trial. What all the contention, my lord, is there, the bulk of document is there, my lord, is to include all this petitioners as an accused. All the documents, my lord, has to be looked into. Not only, my lord, they are saying that is a piece of paper saying that, my lord, is I am not responsible. At that point of, during the course of trial, they have to raise all these grounds.
ಅಷ್ಟೇ. ಈಗ ಆಯ್ತಾ? ಆಯ್ತಾ?
ಇಲ್ಲ ಇಲ್ಲ,
ಇನ್ನೂ ಇದೆಯಾ? ಸಬ್ಮಿಷನ್ ಆಯ್ತಾ?
ಸಬ್ಮಿಷನ್ ಆಗಿದೆ.
ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Kindly see, my lord, form the continuing offense is concerned, my lord.
379 is a continuing offense.
Yes,
All right.
the Mines Act also, my lord, is a continuing offense. On that point of time, they are raising that, my lord, only 379, only limitation aspect, my lord. Not only that, MMDR Act is also there. On that point of time, my lord, the part 4, my lord.
Part 4 of what?
One moment.
CRPC.
No, sir, MMDR Act. I'll come.
Your lordship, the old MMDR Act will have to be looked into.
Prior to Act number 10 of 2015.
Not not
Only
the.
2 years at that
amended.
time.
Because it dates back to 9 and 10, e-bookment. It's 2017 Barrett.
Yes,
If it isn't only the MMDR Act, they are saying that, my lord, they are taking a contention, is a old act, is 2 years. Unless and I'm repeating once again, my lord, unless and until the royalty is paid, it's a continuing offense. And
old or new,
yes, my lord.
all right. Submissions. All right, yes.
And I'll file a synopsis of
Yes,
in all these cases.
yes. Judgments? ಎಲ್ಲ ಸೇರಿಸಿ ಒಂದು
ಎಲ್ಲ ಸೇರಿಸಿ.
ಹಾಕ್ಬಿಡಿ. ಕೊಟ್ಟಿದ್ದೀರಾ ಒಂದು 4-5?
Only Pradeep Oder and Sanjay case I cited.
ಹಾ. ಬೇರೆ ಯಾವ್ದಾರು ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ.
Please.
I'll post it on 12th for dictating. ಅಷ್ಟರಲ್ಲಿ ಅದಕ್ಕೆ ಮುಂಚೆ ಕೊಡ್ಬೇಕು.
Please.
Yes.
What the joined up, Lord, learned friend, refer to the cost
Come
item
here.
of some delays.
ಫಾಸ್ಟ್ ಅಲ್ಲ ಅವ್ರ ವಾಯ್ಸ್ ಬಿಡಿ, ಅಲ್ಲೇ ಆಗತ್ತೆ, ತೊಂದರೆ ಇಲ್ಲ ಹೇಳಿ. ಎಸ್.
Refer to below the cost title of our petition to contain that we have mentioned represented by petitioner number 1. In fact, there is a note specifically written by the AOR saying petitioners are shown in the cost title as per their description in the complaint without prejudice to the grounds raised in the petition.
No, don't worry. He wants to make his case on a cost title. Then it's dangerous. We'll see.
There is neither cause nor title in the charge sheet. Now,
Yes.
Lord, with regard to his contention that it's a collusive suit. Nowhere, my lord, have they even whispered in the entire charge sheet that the documents produced by the accused during the course of investigation, I have perused it, the power of attorney is collusive, nor the decree passed by the civil court is, nowhere do they say. These are all submissions of my learned friend. Then, my lord, we have produced your lordship's judgment with regard to 305. Krishna Swami Sridhar, your lordship has elaborately held.
You produced it? Yes.
It's there in the
Compilation. Yes.
Because the option rests with me. If I am not the company, then the company has the right under subsection 2 of 305. And there is a pari materia provision also in the BNSS. So that-
VNSS and Badai.
And I'm just.
Yes, yes. All right.
Comparison, my lord.
12th.
Lordship permit, just one.
Any synopsis or authorities a week before you give it?
Yes, sorry.
No, anything else you want to do? Yes.
Yes, yes, please.
He also submitted that there are bulk of documents that Mr. Prasad submitted, and he also, in the same breath, submitted that there is no piece of paper to absolve themselves. When they produce a decree, they say it is collusive. They don't even take into consideration.
Yes. Yes.
Sort of these grounds. And,
No, he said that you had all come before this court earlier. Justice Michael Kunnas not, you are for the first time, all of you are for the first time coming?
clients, Lord,
Yes, Prasad sir, who had come?
Murthy denied first time.
Huh?
Murthy denied the first time.
ಮತ್ತೆ ಬೇರೆಯವ್ರದ್ದು ಯಾರು second time? You are second time?
Yes, it's 482. I had approached this honorable court.
ಇದು revision.
Then subsequently, my lords, I filed an application for the
Discharge.
discharge. That discharge application came to be dismissed.
Then no problem.
Please.
ಅಷ್ಟೇ ಅಲ್ವಾ? Yes.
In fact, my lord, we had anticipated that Mr. Prasad will definitely raise this. So we have produced Justice Kunna's judgment also as an annexure. Annexure F in 5279. Because there.
ಅವ್ರಿಗೇನು ಸಂಬಂಧ ಇಲ್ಲ.
In fact, it's a self-destructive submission they had made there. Which bolsters my submission now. There they had, not our contention was, our in the sense, two accused for whom I had appeared, the contention was the firm or the company is not made an accused. So there they would submit that the allegation against the firm is different and allegation against the individual is different. Hence, individual has been arraigned in individual capacity. Now, if the both the charge sheets are juxtaposed, they are identical, including the comma, full stop, spacing, everything. So in fact, it is
Complete copy paste.
everything minus the cost
All
item.
right, yes.
Grateful.
All 12th. Except 17 and 18, yes. 21.17 and 18. Interim order subsisting shall continue till the disposal of the petitions. Yes, next.
Grateful.
Next. Sir.
My lord, both matter, my lord,
Yes.
arising out of same crime, my lord.
Yes.
The first matter, my lord, is upon charge sheet.
Yes.
The second, my lord, is on PCR, invoking the provisions of section 21 and 23 of MMDR. Now,
Yes.
my lord, petitioners are accused number 1 to 5, my lord. My lord, you may kindly see, my lord, in the first matter, charge sheet, my lord, the offences which are dropped here while filing charge sheet, my lord.
I think I had granted an interim order. on that.
Yes, your lordship granted. Kindly page 24, my lord.
Companion petition code, madam. One minute, page 24 of which petition, sir?
My lord, first petition, my lord, 7946, your lordship.
7946. I am holding that, yes.
My lord, in call number 5, your lordship.
Page, sir.
Page 24, call number 5. My lord, whether the charge sheet is filed against the accused under same section of law under which case was registered. Call number 5, your lordship.
Yes.
My lord, here, column
379.
465, 467, 468, 471 IPC, column 7, 13.2, read with 13.1D of Prevention of Corruption Act, kai bidalagide.
All right.
Yes.
All these kaibidala.
All these offences, my lord, are dropped. Now, charge sheet, my lord, is for the main accused, my lord, it is filed for offence under section 379, 409, 420, read with 120B.
Yes.
My lord, against accused number 1 to 5, my lord, will me kindly go to page 727, my lord.
Yes.
My lord, only section, my lord, for which charge sheet is filed, my lord, 379, 420, 120B, read with rule 165, read with 144 of Karnataka Forest Act.
Yes. That is accused
But
number.
in the connected petition, my lord, in the connected which is arising out of PCR, my lord, filed, my lord, to comply section 22. My lord, it is only for violation of non-obtaining of permit and non-payment of royalty, violation of section 4141A. My lord, penalty section, my lord, 21 and 23 of MMDR.
Yes.
My lord, kindly see, my lord, page 14, my lord, 15, my lord, relevant page, where the order of taking cognizance. Page 15, your lordship.
Oh, there was a specific ground that you said while granting the interim order. I have granted an
My
interim
lord, they have
order.
purchased, my lord, at the port plot. They are not either the.
No, no, not. Yes, sir. You tell me, sir. Yes.
My lord, the petitioner number 5, my lord, is the partnership firm.
Yes, sir.
Raj Mahal Silks.
Yes.
My lord, it had purchased iron ore, my lord, at the Mangalore New Port plot.
Yes, sir.
And transported, my lord, and exported to China. My lord, out of 139,000 metric ton of iron ore, only, my lord, 4,700 metric ton of iron ore is found to be not based on valid permit.
4,000.
It was with permit, it was. But the allegation, my lord, it was not based on valid permit. My lord, by the time, my lord, when these petitioners have purchased the iron ore, my lord, it had crossed over all the compliance of law. My lord, without permit, my lord, material cannot reach the port plot. This company had only, my lord, firm had purchased the iron ore at the port plot. My lord, the permit is required for the purpose of transportation. My lord, it had, my lord, based on the permit only, my lord, it had come to port plot. My lord, the port authorities have cleared the material. It was legally saleable material that was purchased by firm, my lord, accused number 5.
So there is no question of 420 or 379.
Not only 379, 420, read with 120B. You lordship may kindly, now they have been implicated with the aid of only 120B. 120B for substantive offences, my lord, of 317 and 420 should be prior to commission of substantive offence. My lord, the definition,
Conspiracy should be before.
it should precede the commission of offence. Your lordship may kindly see, my lord, the allegation is against accused number 16, which is the mine owner. It possesses a mining lease. My lord, the allegation is that without obtaining permit, they have committed theft of iron ore. My lord, the conspiracy should be prior to committing theft. Prior to committing theft, here the offences alleged are under section 379 and 420. It cannot be simultaneously. My lord, many decisions, my lord, right from, my lord, 1959 Supreme Court Leo Roy's case, my lord, till today, my lord, the law is conspiracy precedes the commission of the offence. Now, once, my lord, commission of offence starts, conspiracy ends. It will not continue. This is, your lordship may kindly see, the important ingredients of offence of conspiracy is to be considered here. They have been brought only with the aid of 120B. My lord, on reading the entire charge sheet material, my lord.
So it should not have been read with 120B.
My lord, the
According
allegation.
to you, 120B should precede 379, 409, 420.
No, not only the not
Conspiracy should.
even otherwise,
come
vice
first.
versa also, your lordship. Even vice versa also, 120B read with 379, 420 also do not attract here. My lord, either way, my lord, since these accused have been implicated only with the aid of 120B, well, otherwise they have not involved in the direct commission of offence, my lord, either theft or causing loss to the government. They are only the purchasers. They have been implicated only.
Then it can only be conspiracy.
Only be conspiracy. For this, my lord, conspiracy, if at all, it should precede the commission of substantive offence of 379 and 420. Normally, that is,
Your submission is you are purchasers of iron ore.
it is a post event, my lord. It is a
That's what,
post.
379 and 409 and 420 would not be applicable. You're only on conspiracy. Conspiracy should be prior to the
Prior to
purchase.
the commission of
of the
379 and
offense,
420.
420. So that is not there because it
important
is,
argument.
your act is post
Transportation, my lord.
post transport or whatever.
Post commission of offence of 379 and 420.
Yes.
My lord, actus res, my lord, actus at the time, before the act, at the time of the act, after the act, my lord, after the act only, screening of offence, harboring the offender, any of these sections only will attract. Not, my lord, it will not take back to the position of 120B. These persons, they have purchased iron ore at the port plot by then commission of offence of 379, 429, 420
others.
was already completed. Was already completed. And they have not been prosecuted, my lord, for the offence of any of the post-occurrence offences like 212 or 201. 201 does not apply here. 212 also, my lord, for harboring does not apply. And they have not invoked also. Now, this, my lord, the offences which are invoked are totally innocuous to the circumstances of the case. Now, apart from this, your lordship, 379, 420, which is invoked against the other accused persons, also do not constitute here. My lord, accused number 16, my lord, is the mine lease owner. Mine lease owner, my lord, is accused number 16, SB Mineral.
Now, these accused 1 to 5 are all purchasers?
Only purchasers, my lord. Here, your lordship may kindly, only accused number 5, my lord, firm. Accused number 2, 3, 4, my lord, are only nominal partners.
All right.
They are not, they were not in charge of the business affairs of the firm. Only
Accused number 5 is the firm.
Accused number 5 is the firm. Accused number 1 is the managing partner of the firm. Now, my lord, he even in his individual capacity, he cannot be prosecuted My lord, if at all, it could be only accused number 5, my lord, a partnership firm.
Yes.
Now, my lord, that what I submitted to your lordship that since the charge sheet is filed only with the aid of 120B, my lord, it do not constitute any offense against them because they are the post purchasers. And my lord, by then, my lord, the legal hurdles, my lord, requirement of permit or license, my lord, whatever it is required under MMDR Act or under Karnataka Forest Act was crossed over. The allegation here, your lordship, that for 4,700 metric ton of iron ore, there was a permit, but it was not a valid permit. A purchaser, my lord, when he was offered, my lord, that he has purchased based on the permit. My lord, by then it was clearly cleared by the port authorities. Once material reaches the port, my lord, it is deemed to be illegally exportable material.
So even 120B would not.
Even 120B, my lord, should go back, my lord. Any other section, my lord, will not constitute an offense against them because mens rea is not there. No criminal offense constitutes against these persons.
Yes.
But added to this, your lordship, now they have invoked, my lord, 379 and 420. 379 against the person who extracted iron ore. That is, my lord, accused number 16, my lord, is the firm, my lord, which was holding a lease, my lord, granted by government under ML number 2515. My lord, when, my lord, that a person win over iron ore on the strength of lease, my lord, he will not be a thief. Only that he can be prosecuted for non-payment of royalty, which is recoverable as arrears of land revenue.
So you mean to say that mutually exclusive?
Yes, my lord. Even that also, your lordship, that even the principal offender, my lord, accused number 16, they have also not committed the offense of either 379 or 420. And what your lordship observed rightly, mutually exclusive here, a thief will not be a cheater. See, your lordship may kindly disappreciate, my lord, that it cannot be invoked that. A person who commits a thief, my lord, if anyone purchases from him, he will be liable for offense of receiver of stolen property, punishable under section 411. My lord, if it is a dacoity material under 412 of IPC.
Yes.
My lord, none of these, neither they have invoked it, nor it can be invocable in the facts and circumstances of the case. Let's kindly see that another section, my lord, what they invoked is Rule 165, Red Bit 144 of Karnataka Forest Act, my lord, which is obtaining of passes for transportation of forest material.
Even that is not against.
Even that is not, my lord, applicable because transportation was completed. And this is not a forest material, your lordship. My lord, as per their own, my lord, it is the iron ore which was purchased was win over from the mining lease hold of or mining head of ML number 2515.
Yes.
Which, my lord, and by virtue of a lease, my lord, the lessee has been given an authority to win, my lord, iron ore in that area.
Yes.
Then thereby, my lord, that the lessee will not be a thief. My lord, non-payment of royalty, my lord, is not constitutes an offense of cheating. 420B. It is recoverable as land revenue, but, my lord, in order to constitute offense under section 420, my lord, there must be false representation. The other side must believe the false representation. And failure to comply this false representation constitutes an offense within the ingredients of section 24 or 21, my lord, fraudulently defined, my lord, under section 21, my lord, dishonestly defined under section 24 of IPC. All those ingredients must cover. But in order to constitute offense under 420.
Inducement with dishonest
Yes,
intention.
inducement, making false representation. I will make you a rich by buying this. Well, Lord, that kind of representation, believing that representation, acting upon that representation, suffering loss, there must be wrongful gain and wrongful loss. Well, Lord, these are all, my lord, important ingredients of the offenses. Well, Lord, none of those ingredients are alleged here. The simple case, my lord, that accused number 16 has won over, my lord, iron ore material which has sold to different sellers. My lord, they have purchased this based on that he had a lease. that accused number 16 possesses a lease, which is a government lease granted by the government. And my lord, permit also was there. My lord, only to the extent of 4,700 metric ton. My lord, there was no permit, not that no permit, it was not a valid permit. No, my lord, they have not identified which was that valid permit, which was not a valid permit. This is again, my lord, investigation is inconclusive. No, with this, my lord, I need not venture to that extent, my lord. My role is limited here.
Your role is
My lord,
limited,
very limited, your lordship. My lord, in the broad concept of the case, my lord, what the charge sheet is filed, my lord, I am submitting to your lordship. Since the accused number 5 being a firm which had purchased iron ore at the Mangalore New Port plot, by then, my lord, all legal hurdles were completed, crossed over. Legally exportable material that was purchased, and my lord, it was exported. My lord, in 120B cannot be invoked because there is no legal material collected to show that these persons have conspired with other accused, particularly accused number 16, prior to winning over of iron ore. My lord, therefore, my lord, that
you have come into the picture after all the ingredients of
all-
other offences by others were over.
yes, yes. My lord, that here the offences alleged under section 4141A of MMDR Act, my lord, read with 21 and 23 of MMDR Act.
No, that
For-
is no person shall transport or
Transport
store or.
is for
whatever.
them, my lord, it is. Even, my lord, forest rules, my lord, 165, are read with 144 also for transportation.
All right.
My lord, with this, my lord, I submit, my lord, that this petitioners, my lord, accused number 1 to 5, the order of taking cognizance by the magistrate is without application of mind to the legal concept of law. Therefore, my lord, I pray, my lord, the petition is to be allowed quashing the proceeding against them.
Both the petitions same.
Yes, my lord, the other grounds, my lord, limitation is also that the period, my lord, is 1/4/2006 to 31/5/2010 is the period of offence as per the FIR.
Yes.
My lord, it is more than, my lord, that the date of cognizance is, my lord, it is only, my lord, in 23, my lord.
No, date of cognizance is not important, but date
Even-
of complaint.
Complaint is also, my lord, 21, your lordship. FIR, your lordship, may kindly see. Date of complaint is also, in
Yes.
one case, my lord, date of complaint, my lord, is on 23, your lordship. The complaint presented on 20th/7/23, page 13, my lord, in the second
Yes,
petition.
yes.
20th/7/22. My lord, by then, my lord, that is more than 12 years, my lord, it is.
Yes.
Offense, my lord, is MMDR Act cognizance is taken after 12 years. My lord. One more
No,
important
taking
aspect.
of cognizance is not important for limitation.
My lord,
Filing of complaint.
Filing of complaint, my lord, that is what it is. Your lordship may kindly see.
Yes, filing of complaint is 14/6/21.
Yes.
The
Even in
period-
the first case, my lord, even in the first case, the FIR was registered, your lordship. FIR was registered in 21.
Yes.
Kindly see, my lord, that
Period of offence is 2006 to 2010.
2010, my lord, it is.
Yes.
Period of offence it is.
Yes.
It's more than 10 years old matter, my lord, that. By then, my lord, on reading of the facts, my lord, if the offence of 379/420 do not constitute, my lord, it is barred by limitation. And my lord, cognizance, my lord,
Anyway, 379/420 would not be.
not be invocable
Against
against
you.
this accused, my lord, it is.
Yes.
With this, my lord, I
Yes.
pray the petition.
Same submission, limitation, same submission.
Same submission.
Ah.
And conspiracy, my lord, it's,
They are not transporters.
they are not transported.
They are purchasers.
conspired because they want to.
Conspired when?
When, my lord, that is the reason, my lord, they want to purchase the iron ore.
That is conspiracy. according to-
Conspiracy, because they want to purchase the iron ore, even though in airport, Mangalore port or some other place, it is not a criteria. They joined with the hands of the accused number, remaining accused. They transported.
They are traders. They purchase it from anybody.
Because he will purchase the iron ore in the Mangalore port. That is the reason, my lord, they transported. Or otherwise, they would not transport the iron ore.
They have not transported.
They are not. Because of he is purchasing the.
Transport ಆದ್ಮೇಲೆ purchase
No,
ಮಾಡ್ತಾರೆ.
they are conspiracy is concerned, my lord. They joined with the hands of the transporter. Then
to-
only
To purchase the ore.
to purchase the. That is the reason that conspiracy, my lord. That's.
All right. Yes, sir.
My lord, here one submission. my lord, if it is, my lord, there was an agreement to purchase this iron ore, which was a immovable property, which was a movable property. Section 20 and 21 of Sale of Goods Act attracts, there must be an agreement.
Where is the
Prior to-
agreement? There is no agreement.
There is no agreement, my lord, that the submission.
Theft material is concerned, there is no agreement. That is the reason, 420 and theft.
Yes, this is
Agreement
a
is not
property
required because,
which was
because he
purchased.
will purchase the property, iron ore, theft material. That is the reason it's a conspiracy. That is the reason they transported.
My lord, your lordship, kindly, my lord, not brought, my lord, section 20 and 21 of Sale of Goods Act is very clear, my lord. As on the date of agreement, my lord, the sale completes. It should complete, my lord, prior to commission of 379 and 420 offense. My lord, I produce that section 20
Yes,
and
yes.
21 of Sale of Goods Act, my lord, is very clear. Sale completes as on the date of agreement to buy. It should be prior to digging of that iron ore. There must be an agreement, at least oral agreement. What is the material they have relied?
That is a matter of trial.
No, but nothing, my lord, on perusal of charge sheet, my lord, that
That is.
my lord, R.P. Kapoor's case, my lord, 65 Supreme Court, my lord, with regard to the scope of 482 is concerned.
No,
If
that has
the
been-
absence.
That
if
has
the-
been now clarified, reiterated.
my lord, reiterated and it is followed, my lord, repeatedly. That is
So,
the authority, my lord.
See
that
Muhammad Ali now.
Muhammad Ali's case is also there, my lord. which
Muhammad
is-
Ali reiterates and
Look,
glorifies it.
Yes. Not only that, in Muhammad Ali's case, Supreme Court go beyond that, the court has to understand even in between the lines.
Between the
In
lines.
between the lines to understand the reality of it. Here, my lord, the reality is, my lord, when they offered for sale in the port plot, they have purchased it, exported it. They have got some profit, that's all. It is nature of a business. To support the submission of my learned friend, the agreement to buy a movable property and iron ore should be prior to commission of offense.
Yes. Yes.
Or even there is no agreement prior to purchase also. With this, my lord, on legal concept, my lord.
That is the reason it's theft. That is the reason it's cheating. They are not at.
All right. Yes. Yes, sir. Heard the learned senior counsel, so and so. List the matter on 12th for dictating words. Yes, at 2:30 PM. Interim order ಇದೆಯಲ್ಲ? Interim order subsisting shall continue to the next date of hearing.
Because this case, my lord, CBI earlier initiated the matter. And thereafter, my lord, it's a below 50,000 metric ton. That's why, my lord.
Which case? Which case?
This case. That's why, my lord, the interim order was granted earlier. It was not
Anyway,
noticed.
it's still there. Interim order is subsisting.
Still, my lord, I omit to mention, my lord, one important fact. Now, my lord, CBI had conducted inquiry investigation. They closed the matter that we have produced that letter. My lord, thereafter, my lord, this SIT has taken up investigation.
I
This
produced-
report, your lordship, may kindly page 74, my lord. They conducted preliminary inquiry.
I produced the document along with the.
Page
objection
74 in
statement,
the
my lord.
first petition, my lord. Intimated to the accused about the closure of investigation and inquiry. Preliminary inquiry was undertaken by CBI. Page 74, your lordship. Annexure E, my lord.
1 moment.
Annexure E, your lordship, may kindly see, this is Central Bureau of Investigation to the Director Rajmal Sales. My lord, as per the orders of the competent authority, white note sheet so and so, in the above mentioned inquiry, the document mentioned as per the above mentioned MR number, item number seized during the inquiries are hereby returned to you. The above documents are to be kept in safe custody. Same are to be produced before CBI as and when required. The receipt of the document may kindly be acknowledged. So far, my lord, CBI did not continue the investigation nor the inquiry. These SIT, my lord, they have overpowered and taken up with independent investigation. This was the inquiry that was conducted by CBI. They
No.
did not reopen, my lord. They did not ask the complainant to the accused to produce documents for re-inquiry or re-investigation.
Yes.
Kindly
When
see-
it was taken up by the CBI, the SIT has no locus standi to take up again.
That is pursuant to Supreme Court judgment.
Kindly see,
No, my lord, this CBI has taken, my lord, pursuant to Supreme Court judgment, my lord, dated
1,000 metric
16.
tons ಗಿಂತ ಜಾಸ್ತಿ ಇತ್ತಾ?
My lord, here 1,39,000
then
metric ton
yes.
of.
Kindly see
Then
page number
see,
21 in objection.
How did
statement.
you get into this?
Kindly see page number 21, my objection statement. A letter issued by the
Subject matter,
CBI.
sir.
CBI.
CBI letter issued by the page number 21, it starts from 21. 22, my lord. It is not closed the entire
So it
investigation.
is not closed.
Closed.
All right, yes.
Enquiry revealed that during the period of under inquiry, 76 companies individuals exported iron ore through Mangalore port, out of which 40 company firms, individuals have exported so and so metric ton iron ore without valid permits. That's a finding. That is the reason, my lord, this is 76 company, in total
Above
76
50
company,
lakhs,
there
above
is a,
50,000
more than, it's a less than 50,000 metric ton. That is the
57
reason, my lord, this individual company has taken into consideration, my lord, and started
So
investigation.
that is at page 23,
Yes.
Yes.
paragraph 179 of your objections. Because there are multiple transactions, individual cases are directed to be taken up. The preliminary inquiry did not get itself converted into RC. Hence, Government of Karnataka, being the authority, is requested to take appropriate action in terms of MMDR.
Yes.
That is why they have taken.
Yes, my lord, still, my lord, that the quantity individually also it is above 57,000. 57,000, the page 21, your lordship. 22, your lordship, that.
Then we will ask the CBI to conduct
They should have
investigation.
investigated, my lord, they have hands up. And now, my lord, they have left to this SIT who have no power as per the direction of Supreme Court.
We'll
My
answer.
lord, ordered, my lord.
Ultimately, it's a 4,000 not the metric ton.
Yes, 12th dictating. Next.
But a similar case, my lord, of this accused only, that is filed by CBI, the same contentions, my lord, it is listed in list number 2. It is
Why list number 2?
list number 2, my lord, that. Huh? 61, my lord, it is here. Mr. Prasanna Kumar for CBI appears, my lord.
Oh, the
It is-
same
Yes.
Rajmal Silks.
Rajmal Silks.
This was yesterday also, yesterday or day before.
Not there, my lord, it was long back, your lordship. Stay is there, my lord,
Huh.
and it reaches, my lord, I submit, your lordship. This Mr. Prasanna
will
Kumar
see.
has to come, your lord.
Ivat doubt reach out.
Right.
Time back.
Yes.
ಆಮೇಲೆ reach ಆದಾಗ ಹೇಳಿ.
Yes.
Yes. Next.
23.
Yes, madam.
I'm happy with it. It's a case, my lord, pertaining to reference under section 45 of the Evidence Act, my lord. The learned magistrate has rejected, and I approached the Honorable Sessions Court, my lord. The Honorable Sessions Court has also gone on a different line altogether. He has not considered what the magistrate has not considered.
Yes.
Your lordship may kindly see the order passed by the magistrate court. The magistrate is
Who appears for the respondent?
one Mr. Srinivas.
K. Srinivas. So there is an interim order.
There's an interim order, my lord.
Heard the learned counsel, Srimati Revati Adinath Narade. The learned counsel for the second respondent, complainant remains absent. List the matter as a last chance on the 5th of September. In the event the counsel would not be present, the petition would be answered on the averments and the submissions. The counsel for the petitioner, interim order subsisting, shall continue to the next date of hearing.
For petitioner, my lords, I'm told they filed the additional charge sheet. They may be directed to give the copy, my lords. We'll make a submission.
Charge sheet in this case, my lord, sir. I will.
The learned
We
counsel.
will furnish in the trial court itself, my lord.
ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಮತ್ತೆ ಇವ್ರು ಯಾಕೆ ಕೊಡ್ಬೇಕು?
We
Last
don't have
occasion
the
also
copy.
they made a submission before the court. We have to apply the entire charge sheet material. Because we earlier, my lord, before the trial court,
There's an interim order by the coordinate bench.
yes, my lord.
Yes.
But they made a submission, my lord, charge sheet materials I have to supply. But
At the request of the learned counsel appearing for the petitioner, list the matter on 19th.
Interim order may be.
Interim order subsisting shall continue to the next date of hearing. It's made clear no further adjournment will be granted on the ground that the copy of the charge sheet or the supplementary charge sheet is not furnished to the petitioner, as the same would be done before the concerned court is. Next.
25.
Now, sir, for the petitioner, first matter.
25.2 and 25.3, my lord. So you can pass over, my lord.
Pass over. Passed over by one week. Report ಆಗ್ತಾ ಇದೀರಾ?
ಅಲ್ಲಲ್ಲ, this is a case they wanted to take a different view from your lordship's earlier order, Viresh Pillai. They said that
Who wants to take a different?
think Mr. Nayak, Murthy Nayak.
Yes, sir.
Milord, 20, yes,
155.
yes, 25.2 and 25.3.
Yes, sir.
Milord, this is not that mechanical permitted.
It's a
I'm
detailed,
not on that point.
detailed order.
Yes, quite a detailed order. Here, my lord, on merits. Lord, 155(1). Your lordships have the earlier view, my lord, in Gopal Krishna was that the informant has to be sent. In Vijesh Pillai, your lordship has taken the view that even the investigating officer can. As far as, my lord, that point is concerned, the Honorable Supreme Court, my lord, has in Gangadhar Narayan Naik.
Supreme Court held will follow that only. Pudi.
I think your lordship went through the interim order passed. I don't have much role in that.
No, this is referred to a larger bench.
Yes, this is on the point of, my lord, in POXO offences,
Section 90.
whether it is cognizable or non-cognizable.
Section 23.
Yes, while dealing with that aspect, of course, the two judges have differed.
Yes, differed, saying one is cognizable, one is
Yes,
non-cognizable.
kindly come to para 71, my lord, if I may pursue it, your lord. Para 71 on page 31 of the report. In contrast,
yes,
Chapter 12 CRPC deals with investigation also.
Yes.
After receiving information in cognizable or non-cognizable offenses. The power of investigation has been given to the police officer as per section 156. And the said officer shall make the investigation following the procedure as prescribed, so and so. I'll skip the next line, my lord. In non-cognizable offenses, the information may be recorded in section 155(1) CRPC by an officer in charge of a police station within whose limit the offense is committed. He shall enter the substance of information in a book to be kept by such officer in such form as the state government may prescribe in this behalf, comma, and shall refer the informant to the magistrate having power to try such cases, case. The said magistrate may pass an order for investigation, which shall be abided by the police officer and shall exercise the same power except the power of arrest without warrant. So, my lord, with regard to the interpretation of 155(1), of course, this was not the direct point involved in that case, but the point was, well, it had a overlapping. Whether offense under POXO, that is a specific offense there.
23.
Yes, was a cognizable offense or not. One of the learned judges, my lord, held that it is cognizable. The other learned judge has held that it is non-cognizable.
Yes.
Now, this is, my lord, with regard to interpretation of 155(1). Your lordship's view in Vijesh Pillai centered around, my lord, the judgments of various other high courts.
Yes.
Prior to that, your lordship in Gopal Krishna's case, my lord, had held that it is the informant alone who should be referred to the magistrate.
Yes. Where is my judgment?
This, my lord, this is the
Vijesh Pillai.
Vijesh Pillai is here.
That is after Vijesh Pillai? Is Gopal
No.
Krishna?
No, no, Gopal Krishna is prior. And in Vijesh Pillai, my lord, that has not been referred to. In fact, in the compilation of judgment, it must be on the file of the court. I have referred to all the earlier judgments of the coordinate benches of this court. Vijesh Pillai put. Huh? ಇದು Gopal Pillai proposal. ನಮ್ಮ ಕಂಪನಿ ಇಲ್ಲ ಅಲ್ಲಿ ಹೋಗ್ತೀವಿ In fact, my lord.
Yes.
This is on the point of 155(1). In fact, Vijesh Pillai has been, that is the compilation, my lord, all the
Vijesh
earlier.
Pillai has become final? Not challenged?
Not challenged. Not challenged.
The lordship reconsiders that view, my lord. This compilation consists of all the early, sorry? ಬೇಕಾ? ಈಗ ಸದ್ಯ ಇಲ್ಲ, ಆ ದಿನ ಕೊಟ್ಟಿದ್ವಿ ನೀವು. ಕೊಡ್ತೀವಿ. ಈಗ ಲಿಸ್ಟ್ ಇದೆಯಾ? ಇಲ್ಲ, ಆಯ್ತು, ಇರ್ಲಿ ಬಿಡಿ. In fact, serial number 2 of the compilation, my lord, from page 13 onwards in Yediyurappa's case, that was a pointed point for consideration, specific point for consideration, page 13 onwards. Your lordships would kindly turn to page 25. The judgment begins at page 13, 2020 SEC online. If may kindly turn to page 25, para 6.
Yes.
Point number 1 for
Justice
consideration.
Suraj Govindraj.
Yes.
That I have seen.
Yes, whether when a complaint has been lodged and or information furnished of an offense to a station house officer, the station house officer can
Now
use
you
a.
tell me one,
Yes,
apart from this.
yes.
A victim goes to the police station, seeks to register an FIR. It is a non-cognizable offense. Now, the informant has to be sent, whether he goes or not, waits there, who will not. Adike, either the informant or the police officer, what's wrong with it?
But the wording, my lord, even now the corresponding section in 155 in BNS.
That's the same.
It's it. And even the 1898
No,
code,
it's the same, all
all
same.
three. Because there is a.
Send the informant.
There is a specific purpose behind it, because normally, my lord, these non-cognizable offenses are not very grave offenses.
I know they are not grave offense, otherwise Permission Act.
Yes, like 323 for
It's
that.
504, 506, 323 and.
And most of them are summons triable offenses. The only
true.
summons triable offense, which is a cognizable offense under the IPC, was 304A. Now, even that, by virtue of 106 of BNS, that also has become a warrant case because the sentence has been enhanced.
Yes, cognizable offense.
Yes, only in respect of negligence by the doctors, the sentence is, the 304A now
Bifurcation is.
has been bifurcated into 3 parts. And if it is a hit and run case, then it is 10 years. So automatically it becomes a warrant case. But here, my lord, normally all these non-cognizable offenses, such as these election offenses.
No, the issue is whether the informant should go or
Yes,
the
the purport, my
officer
lord,
in charge of
behind.
police station.
because the section will have to be read as it is. That is one point. And even otherwise on merits.
Let me see, section 8 recourse we can now take, but since it's a 482 petition,
Can be.
that is where I was a little doubtful then also.
In fact, I have produced one judgment.
Ah.
In fact, I and Mr. Chowta had argued this before Justice Chavan, my lord.
Ah.
And there the point was whether a 482 can be referred to a larger bench.
That's, which is that?
Yes. I'll give, there his lordship has held, there the point, my lord, involved was regarding revision. Whether a revision petition can be.
So whatever point involved may be anything.
Yes, so
Whether it is with 482 petition can be referred to a larger bench.
it has been held, my lord, under section 4 of the Karnataka High Court Act, subject to correction. It has been held that even a 482 can be.
Yeah.
Now, of course, if your lordship reconsiders there is nothing wrong in your lordship taking a different view.
True, but we went on quashing petitions were permitted and
Yes.
the informant.
That
But-
is 155 too.
True.
Now this is
155 no, no,
155.
155. One also we have quashed
Yes,
proceedings
Yes.
because informant has not gone
yes,
to the police station, but the officer in charge has gone.
please.
Where is the justice to the victim, sir?
Yes, now here, my
Where is the
lord,
justice to the victim? Tell me. That's what you should look. Ground reality you should
yes,
see,
that is.
not literal interpretation of the statute. Now, 323, there is an assault.
Yes,
For an illustration, there is an assault.
yes,
Victim goes to the police station,
simple,
gives it.
simple
Or
hurt.
simple
Yes,
or whatever, there is
Yes.
assault.
yes,
504, 506, all right. The 323 deals with assault. It's an assault.
yes,
All right. He goes to the police station, comes back. The officer in charge of the police station goes to the magistrate, seeks permission and comes. So the informant has not gone to the police station, so we quash it.
has not gone to the magistrate. Yes.
Magistrate, we
Yes.
quash it.
Yes,
So what happens to the victim?
that, my lord, the police officers have to be blamed.
No, that is why.
They have to be vigilant.
Either police station ಹೋಗೋದೇ ಕಷ್ಟ ಎಷ್ಟೋ case ಅಲ್ಲಿ.
Sometimes
You ask
not-
them to go to the magistrate and sit there and get permission.
Sometimes they are over exuberant. Sometimes when commercial matters are involved, they are
Commercial
over
matters, sir,
exuberant. They
commercial-
go overboard.
Sir, I'll tell, that's a different thing, sir.
So they should be
They're going
vigilant.
overboard is a different thing.
Yes, here when
See,
they are required,
Now, whatever, in a rural area, a man gets assaulted. He goes to the police station saying, yes, somebody has hit me. You go to the magistrate, take permission and come. Why will he go? He'll go back home.
or he will go back and assault that.
No, whatever. See, that's why. Know the ground reality.
Yes.
What is the justice to the victim, you tell me?
That is there.
Then that's precisely why I wrote that judgment. Either the police officer or the informant, either of the two can go.
Mine
Otherwise,
is-
there is no justice to the victim.
In the Supreme Court, my lord, in this judgment, issue was not whether
No,
informant
section
has,
23 of POCSO runs on a different
Yes.
thing.
and the second issue.
Whether that was cognizable or non-cognizable was the offense.
issue.
Illy, that is not the issue.
Not, and the para which my senior friend read.
And scores and scores of cases, even I have quashed. I am not saying I have not quashed. On the
Yes.
ground that
Yes.
informant did not go to the.
The reason, my lord, why I am trying to persuade your lordship to try and consider this is,
We'll see. Yes.
one, my lord, in Gopal Krishna's case,
No, you leave cases of this kind, cases of the other
Yes.
followed. Gopal Krishna's case, yes, we had. See, if daily, I think, following Vagepa, we have disposed 10 cases. Saying it is permitted. That is why I have given direction to the magistrate not to say permitted, maintain a separate order sheet, write a detailed order,
in
all
which,
that.
in Vijay
Because
Pillai itself,
informant cannot go, sir, in every case.
in Vijay Pillai itself, your lordship has very copiously
Yes.
issued directions
Yes.
in paragraph 5. That is there, my lord.
No, you tell me the solution.
Correct.
What justice would be given to the victim?
Looking at it from a
That is-
broader societal.
That is
my lord.
what I have looked into in that
Yes,
and nothing else. I have said so.
yes.
We will be denying justice to the victim.
Your lordship also followed the other high court judgment.
I have followed all the other high court judgments and distinguished my own orders that are passed. And I have so said, because victim justice is definitely needed.
That is true, my
Then,
lord.
sir,
As
it's
an
not,
officer of the court, I would definitely say.
That is what I'm.
Yes.
That's why I said you leave everything
Yes,
apart.
yes.
Leave your case
Legality-
apart. Now you tell me that assault ಆಗಿದ್ರೆ ವಾಪಸ್ ಮನೆಗೆ ಹೋಗ್ತಾರೆ. Police station ಎಷ್ಟೋ ಸರಿ ಹೋಗೋದೇ ಕಷ್ಟ. And you ask him to go and sit before the magistrate and take permission and come. He will not, sir.
That is it.
Some may not.
Some may not.
So that's not.
Only one thing, my lord, I would like to add, the intention behind this would be, intentions of the legislature would be taking into consideration the triviality of the allegation.
See, misuse of that by
Yes.
the station house officer can happen. ಎಲ್ಲದ್ರಲ್ಲೂ you go in, ಕೆಲವ್ರು ಕಳಿಸೋದು, ಕೆಲವ್ರು ಕಳಿಸದೇ ಇರೋದು, ಇವ್ರು ಹೋಗೋದು. But that doesn't mean you can paint everything with the same
Yes,
brush and
yes.
say,
One is
no.
misuse, my lord. Second is the trivial nature. For example, if I may give another example, my lord, for mischief, that is 426. Someone might say someone has pelted stone on my, yeah,
Alright.
so that is again a non-cognizable.
Yes.
Yeah. So taking into consideration the trivial nature of
No,
the
you
allegation.
take 323 itself.
Yes, someone can say someone slapped down
Assault,
the corridor.
slap,
Yes.
assault, or even minor hurt.
Yes.
The injury is simple in nature, but that's an injury. That's an injury, that's an assault, that's an offense.
At least in BNSS, they could have revisited.
It's a different thing, but that's an offense.
Instead of the entire cut and paste exercise of most of the sections, they should have done it. It's nothing but, huh?
Of course, that you can say. Yes.
Yes. And yes.
That's precisely why I wrote Vijesh Pillai.
Yes, my lord. That is only as far as 155(1), only tried to pursue it, my lord. And as far as the merits of this case is concerned.
Merits you can tell me.
Yes. The allegations, my lord, are that certain pressure.
171B.
Yes, certain pressure cookers
Pressure cooker matter.
were distributed to entities voters. Here probably, my lord, this is one classic case where misinterpretation of language in the section has gone awry. The word employed in the Representation of People's Act is vessel. So the vessel means a ship.
No. That's not the intention. 125 RP Act.
Yes. The word employed there is vessel. If your lordship would kindly come to section the.
123(5).
Yes.
Yes. Hiring or procuring, whether on payment or otherwise, of any vehicle or vessel by a candidate or his agent. This is your right. It's a vessel.
So it has to be.
Independently, if you read vessel, they have independently read vessel and.
Yes, because they must have literally translated a cooker into a
ಅದೇ
vessel.
vessel ಅಂದ್ರೆ ಪಾತ್ರೆ.
Patre.
Yes. All
So
right.
certain pictures of the petitioner, that is the first petitioner in 1369 of 24.
Yes.
Was found on these carton boxes of the pressure cooker, which was found in the house of the second petitioner, is the allegation. So these offenses, my lord, are involved. It is
Who
not.
is the complainant here?
Complainant is the electoral officer.
He does not go to the police station.
He goes to the police station.
Then?
He files a complaint.
Then what is the issue of distinguishing Vijesh Pillai in this?
Is there contention that
No,
he
no.
should have gone to court?
He goes to the police
Police
station.
court.
The investigating officer takes permission. So what weighed with the coordinate bench, my lord, while passing the order, in fact, my learned friend was there. The coordinate bench had asked him a specific question: can the investigating officer not be selective?
Exactly.
Yes.
That was what I also thought. He can be selective.
In
cases,
harassing also.
That is why what I've said. I have not said only the IO can go, either the informant or the IO.
No, my lord, selective, not that way.
Then?
Selective in terms of going to the magistrate. So in one case, if he wants to assist the accused, then he will himself go.
All right.
He will raise this ground.
All right.
In another case, my lord, he will literally follow 155, mandate in 155. Send in. So it can be a selective flaw that is adopted by him
It can be the other way around.
Other way, yes. My
That is
judgment was
that is
there.
where we were reading 155, we said that 155 one cannot, has to be looked in two different compartments, 155-1 and 155-2. So therefore, your lordship in this judgment have distinguished these two aspects
Yes,
and then
yes.
rendered the judge.
So on merits, my
Justice
lord,
to the victim, sir,
Yes.
somehow.
here on merits, also it doesn't.
Because it is easy, the informant has not gone quash it.
Yes,
Accused gets away.
yes, ma'am. Second case to either to interim order. In fact, the second case, that is 2993, lordship may kindly see the interim order.
ಎಲ್ಲ ಪ್ರೆಷರ್ ಕುಕ್ಕರ್ ಏನಾಯ್ತು?
ಹೌದು, ಇವರು this petition is the petitioner is the one in whose possession pressure cookers were found is the allegation, or rather in whose house.
There are four petitions.
I am, my lord, concerned with 25.1 and 25.2.
25.1 and 25.2.
I'm sorry.
ಹಾ. ಇದರಲ್ಲಿ ಪ್ರೆಷರ್ ಕುಕ್ಕರ್ದಾ?
I'm sorry, my lord, 25.2 and 25.3. That is 1369 of 2024 and 2993 of 2024.
Yes.
These both, they are A1 and A2. In 3969, my lord.
Facts are same,
Facts are
arising out of same crime.
Same crime.
Yes,
that's
arising
all.
of same crime. A1 and A2.
Yes, sir. On merits, no case.
171E.
ಏನು bribery?
ಹೌದು. ಇದನ್ನ ಇಟ್ಟಿದ್ದು ಬ್ರೈಬರಿಗೋಸ್ಕರ. And we are not invoked 123, we invoked 133.
ಯಾವಾಗ ಕೊಟ್ರಿ ನೀವು ಪ್ರೆಷರ್ ಕುಕ್ಕರ್ನ? When the pressure was on? Or it had come to the brim? Previous day?
Illa, long before.
Long
That is
before.
the education. And a very good quality pressure cooker.
Obviously, ಇಲ್ಲದ್ರೆ ಓಟ್ ಬರಲ್ವಲ್ಲ.
Hawkins or something.
Okay. Yes.
Long before,
Huh?
on 5/4.
5/4/23.
23. ಅವತ್ತು election.
5/4/23, after the code of conduct.
Before the election.
Before, of course, before the election. Election was 10th May.
ಹೌದು.
And it was found in his house and of the second petition.
ಎಷ್ಟಿತ್ತು? Considerable.
Numbers are considerable.
Were you a dealer in pressure cooker? ಇಲ್ಲಲ್ಲ? Yes.
7.5 liters, so 140 cookers.
And size is also quite big.
5 liters 8 cooker, 7.5 liter ಮತ್ತೆ 5 cookers, 5 liters 13 cookers, 231 cookers total.
Who is the petitioner in the companion petition?
He, second accused, my lord.
Lala. Who is he?
The first petitioner, that is
First petitioner is the
1369 was the candidate.
candidate. Who is this second petitioner?
Second petitioner.
I mean in that TNR Rohit.
Yes.
Who is he?
The allegation is that in his house, the pressure cookers were found.
Was he an agent of?
No, that
the
is,
candidate?
they only say cookers were found in his house. Photo of this first petitioner was found actually.
Oh.
And this was much before code of conduct.
No. 30th March was the code of conduct.
Yes.
30th March 2024 was the code of conduct.
I might be wrong.
Yes. ಅಲ್ಲ ನೋಡ್ಬಿಡಿಬೇಕಾರೆ I might be wrong.
ಇಲ್ಲ. Sometimes.
Yes, sir. Ashana, glance, sir. Heard reserved because I'm reserving because I have to see whether I should reconsider that or not. But I'm doubtful of reconsideration.
Yes. The interim order in both.
Interim order subsisting shall continue till the disposal of the petition. ಇಲ್ಲ ಎರಡು ಮಾತ್ರ. ನಿಮ್ದು ಯಾವುದು?
First matter must 10209 numbers 23.
25.1 and
Plus, first matter plus 10209 plus.
ನೀವು ರೆಡಿನಾ?
Please, plus offenses punishable number 171B, 171E.
ಅದೇ all bribery, sir.
Please, plus can you see the complaint plus accused number 1 plus before plus page number 14 plus.
Yes, sir. ಇದರಲ್ಲಿ you have vehement objections.
It's a detail order has been passed in this. House.
No,
No, detail order.
no detail order plus. Can you see plus
No, ಇಷ್ಟು ಸಾಕು. ಇದಕ್ಕಿಂತ ಆರ್ಡರ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
plus accused number 1 is officially candidate plus the accused number 2 is plus distributing the money.
You come on merit, sir. Don't go on 155, 1 or 2.
Plus can you see the complaint plus page number 14 plus.
Yes.
Plus page number 14 plus plus may I read plus. ಈ ದಿವಸ ದಿನಾಂಕ 8/5/23 ವಾಹನ ಸಂಖ್ಯೆ ಎತ್ತರಲ್ಲಿ ಸಂಗಡ ಶ್ರೀಮತಿ MR ಮಗ್ದುಮ್ ASI ಮಾರ್ಯಾಳ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮತ್ತು ವಿಡಿಯೋಗ್ರಾಫರ್ ಮಾದೇವರಾವ್.
Oh, you are distributing money?
No, I am not distributing money, sir. The accused number 2 is distributing money in favor of my plus.
On behalf of accused number 1, accused number 2, that's it.
ಇದು bribery. We'll see. D-link 25 and 25.1. Sorry, 25 ಮಾತ್ರ. 0.1 ಯಾರ್ದು ಮೇಡಮ್?
25.1, Malad. Senior counsel is held up in the
25 and 25.1. List them both on 19th.
Interim order may continue.
Interim order subsisting shall continue till the next date of hearing. 25.2 and 3 reserved.
Please.
Government ಯಾವ್ದ್ರಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಸರಡ್ ಅಂತಿದೆ. Registry 25.2 ಅಲ್ಲಿ ಮೇಡಮ್. Registry to print the name of learned additional SPP as appearing for the second respondent as well. Yes, both. Next.
Wait.
ಇದೇನು?
This is 195A proceedings, my lords, which were in.
195 capital A of IPC. That is, witnesses came to be threatened to toe the line that is suggested to them by the defense. That is certainly, my lord, is made penal under 195 capital A. There is no doubt about that. My lord, under section 195, my lord, who is the person who has got to file the complaint? But for that, again, 195 capital A CRPC, there is an amendment. May I request your lordship to kindly have a look at
195A.
195. First, we'll go to 195. Man. No court shall take cognizance.
Yes.
Kindly go to B.
Yes.
Of any offense punishable under any of the following sections of the Indian Penal Code.
Yes.
Namely, sections 193 to 196, both inclusive. Except on a complaint in writing of that court. But 195 capital A comes within 195 1B, because 193 to 196.
Yes.
Excepting upon a complaint by the court concerned.
Sections 193 to 196.
Yes.
When such offense is alleged to have committed or in relation.
No, my lord. There is an amendment.
Amendment.
Yes, there is an amendment. 195 capital A came to be introduced in 2009.
Yes.
That would enable
a witness or any other person.
A witness or any other person may file a complaint.
Under section.
That is a concession that is given to the prohibition that is imposed under 195.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ?
ಅಲ್ಲ ಬಂದೆ ಒಂದು ನಿಮಿಷ. This is the finest legal issue which I have raised from a lord's kind consideration. Well, 195 capital A only enables either a witness or any other person to file a complaint. That's all. It will not dispense with the procedure with the court is required to follow in or in relation to an offence under section 195 capital A of the IPC. May I just request your lordship to kindly have a look at section 340 now for a second.
340.
340.
Yes.
That is the procedure.
Yes, yes.
It will not dispense with 195 capital A as amended, may not, will not dispense with the procedure which the court is required to follow. For the purpose of initiating action in or in relation to an offence under section 195 capital A. Have a look at section 340 of the CRPC. My lord gets it?
Yes, yes.
When upon an application made to it in this behalf or otherwise, any court is of the opinion that it is expedient in the interest of justice that an inquiry should be made into any offence referred to in clause B of subsection 1 of section 195.
Yes.
Which appears to have been committed in or in relation to a proceeding in that court, or as the case may be in respect of a document produced or given in evidence in a proceeding in that court, such court may after such preliminary inquiry, if any, thinks necessary, number one, record a finding to that effect. B, make a complaint thereof in writing, send it to a magistrate of the first class having jurisdiction.
So whether it is 195 or 195A, his submission is 340 cannot be given a go by.
That's it. That is the first submission, legal submission.
Yes.
Well, now have a look at section 341 for a second.
Yes. Appeal.
Appeal is there. And any person on whose application any court other than a high court has refused to make a complaint under subsection 1 or subsection 2 of section 340, or against whom such complaint has been made by the court may appeal to the court to which extent an appeal lies. But here the question is, what the complainant does, they will go to the magistrate and file a complaint, and the magistrate takes cognizance
Of 195A.
195 capital A. Then he would issue summons. ಅದು ಯಾವ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಂತಂದ್ರೆ ಇದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕು ಆಕ್ಚುಲಿ.
ಹೌದು.
ಅಲ್ಲಿ ಅಲ್ಲಲ್ಲ, ಅದು ಲೋಕಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ ಕಾಗ್ನಿಸೆನ್ಸ್. ಅದು ತಪ್ಪೆ. Have a look at the schedule 1 minute to the CRPC classification of offenses. ಇಲ್ಲೇ ಇದೆ ಆಕ್ಚುಲಿ, ಈ 195 ಕ್ಯಾಪಿಟಲ್ ಏನಲ್ಲೇ ಇದೆ.
IPC.
ಹೌದೌದು, ಅದರಲ್ಲೇ ಇದೆ.
ಥ್ರೆಟನಿಂಗ್ ಅ ಪರ್ಸನ್ ಅಲ್ಲೇ ಇದೆ.
ಕ್ಲಾಸಿಫಿಕೇಶನ್ ನಲ್ಲಿ
ಅಲ್ಲೇ ಇದೆ.
ಅಲ್ಲೇ ಇದೆ. ಏನಂತಂದ್ರೆ
7 years.
ಹೌದು. The court in which the offense has been committed. Even schedule ಅಲ್ಲೂ ಬರುತ್ತೆ, schedule 1 ಅಲ್ಲೂ ಬಂದ್ಬಿಡುತ್ತೆ.
Triable by court by which the offense of giving false evidence.
Magistrate, how can he take ಅದು? Number 1. Number 2, my lord, there must be an inquiry under section 340. What the magistrate does, he treats the complaint as if it is a police report. Without he does not hold an inquiry at all. May I just request your lordship to kindly have a cursory look at the order which can be passed by the learned magistrate.
Page
122 minutes. Kindly go to ಬರೀತಾರೆ ಪಾಪ, ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು ಅಂತ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಡ್ತಾರೆ. Para 15, 127, relevant page 127, para 15. The present my lord gets it.
127 ಯಾವ್ದು?
A separate order is passed.
Separate documents ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, separate order is passed, my lord. On 125 minutes. It commences at page 125.
125 handwritten.
ಅಲ್ಲ, typed copy. May I just pass on the certified copy?
No, that is page 129, I guess.
Yes, I'm sorry, my lord, sir.
Acting under section 190 ಅದ?
Yes. ಅಲ್ಲ. My lord, may I just pass on this? Kindly go to para 15 for a second.
Oh, this order is not there. Yes.
ಇವರು ಹಾಕೋವಾಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, ಈ ಡೀಟೇಲ್ಡ್ ಆರ್ಡರ್ ಹಾಕಿಲ್ಲ.
Separate order ಹಾಕಿಲ್ಲ.
Separate order.
Page para sir?
Para 15, internal page 11 of the order.
Yes.
The present complaint is under section 195 capital A of CRPC against the accused 1 to 8. And the said provision is mainly related to an offence committed under section 195A IPC, which deals with threatening any person to give false evidence. But I am not on the merits of the matter at all. Your Lordship may proceed with an assumption that everything is true. I am only concerned with the legal procedure,
Yes.
my lord, which the court was required to adopt
Yes.
and follow. On a close reading of facts of the complaint and the careful perusal of the relevant documents collected by the CBI. No, it is not a charge sheet. It is not a police report under 173(2). It should be a complaint as defined under section 2D. During further investigation, there is no investigation here. Well, it is for the magistrate to hold an inquiry and nobody else can do it. It is noticed that the facts constituted the alleged offence under section 195 capital A of the IPC. Further, on a careful perusal of statements of witnesses recorded by the complainant CBI in its further investigation. No, but CBI is nobody. It is only the court under section 340 that has got to hold an inquiry. Inquiry means as defined under section 2G of the CRPC. Well, 2G specifically says it is only the magistrate who has got to hold that inquiry under the provisions of the court. The deposition of the witnesses in SC number so and so on documents used and produced by the complainant, it appears and shows prima facie that there are sufficient grounds and materials evidence to take cognizance for the alleged offence under section 195 capital A against accused number 1 to 8 and proceed with the case. But he has no jurisdiction to take cognizance. It is a court. It is a trial court. Next, my lord, kindly see the next sentence. Therefore, I am of the opinion it is expedient in the interest of administration of justice that an inquiry should be made into the matter by taking cognizance. All right, hold an inquiry. Doesn't matter. Even proceeding with an assumption that he has jurisdiction. Then he has already issued summons. Issued summons to the accused. The inquiry should proceed prior to the issuance of summons. That is number one. After the inquiry, if he is able to make out that an offence has been committed, then my lord, a formal complaint has got to be filed before the magistrate before him. Not otherwise.
Yes. Yes, sir.
That's a coordinate bench of this court has already considered the submissions in this case and has dismissed.
Where?
That's I have only one copy.
ಇದನ್ನ
195.
195 ಈ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿರೋದನ್ನ
I have only
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
one Mr. Gurunath Gowder has.
ನಾವು ಸರಿ ಬಿಡಿ.
That's a request.
Justice
short
Sandesh
accommodation.
ಮೇಡಮ್ ಅದರಲ್ಲಿ ಇದನ್ನ ಕ್ವಶನ್ ಮಾಡಿದಾರೆ ಈ ಆರ್ಡರ್ನ.
ಈ ಆರ್ಡರ್ ಅಲ್ಲ.
195 proceedings.
No, 195A proceeding.
Because
The coordinate bench holds that it can be,
no,
it need not, procedure 340 need not be followed.
May I request for a short accommodation, my lords? My senior is not.
but this is not the case, I am told.
Not this case, sir. Not at all this case.
Not at all this case. ಸಂಬಂಧ ಇಲ್ಲ.
ಇಲ್ಲ ಇದೇನೆ. One of the persons, same.
But that is filed by the victim. Mother.
ಗುರುನಾಥ್ ಗೌಡ ಯಾರು?
ಹೌದು. ಇವ ಅಕ್ಯೂಡ್ ಅಲ್ಲ, ಅವನು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ. ಇನ್ನೊಂದು ಕೇಸ್ ಅಲ್ಲ ಅದು.
But same, respondents are the same.
In that case, my lord, B report has been filed. Now what we have questioned is the issuance of summons in this case. Right?
No, but same allegation.
ಅದು ನಮ್ಗೆ ಪರವಾಗಿದೆ ಅದರಲ್ಲಿ, ಅದರಲ್ಲೂ ಅದರಲ್ಲೂ ಬರೆದಾರೆ 340 ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಬೇಕು ಅಂತಾನೆ ಬರೆದಾರೆ. But I am not on that issue. Here process has been ordered. Magistrate orders process without an inquiry.
And this appears to be in their favor.
My lords.
It is set aside and sent back.
ಅಷ್ಟೇ.
For my lords, that.
ಅದ್ರಲ್ಲೂ ಅದೇನೆ.
340 ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಿದ್ದಾನೆ ಬರೆದಿರೋದು ಅದರಲ್ಲಿ.
That's what the learned judge takes notice, since the law is being developed there, since they have not yet been included it in 340, 195A, which is recently amended. That part is what we're trying to rely upon. We'll file a short synopsis, a short accommodation may be given.
Yes.
They have the benefit of interim protection.
Interim order ಇದೆ, not the.
ಇಲ್ಲ ಇಲ್ಲ. ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರೆ ಯಾವ ತರ ಇದೆ ಅಂದ್ರೆ
Not to precipitate.
ಅಲ್ಲ ನಾಟ್ ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಅಂತ ಹಾಕೋತಾರೆ, ಅದು ತಪ್ಪೆ. ಎನ್ಕ್ವೈರಿನೇ ಆಗಿಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಬೇರೆಯವ್ರಿಗೆ ಹೋಗ್ಬೇಕು, ಇವ್ರು ಮಾಡ್ಲಿಕ್ಕೂ ಬರೋದಿಲ್ಲ ಅದನ್ನ. ಸೇಮ್ ಕೋರ್ಟ್ ಕಾಂಟ್ ಡೂ ಇಟ್.
In fact, this court on 24/11/2023.
Not to precipitate.
No,
ಹೌದು
in
ಸರ್,
fact,
not
to
to
defer
precipitate
trial
ಆಗಲ್ಲ.
proceedings also has.
Not, well, in fact, in one of the judgments of this court, a coordinate bench of this honorable court, speaking through, Honorable Justice Dinesh Kumar has said, not to precipitate means,
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ದಾರೆ.
Supreme Court, not to take any coercive steps, don't go lay your hands upon him ಅಂತ, not for the purpose of recording. ಅದು ನಮ್ಗೆ ಇವರು ಪ್ರಸನ್ನ ಕುಮಾರ್ ತೊಂದರೆ ಇಲ್ಲ ನನಗೆ.
ಕೋರ್ಟ್ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲಲ್ಲ, ಅಲ್ಲಿ ಒಬ್ರು ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಇದ್ದಾರೆ, ಅವ್ರಿಗೂ ಗೊತ್ತದು. ಬಹಳ ತೊಂದರೆ ಏನಿದೆ ಆ ತರ, ನಾವು ಎವಿಡೆನ್ಸ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ.
We have communicated it to him.
ಇಲ್ಲ ಬೇಡ ಸರ್, ಯಾತಕ್ಕೆ? If I am otherwise entitled for the grant of an interim order to your lordships, and kindly grant me.
Not to
Otherwise, no.
precipitate order cannot be granted to a against the court.
No, my lords, on
Only for-
24/11/2023, this honorable court directed us to defer proceedings before trial.
24/11.
2023. There's an order. That is what I'm emphasizing, not the no coercive action.
ಇಲ್ಲಿ ನೋಡಿ, ಎವಿಡೆನ್ಸ್ ಹಾಕೊಂಡು ಎಕ್ಸಂಪ್ಷನ್ ಹಾಕ್ಬೇಕು.
I'll
With
communicate.
my
it.
order.
Yes, my lords.
ಎಲ್ಲಿದೆ? 24/11/23.
24/11/2023. there-
24/11 ಇರೋದು to secure restrictions and make submissions in the
Yes.
light of the fact the challenge.
No, in fact, this honorable court had orally directed us to defer proceedings to intimate.
Orally directed.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳಿದ್ರು. ನಾನು
We have, my lords, we have communicated it. If there's any issue.
All right, you submit on the next date. I will just record the submissions of the senior.
Yes, my
counsel.
lords.
Let further proceedings be stayed.
Yes, heard the learned senior counsel. Who's for the respondent? Complainant?
ಅಲ್ಲ, ಇದರಲ್ಲಿ CBI, he can't be the complainant, my lord. Police charge sheet ಇದು. Under the learned judge
Heard
writes.
the learned senior counsel, Shri C.V. Nagesh, appearing for the petitioner. The petitioner calls in question an order of the learned magistrate taking cognizance of the offence under section 195-A of the IPC. The learned senior counsel would submit that 195A, the offence deals with threatening the witness, threatening a person to give false evidence. The learned senior counsel submits that the procedure for an inquiry, for an inquiry on an offence under section 195 is stipulated in section 340 of the CRPC. Section 195 and 195A and 340 reads as follows. The only difference that has cropped up in the year 2009 by way of an amendment to the CRPC is section 195A of the CRPC being inserted. Section 195A coming in by way of the amendment, which reads as follows. Section 195A of the CRPC permits a witness or any other person to file a complaint in relation to an offence under section 195A of the IPC Supra. The learned senior counsel, the submission of the learned senior counsel is that merely because permission is granted to file a complaint, permission is granted to a witness or any person to file a complaint, the procedure under section 340 cannot be given a go-by for an offence under section 195 or 195A of the IPC. The learned 195, there is merit in what the learned senior counsel would contend. If the provisions of the statute quoted supra is pitted against the order that is passed by the concerned court, taking cognizance of the offence, it would prima facie fall foul of the statute. Therefore, fall foul of the statute. The learned senior counsel would further submit that the proceedings are before the concerned court. The concerned court in the case at hand is the court of session, the special court dealing with the matter. But the complaint, you are the complainant, huh? But the complainant, CBI in the case at hand, registers a complaint before the learned magistrate at Dharwad. And cognizance is taken by the learned magistrate, which ought to have been placed and cognizance taken, if any, only before the special court. In the light of the in the light of the lack of jurisdiction, the hands of the court that has taken cognizance, as also the procedure under section 340 not being followed even to its semblance, I deem it appropriate to stall further proceedings, the impugned further proceedings before the concerned court, the impugned offense till the next date of hearing. List on 5th September. You file your synopsis or whatever you want. How you have. Synopsis, sir. Yes, adjournment,
Yes.
madam.
27. Hearing in 27 minutes. Next case.
Next case, you want time?
No more. Take accommodation.
I want time. Yes,
Second half, I may be accommodated for 5 minutes. Very short matter.
we'll see. Any adjournments, madam?
27, 27 and 28. Page 8. Number 29 to 37.
Yes.
This
List two, I'll call list two, wait. Yes.
This one, page 9, number 38 to 43. Page 10, 44 to 47.
Serial number 40.
First list.
Yeah, first.
Yes, sir.
Learned friend appears in the petition. I'm ready for quashing here.
Idyena? Quashing.
354A and 354D.
ಅಲ್ಲ ಇನ್ನೊಂದಿತ್ತಲ್ಲ ಅದು ಮೇಲೆ 364A ಗಿವನ್ ಅಪ್ ಅಂತ ಹೇಳ್ತಾರೆ.
354 ಇದು. ಈಗ 364A ಅಂದ್ರೆ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ your lordship may recall to your lordship's memory while your lordship heard the bail
applications, yes.
ಅದರಲ್ಲಿ court itself has not taken cognizance for the offense.
364A.
ತಗೊಂಡೇ ಇಲ್ಲ 365 ತಗೊಂಡಿಲ್ಲ. ಅದು ಆಮೇಲೆ ನೋಡೋಣ. We are not concerned with that.
Yes, sir.
ಅದಕ್ಕೆ connected
So this is 354.
354A and 354D.
All right.
One second. ನಾನು ಜಾಸ್ತಿ ಹೇಳಲ್ಲ.
ಆಯ್ತು.
354A and 354D are offenses. Ultimately, if it is found to have been established, the punishment that is contemplated is 3 years sentence.
Yes.
468 comes into play. The complaint itself is after lapse of 4 years. ಅಷ್ಟೇ, ಬೇರೆ ಏನು ಬೇಕಾಗೇ ಇಲ್ಲ.
ಆಯ್ತು. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬಿಡಿ ಸರ್.
ಇದು 3 ಸರಿ ಆಯ್ತಾಗ್ಲೇ.
Finally.
Stay my lord, otherwise let there be a stay.
ಅಲ್ಲ ಫೈನಲಿ ಹಾಕ್ಬಿಡಿ. We'll hear it and dispose it off.
ಅಲ್ಲ ಇವ್ರು ಹೇಳಿದ್ರು
Any day convenient.
We'll have it on 30th, next Friday. Objection, sir. Copy, sir, ಮಾಡಿ.
Copy.
Copy, sir. Learned additional SPP, special PP. Files statement of objections. ಯಾವ್ದು serial number 49 ಇದು? Serial number 40. File statement of objections. The same is taken on record. Yes.
Please.
30th August. Yes. Next.
Number 2.
Serial number 1, 2 weeks time.
1.
This
Why,
number
sir?
2 weeks time may be that.
Non-filing for having hand summons.
Page 1.
Serve the copy to the respondent.
138.
130.
Stay ಇದೆಯಾ?
Stay.
ಇಲ್ವಾ? 2 weeks third. Yes. At the request of the council with the petitioner list after 2 weeks. Yes, next.
Page 2, 8 to 15. Page 3.
Serial number 13.
ಯಾವ
ಒಂದು ಫ್ರೆಶ್ ಲಿಸ್ಟ್ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ.
Interim order ಇದೆಯಲ್ಲ?
ಇಲ್ಲ.
ಇಲ್ವಾ?
Fresh
ಯಾವತ್ತು
list.
ಬೇಕು?
ಎನಿ ಡೇಟ್ ಕೋರ್ಟ್ ಟು ಕನ್ವಿಟ್ ಟು ದಿ ಕೋರ್ಟ್.
List on ಯಾಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇದೆ?
ಕೇಳ್ತಾರೆ ರೆಡಿ ಇದೆ ಸ್ವಾಮಿ, ರೀಚ್ ಆಗಲ್ಲ.
ರೀಚ್ ಆಗಲ್ಲ. ಕರೆಕ್ಟ್. Yes. ಆಯ್ತು. List on 10th. Yes.
ಫ್ರೆಶ್ ಲಿಸ್ಟ್ ಸರ್.
Fresh list 10th. Yes. Fresh ಅಲ್ಲಿ ಇರೋದು ಫ್ರೆಶ್ಗೆ ಬರುತ್ತೆ. Yes.
Page 3, 16, 21. Page 4, 22 to 27. Page 5, 28 to 35.
Serial number 30, my lord, 30. Lord, this is the 407 petition, transfer petition.
awaiting service ಇದೆ, will adjourn it, sir.
However, my lord, it was admitted
407 ಇಲ್ಲ
ಹಾ,
ಬಂತು.
ತಮ್ಮ ಮುಂದೆ ಬರಲ್ಲ ಅಂತ ಸರ್.
ಅದು post the matter before the bench having roster. Yes.
Please.
ಅದೆಲ್ಲ ಮಾಡ್ತೀನಿ ಸರ್. ಅದಕ್ಕೂ ಈಗಲೇ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ? ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ? 36.
I'm for respondent number 2, my lords. This is
That's
limited.
vacating stay ಇದೆ, wait sir. ನೀವೇ ಹಾಕಿರೋದಾ?
I require 1 week's time to place some documents or record.
All right. At the request of the learned counsel appearing for the second respondent, list the matter on 11th September.
Great.
Yes. Interim order subsisting shall continue. ಯಾವ್ದ್ರಲ್ಲಿ sir? Extend ಆಯ್ತು sir.
Page 7,
Hmm.
53 to 50, page 8.
44 my lord.
44 my At the request of counsel appearing for the petitioner. ಏನಿದು? Essential commodities. Yes. List again same 11th.
Page 8, 51 to 55, page 9, 53.
50?
The R2 in this case.
Yes, sir.
Objection, your time.
Counsel for the second respondent seeks 2 weeks' time to file statement of objections. Interim order subsisting shall continue to the next date of.
There is no
Ilva.
interim order.
That continues. Yes. No interim order. Yes, next.
Page 9, 56 to
56 to?
62.
606.
mile
56 yen.
for petitioner, my lord, Zeda. 1 week time will be granted, my lord, senior, very covered.
At the request of counsel for the petitioner.
60, my lord, serial.
List after 2 weeks. List after 2 weeks, interim order subsisting shall continue to the next date of hearing. Yes.
60, my lord, serial number 60.
57 or adjournment, S.G. Bhagwan is hospitalized. Sir. Yes, at the request of counsel is representing S.G. Bhagwan, list the matter for 2 weeks. Interim order will continue.
Serial number 60. For petitioner, my lord, steps need to be taken for respondent number 2. The respondent number 2 steps are, I mean, permitted to take steps, my lord, for notice may be reissued. R2 is unserved. The correct address.
ಆಯ್ತು ಬರ್ಲಿ, ಅದು ಸರ್ವಿಸ್
ಅಂದ್ರೆ-
ನೋಟಿಸ್ will grant time, don't.
I'm sorry.
Serial number
ನಾನು ಮಧ್ಯಾಹ್ನ
Serial number 63, Your Honor, reporting of settlement for refer to the mediation. I for the petition.
ಏನಾಯ್ತು?
Mediation. ಅಲ್ಲ ಇವತ್ತು ಹೋಗ್ಬೇಕು ಸರ್. Hard may be order.
ಲಂಚ್ ಆದ್ಮೇಲೆ ಮಾಡ್ಬೋದಲ್ಲ ಅದು?
I'm sorry, my lord, serial number 60 ನಾನು ಮಧ್ಯಾಹ್ನ ಇರೋದಿಲ್ಲ ಹಾಗಾಗಿ ಸುಮ್ಮನೆ.
ಆಯ್ತು ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ ನೋಡಿ.
Please.
ಬರ್ಕೊಂಡು
The lordships kindly, let's list one serial number 29. Lordship kindly have it next week.
ಅಲ್ಲಿ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್, ಯಾವ್ದು ಟೈಮ್ ಕೇಳ್ಬೇಕು?
Let's interim order in that is subsisting.
ಕಂಟಿನ್ಯೂ.
Obligation.
May I make one submission, Lordship?
Yes, Tahir, review petitions tomorrow.
Oblige.
Madam, 29.
Sir.
Second, serial number 75, please. Any day next week.
75.
Second list.
ಆಯ್ತು, ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ.
He's there.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಹೇಳ್ಬಿಡಿ.
He's there. His colleague is there.
All right. At the request of counsel for the petitioner. Placed on 18th. ತೆಗಿದ್ಯಾ? ಅದೇ ಹೆಂಗ್ ಮಾಡ್ರ? ಸರಿ. ಹಾಗಾದ್ರೆ ಫ್ರೈಡೆ ಹಾಕಿ. 20th.
My lord, serial number 40 is that peculiar matter pertaining to 10 husbands.
We'll take it.
Yes.
Yes.
Serial number 58, my lord, LOC matter, my lord.
ಎಲ್ಲಿದೆ?
LOC matter.
ಅಲ್ಲ, ಶಾಂತಿಭೂಷಣ್ ಕರ್ಕೊಂಬನ್ನಿ.
4 o'clock.
As usual, 4 o'clock. Get ಶಾಂತಿಭೂಷಣ್. Yes. Okay. Yes, Girish, ತುಂಬಾ ಹೊತ್ತಾಗುತ್ತಾ?
Please, no, my lord.
ಹಾ.
Only very short matter. May I pass on, my lord, a very brief synopsis
ಕೊಡಿ.
in respect of all the 5 matters?
Who's opposing you?
My lord, there are additional SPP, my lord.
Oh, then it will take a long.
No, I have served a copy of this also. I think, my lord, he is now.
ಕೊಡಿ.
There are totally 5 matters connected. But in all of these matters, the first of the offences alleged is under section 171H.
171 matters.
Yes, that's what, my lord. I have annexed, my lord, 2 judgments with the petition and 2 more judgments with the synopsis. My lord, basically the allegations are.
Covered alva?
Alla.
Alva? Then we'll take it another day. When are you here back?
Today, my lord, I was here for only this matter. If I could, my lord, convince, taking only 5 minutes of my lord's time.
All right, I will hear you, yes.
Please, only, my lord, the synopsis may kindly be seen. What are the allegations? My lord? I have made it, my lord, criminal petition wise.
All right.
But in the first of the petitions,
171H, 192 MV Act.
MV Act, regarding use of, my lord, motor vehicles.
All right.
Yes, my lord, 2 backhoe loaders were used while canvassing for the purpose of showering the flowers. But there is no allegation in the, my lord, complaint that, my lord, it was belonging to me or at my instigation it was used. This is one thing. And even otherwise, it does not attract 171H because it pertains to, my lord, expenses and other things.
Bribery during.
Yes, as my lordships also have, my lord, held it. That judgment I also annexed. My lord, in the second of the petitions, my lord, the allegation is 2 bullock carts were used. Again, my lord, it is in respect of the same thing. While campaigning, 2 bullock carts were used without taking permission. In third of the petitions, my lord.
You won the election or not?
I have, my lord, I am a sitting MLA.
ಹೌದಾ?
Yes.
ಬುಲ್ಲಕ್ ಕಾರ್ಡ್ಸ್ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದೆ.
ಇಲ್ಲ, ಯಾರೋ ಕ್ಯಾಂಪೇನಿಂಗ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ತಗೊಂಡ್ಬಂದಿರ್ತಾರೆ.
ಬುಲ್ಲಕ್ ಕಾರ್ಡ್ ನೀವು ಕ್ಯಾಂಪೇನ್ ಮಾಡಿದ್ರೆ one or not. Yes.
In the third petition, again, my lord, allegation is 3 cars and 1 DJ setup. And only the difference is with respect to fourth, my lord, wherein 127A of RP Act is invoked. My lord, there, the allegation is that an article was published. But I'll make submission with regard to that, my lord, a little more later.
All right, come to the next petition.
And the next one is, my lord, again, 1 car and 1 backhoe loader were used. All of these 4 petitions, my lord, 171H cannot be attracted at all. My lord, I have annexed the judgment at page number 68 in the first of the petitions. My lords may kindly take page number 68.
Yes.
Criminal petition number 4524 of 2022. My lord Justice Sunit Dutt Yadav judgment.
1 minute.
Please. Paragraph number 2 is, my lord, with regard to what was the allegation therein. That, my lord, some motorcycles were used at the time of campaigning without taking permission. And what is held is in paragraph number 4, after taking note of column number 17. Thus, it is clear that the only offence made out in the charge sheet is section 171H of IPC. Section 171H of IPC is an offence that relates to illegal payments in connection with an election. The offence has made out.
Considered another matter.
That is the latest judgment along with synopsis I have produced, my lord, 1st August 2024. This is followed by my lords also. So therefore, all these 4 petitions, my lord, 171H cannot be attracted.
Merely because it's the opposite side, we need not.
No, not like that. The judgment which.
ಅಲ್ಲ, ಅದೊಂದು petition ಬಿಡಿ. Where there is other allegation.
127A is also.
Even Israel, the judgment is relying on it is with respect to not covered. Your lordship may I've taken independent opinion, but
All
that's
right.
covered.
Facts are a little bit different, my lord, but
The issue is there that it's been cost based on 155.
No, cost is 155.
Yes,
That is.
therefore it is not covered.
Ultimately, it went, narrate ಮಾಡಿದ್ರೂ ಅಲ್ಲೋ ಆಗಿರೋದು 155 ಮೇಲೆ.
155.
ಅಲ್ಲ, but taking note of
Then the second judgment which he relies on.
That is Vagepas.
ಅಲ್ಲ, with the synopsis I have produced two more judgments.
Those two judgments are 155 only.
155. So 155.
My lord's judgment dated 1st August 2024 is also concerning 171H.
But ultimately on 155.
ಹೌದು, ಸಿನಾಪ್ಸಿಸ್ ಜೊತೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ my lords may kindly. Considering the earlier judgment.
Following Justice
That's
Sunil
it.
Yadav.
Yes, that's what I was trying to make out.
It's all on 155. Therefore it is not covered.
ಅಲ್ಲ, Justice Sunil Yadav has gone on 155.
All these judgments are 155.
ಇಲ್ಲ, not
ಇಲ್ಲ ಇಲ್ಲ.
155 ಅಲ್ಲ.
ಬರೀ
171H is not attracted at the their quest.
Justice Sunil Dutt Yadav judgment, my lord, refers to 171H, but ultimately goes into 155.
ಅಲ್ಲ,
What I'm saying is, my lord, it's not covered under 155.
All
The
right.
merits may be the different.
No, I'm not at all saying it is covered under 155. I'm saying more regarding 171H.
No, 155 is not his submission.
It is my ancillary ground which I'm not going to urge in view of the recent development.
Sir, 171H for an offense to become 171H, 171B should be present. 171B has 5 clauses. In all those 5 clauses, ಎಲ್ಲಿ the bullock cart, JCB.
Loader ಅದೆಲ್ಲ.
ಏನಕ್ಕೆ JCB ಯಾಕೆ ತಗೊಂಡೋದ್ರಿ ನೀವು ಕ್ಯಾಂಪೇನ್ಗೆ?
ಅಲ್ಲ, JCB ತಗೊಂಡ್ ಬಂದು ಹಾರ ಹಾಕಿದಾರಂತೆ.
JCB ಇಂದ ಹಾರ.
ಅಲ್ಲ, ಅದು that's what more. If there was an allegation that ಯಾರ ನಮಗೆ ಹಾಕಿದಾರಂತೂ ಹೇಳಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
JCB ಇಲ್ಲಿ ಹಾರ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅಲ್ಲಿರ್ಬೇಕು.
ಹೂ ಎರಚಿದ್ದಾರೆ ಅಂತ ದಿ ಕಂಪ್ಲೇಂಟ್ ಲಿಟರಲಿ ಸೇಸ್ ಹೂ ಎರಚಿದ್ದಾರೆ, ನಾಟ್ ಹಾರ.
JCB ಇಂದ.
ಅದ್ರ ಮೇಲೆ ನಿಂತ್ಕೊಂಡು ಹೂ ಎರಚು.
bullock cart ಮೇಲೆ ನಿಂತ್ಕೊಂಡು
ಅದೇನೋ
ಏನ್ ಮಾಡಿಲ್ವಾ?
These 4 matters, those are the allegations. And 192A of MEC Act.
What are your submissions? Tell me.
No, that is my submission. Not covered.
I'm not on 155 at all.
I leave it.
155, I think, has been complied in all these
Yes, complied.
cases. Generally, when election offenses happen, 155 is complied.
Here, my lord, of
Other
course,
cases ಅಲ್ಲಿ ಮಾಡುತ್ತೆ.
at the time of filing,
Because magistrates are a little careful in writing.
no, but in this also, it is the SHO who has approached, not the informant. Informant is
But
electoral
tell me.
officer, but I'm not urging that. I urge at the time of filing this petition, but not at this time.
That time not going to.
Yes.
I'm not going to accept.
No, I'm not going to urge also after hearing my senior's argument little while ago.
Now, all these petitions were, that is the ground they urged.
ಅಲ್ಲ ಇದೆ. That was the ground even I have permitted
Yes,
earlier.
sir. No, even
Then
when arguing,
Gopal Krishna ಯಾವ್ದೋ ಕೊಟ್ರಲ್ಲ. Little difficult.
and even arguing with the coordinate bench, their contention is that Viresh Pillai is wrongly.
That is what he admits that.
Yeah, that's,
That the submission is recorded also.
all these judgments are coming out of, not on merits, because
Victim justice will not forget. Yes. Well, these 4 will close. Madam, ಇದು ಕೊಡಿ, 4 ಕೊಡಿ. ಅದೊಂದು ಬಿಟ್ಟು, ಅದೊಂದನ್ನ ಅಡ್ಜನ್ ಮಾಡ್ತೀನಿ, 4 ಕ್ಲೋಸ್.
Do one day point is if my lord's permit, I'll just.
ಮತ್ತೆ ಬರಲ್ಲ ಬೆಂಗಳೂರಿಗೆ.
My lord's seen I always appeared on VC. ಅದಕ್ಕೆ ಇವತ್ತು ಎಲ್ಲ ಬಂದಿತ್ತು ಅಂತ ಹೇಳಿ.
I was surprised Girish is here. Yes.
I'm pleased, my lord, to be here. But I have culled out section 127A in my petition. My lords may kindly see.
ಈಗ petition by petition we will go.
Yes.
First petition ಯಾವುದು?
12344 of 2023.
1 minute. 12344.
Yes. 2 backhoe loaders were used for showering flowers.
1 2 3 4. The petitioners. ಏನಿಬ್ರಿದ್ದಾರೆ?
Second petitioner is the person who obtained permission for murder campaigning.
ಅಲ್ಲ, accused number 2 ನದು?
Yes, yes, yes.
You have not described him, so. ಎರಡು accused number 1 ಅಂತಾನೆ ಇದೆ. Yes. The petitioners are accused 1 and 2. The first petitioner is a member of the Legislative Assembly today. The issue relates to today. They are knocking at the doors of this court, calling in question proceedings in CC 1246 of 2023, registered for offences punishable under section 171H and 192A of the 171H of the IPC and 192A of the Indian Motor Vehicles Act. Heard so and so. Facts in brief germane are as follows. The second respondent is the complainant, who at the relevant point in time was appointed as an election flying squad. It is the complaint of the second respondent that on 28/4/2023, when they were patrolling, patrolling along with other officials at Kavatgi village at 7:30 PM, noticed the accused number 1, who was the candidate for who was contesting to the Legislative Assembly, was using an earth mower and something else it is.
Backhoe loader.
Huh?
Backhoe loader.
Backhoe
So
loader.
Technical name is backhoe loader.
Using a backhoe loader within bracket JCB for showering flowers during election campaign at the government school Kavatgi. This was alleged to have been done without the permission of the election officer and in violation of the rules of election. Therefore, the crime comes to be registered by the second respondent after obtaining appropriate permission of the learned magistrate for offences punishable under section 171H and 192A of the IMV. The police, after investigation, have filed a charge sheet against these petitioners for the aforesaid offences. Filing of the charge sheet has driven these petitioners to this court in the subject petition. The learned counsel appearing for the The learned counsel appearing for the petitioner Girish Edward would submit that the offences so alleged the ingredients of the offence so alleged are not even met to its semblance in the facts of the case at hand. The allegation is 171H. The learned counsel would submit 171H does not even get attracted in the case at hand. The further submission, you are not, that's the only submission.
I would not urge that.
Yes, so and so. The learned additional SPP would refute the submission to contend that the petitioner was using the backhoe loader, i.e. the JCB, for the purpose of election, for the purpose of campaign at the time when code of conduct was not yet in operation. It had not yet come into effect. It was 30th March. ಮತ್ತೆ 24/3 ಏನ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ not even an offense. Yes, was
with respect to 3 and 4, they are not before this court. Against them, my lord, that they use this JCB without having a number plates and other thing. That your lordship can save.
3 and 4. The learned counsel appearing for the petitioner, the learned additional SPP would however refute the submission to contend that the petitioners were using these vehicles in violation of the election rules during the period of code of conduct without taking permission of the election officer. He would submit that in the other 2 companion petitions, the backhoe loaders did not even have a number plate.
ಇದರಲ್ಲಿ accused number 3 and 4. This
ಇದರಲ್ಲಿ
petition,
ಅದು ಬೇರೆ petition ಇದೆಯಾ?
ಇಲ್ಲ ಅವ್ರು ಬಂದಿಲ್ಲ.
ಇದರಲ್ಲಿ ಎಲ್ಲಿದೆ?
They are the
3 and 4 ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇಲ್ಲ, they are not before my lords.
So and so.
ಅಲ್ಲ ಇದು
ಇಲ್ಲಿ
28
ಹೇಳ್ಬಿಟ್ರೆ ಒಳ್ಳೇದು.
ಹೌದು 28/4 ಮೇಲೆ ಎಲೆಕ್ಷನ್ ಕೋಡ್ ಅದು ಎಕ್ಸಿಸ್ಟ್
ಇದೆ ಗೊತ್ತಾಯ್ತು. 28/3 ಅಲ್ಲ 4. That's why I corrected mine. Yes. So and so. The learned additional SPP would further contend that the accused 3 and 4 who are not before the court were using the vehicles without the number plates. So all these would constitute an offense, and the police and the respondents have appropriately filed a charge sheet. It is for the petitioners or the other accused to come out clean in a full-blown trial is his submission. I have given my so and so. The aforenarrated facts are not in dispute. The issue lies in a narrow compass. The incident as narrated in the complaint, the entire issue has now triggered on the complaint so registered by the second respondent. The complaint reads as follows, page 11. The complaint alleges that JCB was used to get shards, the flowers showered upon the accused number one, the candidate for the assembly elections at that point in time, and this was done without the permission of the election officer. Broadly, this is the complaint so registered. The police, after investigation, have filed a charge sheet against these petitioners and other accused. Column 17 as obtaining the summary of the charge sheet as obtaining in column number 17 reads as follows, page 21. A perusal at the complaint or the summary of the charge sheet, it now becomes necessary to consider whether the complaint or the summary of the charge sheet would make out an offense under section 171H of the IPC. Section 171H reads as follows. For an offense to become, an act to become an offense under section 171H of the IPC, the ingredients of section 171B is necessarily to be present, correct, Tanel?
Yes, ma'am.
We'll also look. 171H, ala? Illegal payments with an election, whoever commits an offense. B is bribery, adbada. 171H reads as follows, Tamadi. One 171H deals with illegal payments in connection with an election. The allegation is not that the petitioners indulged in any illegal payments being made. It is the usage of vehicles aforesaid for the purpose of showering of flowers. ಯಾಕೆ ಹಿಂಗ ಹಾಕಿದ್ರೆ ಆಗ್ತಾ ಇರಲಿಲ್ವಾ?
ಅಲ್ಲ ಅದು ನಮ್ಮ ಮೇಲೆ ಹಾಕಿದಾರಂತೂ ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್.
For the purpose of showering of flowers in the campaign for election. The usage of vehicles is what is now become the bone of contention. As observed here and above, section 171H has certain ingredients of distribution of money during the election campaign. That is not the complaint, that is not this, that is not the charge laid against the petitioners, nor the ingredients of the section 171H is met even to its remotest sense in the case at hand. In that light, permitting further proceedings against this petitioner, again, these petitioners for the aforesaid offences would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, a Lord quashed quay these petitioners.
Only other submission would be regarding 192A. That is also
The
invoked.
other one is the
Reason is, my lord, that petitioners are not alleged to.
The reason so rendered. 192A ನಿಮಗೂ ಏನು ಸಂಬಂಧ?
ಅದಕ್ಕೆ that's what I am submitting. my lord. Vehicle does not belong to me, so it cannot be invoked. Is my
The
submission.
other offense that is alleged against these petitioners is section 192, offense under section 192A of the Act. It is an admitted fact that the vehicles did not belong to these petitioners, but to accused 3 and 4 who are alleged to have used the vehicles without number plates. Therefore, it is for those petitioners to answer the said charge and not these petitioners. In that light, for the aforesaid reasons, the following allowed quashed. Next year.
Next, my lord, only 171H, my lord, 12967 of 23.
Same reason.
Same reason, but only the one bullock cart with 2 bullocks are used anta. That is ಅಲ್ಲಿ
One bullock cart with 2 bullocks.
Yes.
ಅದಕ್ಕೂ ನಂಬರ್ ಪ್ಲೇಟ್ ಇರ್ಲಿಲ್ವಾ?
I am acting.
ಅದನ್ನು ಹೇಳಿರ್ತೀರಾ ನೀವು ಅಂತ ಕೇಳಿದೆ. ಎಸ್.
But ಇದರಲ್ಲಿ I am act invoke ಮಾಡಲಿಲ್ಲ.
IMV Act ಇದಕ್ಕೆ ಮಾಡಲಿಲ್ಲ. ಎಸ್.
And my lord, in the third petition, my lord,
ಒಂದು ನಿಮಿಷ. We'll say for the reasons rendered. ಅದು 171H ಅಲ್ವಾ?
only 171H.
All right. The 12967. The petition, ಅದರಲ್ಲಿ ಇಬ್ರೇನಾ?
ಇದರಲ್ಲಿ my lord, only the petitioner is the only my lord.
The petitioner is before this court calling in question proceedings in CC so and so registered for offense punishable under section 171H of the IPC. The facts in the case at hand would revolve round the usage of a bullock cart with 2 bullocks without the permission of the election officer during the campaign for the elections, then ensuing for the Legislative Assembly of the state of Karnataka. for the reasons so rendered in criminal petition 12344 of 2023, qua the offence under section 171H, the subject petition also deserves to succeed.
Here, my lords may say at the time of filing nomination. Allegation is at the time of filing nomination, that was
Bullock card nomination lo
file ಮಾಡ್ಬೇಕಾದ್ರೆ ತಗೊಂಡು
time correct ಆಗಿ ಹೋದ್ರ? Yes. So and so. The at different time during campaign alla, at the time of filing of nomination. So and so. For the reason so rendered, allowed cost. Next ಯಾವುದು?
12990, my lords.
ಅದರಲ್ಲಿ ಏನು?
ಅದರಲ್ಲಿ again only the petitioner accused number 1 murder.
Used a DJ na?
3 cars and a DJ was set up without permission.
Oh. Diesel generator.
Music murder.
Music DJ.
DJ ಅದು. ಅವ್ರು 3 ಜನನ accused ಮಾಡಿದ್ದಾರೆ. They are the remaining accused.
ಇದು violation of election rules. What music DJ? Yes. Same reason. For the reasons so rendered, so and so. Entertainment. Entertainment without permission. Same order, madam.
The last one is 2769 of 24.
Idal Hyundai Creta na?
Yes, Creta and
one JCB.
One JCB.
Idiyaniki idu flowers ah?
Alla.
Oh, procession to Tahsildar's office.
Yes, at the time of nomination.
Same reason. The petitioners are, idu obrena?
Obre petition.
The petitioner is before this court so and so only for challenging the offence punishable under so and so. For the reasons rendered in 12344 of 23, the subject petition also deserves to succeed. For same order. Adonde namal marana.
Only allegation is that, Marad, if I may just, I'll take only 1 minute, not more than that. Allegation is that, Marad, there are 3 petitioners. The petitioner number 1 is the editor. His name was mentioned, Marad, in the pamphlet, which contained an article about the petitioner number 3, that is the sitting MLA. And petitioner number 2, that is accused number 2, Marad, he was also present, Marad. He
interim order ideyalla?
Interim order is there. It would not attract 127A at all. That's the only submission. There, Marad, I have called out 127A. Please, I'm grateful.
Yes. ಅದು 125 ಲಿಸ್ಟ್ ಮಾಡಿ. ಒಂದು ನಿಮಿಷ ಅದೊಂದು ಮಾತ್ರ ಡಿಟ್ಯಾಗ್ ಮಾಡಿ. ಒಂದು ನಿಮಿಷ ಯಾವ್ದು ಗಿರೀಶ್ ಅದು?
Please, it is 13025.
27.3 ಫಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್. ಡೀಲಿಂಗ್ 27.3 ಅಂತ ಮಾಡಿ. ಡೀಲಿಂಗ್ 27.3 ಲಿಸ್ಟ್ 8 on 19th September. Interim order subsisting shall continue to the next date of hearing. A separate order sheet ಮಾಡಿ. ಮಿಕ್ಕಿದ 4 ಡಿಸ್ಪೋಸ್.
Please, I'm grateful.
Not the offense under 188 of
198.
188
188
of APC balance. Complaint is at annexure A.
ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್
State. Sorry.
ಸ್ಟೇಟ್ ಅಲ್ಲ,
Election officer.
ಅಷ್ಟೇ ಎಲೆಕ್ಷನ್ ಆಫೀಸರ್. Registered to print the name of the additional SPP as appearing for the second respondent.
Yes.
Not
the allegations in the complaint do not attract Mallards 188. Page 7 is the complaint. Under 200 CRPC filed before Mallards, the JMFC Gadak.
ಏನ್ ಗಲಾಟೆ ಮಾಡಿದ್ರಿ ನೀವು?
Mallards, some statement which is at annexure A, page 7.
ಇದು 188
ಎಲೆಕ್ಷನ್ ಕೋಡ್ ನ ವೈಲೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಎಲೆಕ್ಷನ್ ಟೈಮ್.
Because the second portion of the allegation.
Not taken a cognizance of the content, they have taken a cognizance of the time.
Some discussion went on for reservation, granting
on the television channel.
On a 2A Mallards for a community, then during that Mallards, yes. 188 Mallards may not attract.
Offense 188 ಒಂದೇನಾ?
ಹೌದು.
Page 23 is the order of the learned magistrate.
ಅದ್ಬಿಡಿ ಕಾಗ್ನಿಸೆನ್ಸ್ ಎಲ್ಲ ತಗೊಂಡಿರ್ತಾರೆ. Model code of conduct violation 188 ಗೆ ಏನು ಸಂಬಂಧ?
No, it does becomes an offense.
What offense, sir?
They violated the
What order?
promulgation of code of conduct.
So that is the order and promulgation.
Well, let's kindly see 188 for a moment.
Disobedience to order.
Yes. Well, let's, whoever knowing that by an order promulgated by a public servant lawfully empowered to promulgate such order, he is directed to abstain from certain act or take certain order with certain property in his possession or under his management, disobeys such direction, shall, if such disobedience causes or tend to cause obstruction or annoyance. Lord, the second portion of the allegation is absent in the private complaint.
Certain or under management disobeys such direction.
Yes, shall. Lord, it becomes an offense only if
Disobedience causes or tends to cause
obstruction, annoyance or injury or risk of obstruction, annoyance or injury to the person lawfully employed shall be punishable with so and so.
Yes, sir.
So allegations do not indicate that.
ಯಾವ frivolous ಹಾಕೊಂಡು.
That is why I said, Mala, they should have taken a copy.
It clogs the criminal justice system. Left, right, center ಸುಮ್ಮನೆ ಇದಕ್ಕೆ ಹಾಕೊಂಡು.
That is why I said they should have taken cognizance for the content, not the timing, if at all they wanted to take.
Correct. Timing ಮಾತ್ರ ಇದೆಲ್ಲ. Heard the petitioner is before this court calling in question proceedings in CC 573 of 2023, registered for offences punishable under section 188 of the IPC. The heard so and so. The petitioner was a candidate contesting which constituency, sir?
Not say. He was campaigning for.
He was campaigning, he was not
The
contesting.
petitioner was campaigning for a candidate who was contesting for the Legislative Assembly elections at Gadag. It transpires that the second respondent, the flying squad, found that the petitioner, along with the party candidate who was contesting in the constituency, during the campaigning process was interviewed and was videographed, in which he had made certain statements which, according to the complaint, would become an offense under section 188 of the 188 of the IPC. The police, after investigation,
No.
It's a private complaint.
private complaint, sorry, yes.
Next year,
So and so, respondent yaru ಮತ್ತೆ? Garuda?
the complaint, flying squad, the
Flying
government.
So and so. The concerned court takes cognizance of the offence by its order dated 11/5/2023 and issues summons to the petitioner. It is the petitioner claiming to be, petitioner being aggrieved by the said order of taking of cognizance and issuance summons is before this court in the subject petition. Learned counsel Venkatesh Dalwai would submit that that a perusal at the complaint or the order of taking of cognizance nowhere would meet the ingredients of section 188 of the IPC. And he would, 188 of this, and therefore would seek quashment of the entire proceedings pending before the concerned court for the aforesaid offence. ನೀವೇ ಹೇಳ್ಬೇಕು, ನಿಮ್ದೇ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇ. ನೋಟಿಸ್ ತೊಗೊಳಂಗಿಲ್ವ? Because they are served. The respondent flying squad who had registered the complaint remains served, those served remains
Direction for me to
unrepresented.
take. There's a direction for me to take notice.
ಇದೆಯಾ already?
Yes, Mala. 12/1/2020.
Then ಹಿಂಗ್ ಮಾಡಿ. ಇಲ್ಲ
12/1/2020.
12/1.
Notice ಮಾಡಿ.
ಇದೆ.
12/1. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಇದೆ ಅಷ್ಟೇ. Whether the code of conduct answers 188, we will not get into that. Yes. So and so.
Even then, my lord, it's not that he's done anything physically, it is that in a TV interview which is given in this case. Which is not-
Obstruction ಎಲ್ಲ ಆಗಿದೆ.
That is what,
That's what ingredients are not met, and whether 324
yes.
code of conduct and the constitution would,
That was the question framed, my lords, by the.
I saw that. Yes. That's why I said we'll not get into that. Don't. ಏನಿಲ್ಲ ಮೇಡಮ್ ಕೊನೆಗೆ. So and so. The learned additional SPP would submit that the issue would be whether a code of conduct notified under Article 324 of the Constitution of India would become applicable to an offense under Section 188, which would be disobedience to an order duly promulgated by a public servant. He would submit that these are matters which are required. The petitioner is guilty of the offense and would require him to be come out clean in a full-blown trial. He would seek dismissal of the petition. The aforementioned narrated facts are not in dispute. The issue that led to registration of the complaint, the entire issue has now triggered from the registration of the complaint. The complaint so registered by the respondent reads as follows. Page 7 and 8. The concerned court takes cognizance of the offense and issues summons to the petitioner. The order of taking of cognizance reads as follows. Page 23-25. The offense for which cognizance is taken and summons issued is the one punishable under Section 188 of the IPC. Section 188 of the IPC reads as follows. Section 188 of the IPC does not stop at disobedience to order duly promulgated by a public servant, the consequence of which forms the soul of the provision. It mandates that such disobedience should cause obstruction, annoyance, injury, risk or injury to any person lawfully employed, or it must tend to cause danger to human life or right or affray. None of these things have happened in the case at hand, as it is an interview in the given to the television channel is what is made the subject matter of the complaint. The risk of obstruction, disobedience of an order that causes obstruction cannot even be imagined in the case at hand. Therefore, the charge against the petitioner.
Explanation. Explanation, 188 explanation. Correct.
He has not disobeyed any order here.
He knows that his conduct may be.
No, that's only when the first two ingredients are complete.
We'll see
Complaint
the
itself do
explanation
not
later.
indicate that.
Yes,
It is
so and
not
so.
my intention.
ಆಮೇಲೆ ಅದನ್ನ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಯೂಸ್ ಮಾಡಿದಾಗ ತೊಂದರೆ
That
ಆಗಬಾರ್ದು
is the
ಅಂತ
reason.
ಅಷ್ಟೇ. Yes, so and so. Though the explanation would indicate that it is not necessary for the offender should intend to produce harm or contemplate or disobedience would likely result in some harm. It is sufficient that he knows of the order which he disobeys is likely to produce harm. A perusal at the complaint or the summary of the charge sheet would not meet even the explanation in the case at hand. In that light, the permitting further proceedings where the petitioner would become an abuse of the process of the law and result in miscarriage of justice. Yes, for the aforesaid reasons. Next.
Offense under 171B and 171E of IPC and 123(1) of RP Act. Here, my lord, based on a requisition without a complaint, requisition is by the respondent too. the head of flying squad. Straight away requisition is given to the magistrate, which is at page 22.
Is that not in the nature of a complaint? Not complaint under the CRPC, but
Yes, but going by, my lord, your lordship's dictum, those 5 guidelines in Vijesh Pillai, it will not meet the requirement. Because this is not a information to the
Magistrate.
to the police.
yes, ma'am, to the police.
Yes, it's not in the form of an information, it's
ಯಾವ ನಿವೇದನೆ ಅಂತಿರೋದು ಇದ page
yes,
22.
page 22.
Yes, Jagdish.
ಅಲ್ಲ ಇದರಲ್ಲಿ
And an NCR has been, if I may take one more minute, my lord. NCR is at page 22. I'm sorry, page 24. NCR is dated 12/5/23.
ಇದರಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ himself has gone to court.
ಅದೇ.
It meets Murthy sir's. Yes.
But without a complaint.
That given to the police station, police has issued an NCR.
NCR. So he goes before the magistrate.
Straight away.
Interim order ಇದೆಯಲ್ಲ, we'll decide it.
Interim order is there. Because, my lord, the allegations are also vague. The complainant says he receives a video post on his phone, mobile phone, on 12/5/2023. After the election was over on 10/5/2023, saying that, my lord, the video, the contents of the video was that the petitioner, someone like the petitioner, was seen distributing money. Very vague.
It would not meet the ingredients. Next week, ಮುಗ್ಸೋಣ ಇದು. Heard the learned senior counsel Murthy D. Nayak appearing for the petitioner and the additional SPP. 31 ಅಲ್ಲ ಇದು?
30.
30.
Yes.
31 is the same?
Same.
31 is different, 171E.
All right, yes. List on 30th.
30, my lord.
30. Next week.
Grateful.
ಅದು ಅಷ್ಟೇ. Interim order subsisting shall continue. 31 interim order ಇದೆಯಲ್ಲ, ಅದು ಅವತ್ತೇ ಮಾಡು. Yes. 32.
My lord, in this case, my lord, is based on a banner, publishing the banner in 2022, 2020, an NCR has been filed. Later, after immediately the very next day after the NCR, the police sub-inspector himself, he approaches the magistrate and seeks the permission for investigation. It's a non-cognizable offense, my lord.
So
Why not? So in a similar set of facts, my lord, your lordship has clashed the same.
ಎಲ್ಲ ಇದಲ್ಲ ಅದೇ.
And here, my lord, here.
Interpretation of Vijesh Pillai ಆಗೋಗಿದೆ.
My lord, here ದೌರ್ಜನ್ಯದ ಮೂಲಕ ತೆಂಗಿನ ಸಸಿಗಳನ್ನು ಕೀಳಿಸಿ ಹೆಣ್ಣು ಮಕ್ಕಳ ಮೇಲೆ ಲಾಠಿ ಚಾರ್ಜ್ ಮಾಡಿಸಿದಂತಹ ಅಂತ ಹೇಳಿ ಒಂದು ಬ್ಯಾನರ್ ಅನ್ನ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. Even the banner or no handbills are seized. Nothing is being produced, my lord.
We'll take it next week. Yes. 5th, 30th, same. List on 30th. Venkatesh sir, ಇದು next week ತಗೋಣ. Second list ಇದೆ ಇನ್ನು.
Directed to verify if there is an order for
ಏನ್ permission?
155(2).
Permission ಇಲ್ವಾ?
Mention ಆಗಿದೆ, but
There is separate order chief.
separate order produce ಆಯ್ತು.
List on 30th. Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order continue ಮಾಡ್ಬಿಡಿ.
One place disfigurement.
Interim order ಇದೆಯಾ? 30. List on 30th. Interim order subsisting will continue. That day we will dispose another time. Yes.
Endorsement is seen. 155(2). The
Seen.
order of the magistrate is
Then
seen.
it should go asked.
My lord, page 15, document number 2.
Covered by Vijesh Pillai again.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅನುಮತಿ ಪಡೆದು ಅಂತ
Separate order ಇದೆಯಾ?
ಅದನ್ನ ಚೆಕ್ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲಿ ಮೇಲೆ
ಮಾಡಿ.
page 12, page 15, seal of the learned magistrate. ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಇತ್ತು.
ಓ ಸೀನ್ ಅಂತ ಸೀಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದಾರಾ?
ಅಲ್ಲ ಅಲ್ಲ.
ಅದು ಬರೆಯೋದು ಕಷ್ಟ. ಸೀನ್ ಅಂತ ಸೀಲ್. Crime permitted. Good idea. 30th. Separate order ಇದೆಯಾ ನೋಡಿ ಇದ್ರಲ್ಲಿ.
Verify ಮಾಡಿ.
Here for the petitioner, my lord. There's
Yes,
an
madam.
interim order subsisting offences under 499,500.
Offense under
499,500 of IPC.
498A ಅಂದಂಗ 99. Defamation.
Yes, my lord. It's
Yes.
a counter blast complaint.
All right. One sec. List on 30th.
My lord, if I may pray for the fifth, my lord.
First, oh, you have something. When do you want?
Fifth, my lord.
All right, 5th.
Grateful,
Yes.
my lord.
Interim order subsisting shall continue to the next date of hearing.
Going for the petitioner with the-
Awaiting police report. Who is second respondent?
A flying squad members.
ತಗೊಳ್ತದ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಅದರಲ್ಲಿ ಶರತ್ ದೊಡ್ಡ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. Counsel with the petitioner
ವಾಲಂಟರಿ ಆಗಿ ಬಂದಿದ್ರು.
to serve on Sharad Dodwad for the second respondent. Forthwith, list the matter on 5th, interim order subsisting shall continue to the next date of hearing.
Grateful, my lord.
Yes.
The petitioners in the connected matter. In this case, when the interim order was granted, it was subject to disposal of an SLP.
what
Parties were
has
directed
happened?
to move the matters after SLP was
SLP dispose ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಇನ್ನ pending. On 9th August, it was listed, my lord. Post that it has been directed
In which petition is that order?
in the connected matters.
ಅದು ಕೊಡಿ ಮೇಡಮ್. ಅದೇನ ಕೊಟ್ಟಿರೋದು?
2771.
Coordinate bench rejected the petitions filed by the certain petitioners by imposing a
stay
cost.
ಇದೆಯಲ್ಲ.
Then the petitioners therein went to Supreme Court and proceedings are now stayed.
ಹಾ.
So quoting that, my lord, the coordinate bench granted stay, my lords, in these matters.
Yes.
Directed the office to post it after disposal of.
We will post it after 8 weeks. This court on 22/3/2024 had passed the following order. The parties were directed to move the matter after the outcome of the SLP noted in the aforesaid order. The SLP is still pending consideration before, at the hands of the apex court. In that light, they list this matter after 8 weeks. Interim order subsisting shall continue till the next date of hearing.
All three.
Yes. ಎರಡರಲ್ಲೂ ಮಾಡಿ.
Petitioner. Kindly seek for adjournment. 1 week. 1 week of adjournment.
2 weeks of adjournment.
1 week, 1 week.
ಒಂದೇ week ಸಾಕಾ? What interim order is there?
Interim order results.
September, interim order continues till the next date. Yes. What Rakshit?
Lords, kindly see the impugned order, my lords, the order, my lord, assigning, my lord, or giving an approval to investigation lacks jurisdiction by the magistrate.
Special court,
Special court. Magistrate has passed an order.
Can be remanded back to the.
ಅದೇ ಎಲ್ಲ will together do that. Yes. List on 12th, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing.
But notice has to be issued to R2.
One additional SPP, 2 emergent notice, returnable by 12th. ಅದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ 12th ಅಂತ ಮಾಡಿ. Next. 44 ಯಾಕೆ adjournment ತಗೊಂಡ್ರಿ?
ಅವರು ಅದರ್ ಸೈಡ್.
Interim order ಇದೆಯಾ?
ಇದೆ interim order. But the interim order may be extended.
Huh?
Interim order may be extended.
That will be
They
extended.
sought time at 1:30.
Yes.
Forty-five.
45 adjourn ಆಗಿದೆ.
45.
Revision petition.
Yes.
ಅದನ್ನ ಇನ್ನೊಂದಿನ ಕೇಳೋಣ. List on 19 September.
Synopsis, last
ಹಾಕಿದ್ದೀರಾ?
time ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು.
I have informed Shilwant also to appear.
Last time he has not appeared.
ಹೌದು.
Yes.
Lordship, still about 45, I'm appearing.
Onti ಅವರೇ. Last time you had not appeared.
Please, Lordship.
Huh?
I'm apology, Lordship. I was held up in other.
ಆಯ್ತು 19th. 19th. Yes. Next.
Please, oblige.
Oh, this matter. Jurisdiction.
171.
Well, I have granted stay on the question of jurisdiction.
Even on merits, my lord. Covered matter, no ingredients are made out.
No, this is where 4 crores are found.
Undue influence.
Found in your,
Our upload, then we have explained for the income tax department.
Not in my possession. Nothing, I had nothing to do with it.
that we'll see. Yes,
And
not
undue
in your
influence,
possession.
this undue influence, it is not there. Undue influence, your lordship has said, it should be to a voter. Bribery also to be a voter.
Yes. We'll hear it on 12th and close it.
Please.
Heard the learned senior counsel B.V. Acharya appearing for the petitioner. List this matter on 12th.
My
Interim
friend-
order, interim order subsisting shall continue till the next date of.
My friend will take notice for R2 also, my lord.
R2 flying
Also a
squad.
government servant.
Learned additional SPP is directed to accept notice for the second respondent registry to print the name of so additional SPP for second respondent as well. ಆಮೇಲೆ
Please,
interim order.
please.
Same order ಅದರಲ್ಲೂ.
Please.
They go hand in hand.
Mhm.
Not hand in glove.
Not in,
Not hand in glove though. Same. Oh, 47 ಬೇರೆ, sorry.
47 is connected.
47,
same.
sir, appear ಆಗಿದೆ 47, yes. Same 46, 47.
Last occasion, please, my lord. Clarification was sought, please, my lords. As to know whether, my lords, these petitioners were the directors for the first time. I filed a memo, please, my lords.
Huh.
So we copy on the other side also.
ಎಲ್ಲಿದೆ ಮೆಮೊ?
Please, my lords, I had filed it.
ಎಸ್ ಸರ್, ಅದು ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಿ.
Yes, my lord, he verified that the very same petitioners have threatened the second respondent when he had approached to return the deposit after its maturity. You lordship may kindly turn to page 75. At page 77 of the petition,
ಹಾ,
last paragraph. ಆದ್ದರಿಂದ ನನಗೆ ನನ್ನ ಹೆಂಡತಿ ಹಾಗೂ ನನ್ನಂತೆಯೇ ಮೇಲ್ಕಂಡವರಿಗೆ ಹಾಗೂ ಇತರರಿಗೆ ಕುರುಹಿನ ಶೆಟ್ಟಿ ಸೌಹಾರ್ದ ಕ್ರೆಡಿಟ್ ಕೋಆಪರೇಟಿವ್ ಲಿಮಿಟೆಡ್ನಲ್ಲಿ ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ಹಣವನ್ನು FD ಇರಿಸಿಕೊಂಡು ಅವಧಿ ಮುಗಿದರೂ ನಮ್ಮ ಠೇವಣಿ ಹಣವನ್ನು ನಮಗೆ ಹಿಂದಿರುಗಿಸದೆ ನಮಗೆ ಮೋಸ ಮಾಡಿ ಕೇಳಲು ಹೋದರೆ ಪ್ರಾಣ ಬೆದರಿಕೆಯನ್ನು ಹಾಕುತ್ತಾ ಸುಮಾರು 90 ಕೋಟಿಗೂ ಹೆಚ್ಚಿನ ಅಕ್ರಮವೆಸಗಿರುವ ಕುರುಹಿನ ಶೆಟ್ಟಿ ಸೌಹಾರ್ದ ಕ್ರೆಡಿಟ್ ಕೋಆಪರೇಟಿವ್ ಲಿಮಿಟೆಡ್ನ ಅಧ್ಯಕ್ಷರಾದ BL ಶ್ರೀನಿವಾಸ್, ಉಪಾಧ್ಯಕ್ಷರಾದ ಪ್ರಭಾ, CEO ನಂದಕುಮಾರಿ, ಡೈರೆಕ್ಟರ್ಗಳಾದ ನರಸಿಂಹ ಶೆಟ್ಟಿ, ಆದಿಲಕ್ಷ್ಮಿ, ಕಿಶೋರ್ ಕುಮಾರ್, ಕುಮಾರ್, ಚನ್ನಕೇಶವ,
how do you say that you are not at all,
petitioners.
Lords,
how do you say you are not involved in the affairs of the society?
no, the other day, please, my lord, my lord was pleased to point out a particular question, please, my lord. As to whether, my lord, they were the first time of, because, my lords, when the FDs were taken or the deposits were made, please, my lord, they were not earlier period. It is their allegation that, my lord, we did not return the amount. The Savarda has not returned the amount. And when the, my lords, all these petitioners went, my lord, the complainants went, and, my lords, it is allegation that all these petitioners, please, my lord, and other accused persons said in one single word that, my lord, they threatened them. Excepting that,
Okay,
please, my lords,
What is the stage of the proceeding now?
the investigation is pending, please, my lords.
Let it go on. Yes. List the matter on 18th September. Yes.
But till such time, please, my lords,
On
please.
people's money.
Please, my lords, it is not the relegation, my lord. We have taken a single rupee, please, my lord, or misappropriated a single amount, single rupee.
We'll see, we'll see.
That is the allegation, please. Against others, but not against these people.
We'll see.
Please.
For respondents.
Bharat Kumar, you're sleeping.
Based on the complaint of my lords.
You're sleeping and want to submit?
I'm sorry, my lords, I didn't see the cameras.
All right, yes.
Based on the complaint of the chief regional manager, my lords, I have, this FIR came to be registered, my lords. My lords, the act is, my lords, the manager.
Lots, we have communicated with the office. His application for pardon would be considered the next week before Thursday an order would come. Most likely in the affirmative, so.
My lords, till then. my
Wait,
lords-
sir. You should learn patience, wait. ನೀವು ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದೇ ಟೋನ್, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದೇ ಟೋನ್.
I
ಸ್ವಲ್ಪ ಏರಿಳಿತಗಳಿರ್ಬೇಕು.
I apologize.
Yes. This court on 20th August 2024 had passed the following order. The learned counsel Rahul Reddy on instructions would submit that the application of the petition would be considered in a week's time. Yes. In the light of the order that is already passed on 28/2024, further proceedings where the petitioner shall remain stayed till the order would be communicated to the petitioner.
Great.
ಅದಕ್ಕೆ urgency. Yes, sir.
Right.
Yes.
My lordship, the stage is evidence stage, my lordship. Charges are framed on 6/8/22 itself. my
Last time there was a direction whether regarding framing of charges, my lords. Already framed. Please.
Correct.
Please.
Madam Meenakshi Bala.
Abhilay.
Dispose.
This is committed to the sessions court, my lordship.
Huh?
Hearing before charge ಇದೆ ಇದು 306.
306.
It's
Charges
already
were not
committed, my
framed.
lordship.
ಪ್ರೇಮ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ ನಿಮ್ಗೆ?
The death note has been sent to the FSL verification, my lordship.
ಮತ್ತೆ ಚಾರ್ಜಿಂಗ್ ಫ್ರೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ವಿತೌಟ್ ದಟ್.
Committed ಆಗಿದೆ ಅಷ್ಟೇ. Charges not at frame.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವೇ? ಡೆತ್ ನೋಟ್ ಇಲ್ಲ.
Death note has sent to FSL.
ಕಾಪಿ
examiner.
ಇಲ್ವಾ?
Copy ಇಟ್ಕೊಂಡಿಲ್ಲ, my lordship.
Death note ಇವ್ರದಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ?
The brother of the petitioner number 1, even he committed suicide. ಅವಂದು ಡೆತ್ ನೋಟ್ ಇದೆ.
Who is the complainant? Who commits suicide?
The
One Venkatesh, is it?
Venkatesh,
Ah.
who is brother of petitioner number 1,
Who else committed suicide?
wife of Venkatesh. After the Venkatesh commits suicide,
Oh,
when
wife
the
of
news was
Venkatesh.
given to the wife, she committed suicide. She attempted to suicide on 10/8/2022 and she was hospitalized on till on 28/2022 she died, madam.
Now, you are accused of whose suicide? Husband or the wife?
Accused number 1 and 2.
The abetment to suicide ಯಾರ ಮೇಲೆ?
ಇವ್ರಿಬ್ರು ಮೇಲೂ ಇದೆ, ಇವ್ರು ಕಾಲ್ ಮಾಡಿದ್ರು ಅಂತ.
ಇಬ್ರು ಮೇಲೂ ಇದೆ.
ಇಬ್ರು ಮೇಲೂ ಇದೆ.
ಏನಕ್ಕೆ ಕಾಲ್ ಮಾಡಿದ್ರಿ?
Brother of
ನನ್
the
ತಮ್ಮ
brother of the petitioner and the has died, and the mother of the petitioner have committed the suicide, my lordship. And the wife has filed a counter complaint against the sister, who is the complainant in the previous case, suicide case. So the sister of the deceased has approached this court, my lordship.
I am asking a simple question. Complainant ಯಾರು? ಗಾಯತ್ರಮ್ಮ.
sister-in-law of the deceased, my lord.
Husband and wife both commit suicide.
Yes,
That is Venkatesh and his wife.
Venkatesh and his mother first committed suicide, my lord.
ಆಮೇಲೆ
On hearing the news that Venkatesh and his mother committed suicide, the deceased hearing who committed suicide. First complaint was lodged by the petitioner, my lord. The page at page number 47.
why are you alleged of abetting?
Because I called and I informed that my mother and my brother committed suicide. On next day, she committed suicide.
Abetment. Yes. Intermodal. The petitioners are before this court calling in question proceedings in CC 840 of 2023, registered for offences punished 498 ಯಾಕೆ?
498 ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಸುಮಿತ್.
Registered for offences punishable under section 498A 306 and 504 of the IPC. The petitioners are accused 1 and 2. The allegation against these petitioners is that they have abetted the commission of suicide of who? Yarada?
ಧನುಜ.
Of one Tanuja. Tanuja is the daughter of whom?
ಗೌರಮ್ಮ
Gayatramma.
ಗಾಯತ್ರಮ್ಮ.
Gayatramma and Venkatesh.
Yes, ma'am.
Yeah. The daughter of one one Gayatramma and Venkatesh. It transpires that Gayatramma and Venkatesh both commit suicide. The allegation against these petitioners are that they called the lady Tanuja and informed that Gayatramma and her husband have committed suicide. The next day, it transpires they said Tanuja commits
Dhanuja,
suicide.
ma'am, sorry,
Huh?
Dhanuja.
ಧನುಜ.
Dhanuja.
Dhanuja, all right. Dhanuja commits suicide. Therefore, the petitioners are alleged of abetting the commission of suicide of Tanuja. All that the allegation is that they have called the deceased and informed about the suicide of suicide of Gayatramma and Venkatesh. It is ununderstandable as to how that informing the death of certain person would become an abetment to suicide. Permitting further proceedings in CC so and so would on the face of it become an abuse of the process of the law. Therefore, there shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing.
ಪಬ್ಲಿಷ್.
ಆಮೇಲೆ ನೀವೇನಾರು ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಎಸ್.
My lordship, records for videography were more than 1 lakh and odd videographers.
Sir, teacher.
Teacher, no doubt, my lord, but my lord, head grounds are, my lord. Complaint is totally concocted. My lord. May I take a
Complaint is
some time?
concocted.
Absolutely, my lord. I will be able to know how it is done. My lord. Shall I take some time, my lord, if lordship not mind? my lord. I'll
Sometime,
take
andre,
some
according to you, what is the parameter of some time?
time, andre, my lord, I'll be able to demonstrate, my lord.
Till
that
the
this-
cows come back?
Alla,
No, sir.
The lordship may give me free, my lord, free hearing. My lord. I'll be able to demonstrate thereafter. I'll leave it.
ಹೇಳಿ.
Absolutely. Kindly see, my lord. Complaint, my lord, is at page 18. Typed copy, my lord, at page 18.
All right. Yes.
May I read?
Yes.
ವಿಷಯ ನಿರೀಕ್ಷಕರು ಸೋ ಅಂಡ್ ಸೋ ಮಾಸ್ತರ ಮಸ್ತಿ ವಿಷಯ ಮುನಿಯಪ್ಪ ಕಲಾ ಶಿಕ್ಷಕರು ವಿಡಿಯೋಗಳನ್ನು ಮಾಡಿ ಸಾಮಾಜಿಕ ಜಾಲತಾಣಗಳಲ್ಲಿ ಬಿತ್ತರಿಸುವ ಬಗ್ಗೆ
ಪೇಪರ್ಸ್ ಕೊಡಿ ಮೇಡಮ್, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್. ಎಸ್ ಸರ್.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 15/12/2023 ರಾತ್ರಿ 9:30 ಗಂಟೆ ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆಯ ಸಹಾಯವಾಣಿ ಕಂಟ್ರೋಲ್ ರೂಮ್ ಟಿಕೆಟ್ ನಂಬರ್ WUQ61 ಈ ದೂರಿನ ಅನ್ವಯ ಮರುದಿನವೇ ನಾನು ಮತ್ತು ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶ ಅಧಿಕಾರಿಗಳು ಕರ್ನಾಟಕ ವಸತಿ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಕೋಲಾರ ಜಿಲ್ಲೆ ವೆಂಕಟರಮಣಪ್ಪರೊಂದಿಗೆ ಮುರಾರಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಎಲ್ಲುವಳ್ಳಿಗೆ ಭೇಟಿ ನೀಡಲಾಯಿತು. ದೇ ಗೋ ಅಂಡ್ ವಿಸಿಟ್ ಮಾಡೋಣ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿದ್ಯಾರ್ಥಿಗಳು, ಶಿಕ್ಷಕರು, ಸಿಬ್ಬಂದಿಯವರೊಂದಿಗೆ ಪ್ರತ್ಯಕ್ಷವಾಗಿ ವಿಚಾರಣೆ ಒಳಪಡಿಸಲಾಯಿತು. ಈ ಸಂದರ್ಭದಲ್ಲಿ CLT ಪರೀಕ್ಷೆಗೆ ಹೋಗಿ ತಡವಾಗಿ ಬಂದಂತಹ ಮುನಿಯಪ್ಪ, ದಟ್ ಇಸ್ ನಾಟ್ ದ ಅಕ್ಯೂಸ್ಡ್ ಹಿಯರ್ ಪಿಟಿಷನರ್, ಮುನಿಯಪ್ಪ ಚಿತ್ರಕಲಾ ಶಿಕ್ಷಕರನ್ನು ವಿಚಾರಿಸಲಾಗಿ ಈ ಘಟನೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲಾ ವಿಡಿಯೋಗಳನ್ನು ನಾನೇ ಚಿತ್ರೀಕರಿಸುತ್ತೇನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಸಮನ್ವಯಾಧಿಕಾರಿಗಳು ಮತ್ತು ನಾನು ಸದರಿಯನ್ನು ವಿಚಾರಿಸಿದಾಗ ಸದರಿ ಮುನಿಯಪ್ಪರವರು, ನಾವು ಪ್ರಶ್ನೆ ಮಾಡುವ ಅಧಿಕಾರ ನನಗೆ ಇರುವುದಿಲ್ಲವೇ ಎಂದು ಜಂಟಿ ನಿರ್ದೇಶಕರನ್ನು ಪ್ರಶ್ನೆ ಮಾಡಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಅವರು ಸಂಬಂಧಿಸಿದ, ನೀವು ಒಬ್ಬ ಜವಾಬ್ದಾರಿತ ಸರ್ಕಾರಿ ನೌಕರಾಗಿದ್ದು ಈ ರೀತಿ ವಿಡಿಯೋಗಳು ಛಾಯಾಚಿತ್ರಗಳನ್ನು ಚಿತ್ರೀಕರಿಸಿ ಮೇಲಾಧಿಕಾರಿ ಗಮನಕ್ಕೆ ತಾರದೆ ನೀವು ಮಾಡಿರುವುದು ತಪ್ಪು ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ. ಆದರೆ ಮರುದಿನದ ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಪ್ರಾಪ್ತ ವಿದ್ಯಾರ್ಥಿಗಳ ಛಾಯಾಚಿತ್ರಗಳನ್ನು ಜಾಲತಾಣಗಳಲ್ಲಿ ಬಿಟ್ಟು ಪತ್ರಿಕೆಗಳಲ್ಲಿ ಬರುವಂತೆ ಮಾಡಿ ಇಲಾಖೆಯ ಮುಜುಗರ ಉಂಟು ಮಾಡಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ದಿನಾಂಕ 17/12/23 ಹೆಣ್ಣು ಮಕ್ಕಳು ಬಟ್ಟೆ ಬದಲಾಯಿಸುವ ವಿಡಿಯೋ ಮಾಡಿರುವುದಾಗಿ ಟಿವಿ ಚಾನೆಲ್ಗಳಲ್ಲಿ ಪ್ರಸಾರವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಮುನಿಯಪ್ಪ ಇವರ ಮೇಲೆ ಕಾನೂನಾತ್ಮಕ ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿದ ವಾಸ್ತವಿಕತೆಯನ್ನು ಹೊರತರಲು ಈ ಮೂಲಕ ಕೋರಿದೆ. This complaint was lodged, my lord, on 17/12/2023 at 5 PM.
All right.
Information was, my lord, one day earlier, 15/12. Okay, that is a different issue.
Hmm.
No, my lord, kindly see, my lord, page 16 and, my lord, 16 and 17 are written complaint. Na I ಓದಿದ್ದು typed complaint for purpose of, my lord, quick ಇದು ಮಾಡ್ಲಿ.
ಆಯ್ತು.
Page 16 ದಯವಿಟ್ಟು ಮೇಲ್ಕಂಡ
ಇದಕ್ಕೂ ಇದಕ್ಕೂ ವೇರಿಯನ್ಸ್ ಇದೆಯಾ?
ಅಲ್ಲಿ ತುಂಬಾ ಕೈಲೇನ ಮಾಡಿದ್ದಾರೆ, ಕೈಲೇನ ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೊತಾರೆ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 15/12/23 ಅಲ್ಲಿ ಮ್ಯಾಲ್ ತೋರಿಸ್ತಾರೆ ರಾತ್ರಿ 9:09 ಗಂಟೆಗೆ. Why should he add later? That the time is very important. He can't add it later. ಕೈಲೇ ಅಲ್ಲಿ ಹಿಂಗ್ ತೋರಿಸ್ಬಿಟ್ಟು ಮೇಲೆ ಆಡ್ ಮಾಡ್ತಾರೆ. ಮುಂದೆ ಫರ್ದರ್ ಒಂದ್ 7-8 ಲೈನ್ ಆದ್ಮೇಲೆ ಭೇಟಿ ನೀಡಲಾಯಿತು. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿದ್ಯಾರ್ಥಿಗಳು, ಶಿಕ್ಷಕರು, ಸಿಬ್ಬಂದಿಯವರನ್ನೇ ಪ್ರತ್ಯೇಕವಾಗಿ ವಿಚಾರಿಸಿ, he goes and talks to them, have an investigation like. ಆಮೇಲೆ ಪೇಜ್ 17 ದಯವಿಟ್ಟು ನೋಡಿ. ಪೇಜ್ 17 ನಲ್ಲಿ exactly ಒಂದು 4-5 lines on the bottom, my lord. ಅಲ್ಲದೆ your lordship gets that, my lord, ಆ ಡೇಟ್,
yes.
ಅಲ್ಲದೆ 17/12/2023 ಎಲ್ಲ ಅದನ್ನೇನೋ ಮತ್ತೆ ಗಿಜಿ ಮಾಡ್ತಾರೆ. ಹೆಣ್ಣು ಮಕ್ಕಳು ಮತ್ತೆ ಅಲ್ಲಿ ಸ್ಪೇಸ್ ಕೊಟ್ಟು ಅಲ್ಲಿ ಮೇಲ್ ತುಂಬ್ತಾರೆ. ಬಟ್ಟೆ ಬದಲಾಯಿಸುವುದೇ ಇವ್ರದ್ದು ಏನಿದ್ರೆ ಆಮೇಲೆ ಯಾಕೆ ಆಡ್ ಮಾಡ್ತಾರೆ? I don't know why, my lord. If the, my lord, all said and done is, I have photographed, my lord, the photo.
Sir, the allegation, crux of the allegation is,
No.
you being a teacher, you have photographed the girl children changing their dress.
ಅದು manipulation ಅಂತ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
That is the allegation.
My submission is,
And
ಅದು
it
ಏನಾಗಿದೆ
is a
ಹೇಳ್ತೀನಿ,
shade, it is a shade beyond being horrendous.
I will come to that. I know, my lord, I can't go. These things are there. I can't, my lord, say to it that they are not there. But my submission is, ಇಲ್ಲಿ ನೋಡಿ, ಬಟ್ಟೆ ಬದಲಾಯಿಸುವ ಅನ್ನೋದನ್ನ ಕೈಲೇ ಆಡ್ ಮಾಡಿದ್ದಾರೆ. ಮೊದಲಿಗೆ ಇಲ್ಲ ಅದು. ಈ ಟಿವಿಗಳಲ್ಲಿ ಚಾನೆಲ್ಗಳು, ಯಾವ ಟಿವಿ ಚಾನೆಲ್ ಅಂತೂ ಇಲ್ಲ. ಟಿವಿ ಚಾನೆಲ್ಗಳಲ್ಲಿ ಸುಮಾರು ಕಡೆ ತೋರಿಸಿದ್ರಂದು. My lord, not even TV channel is named. Not even, my lord, parents are named. Not even, my lord, children are named. My lord,
No, who is the complainant?
Complainant, my lord, is the
CDPO.
ಮಾಡಿದ್ದಾರೆ.
Correct?
My submission is, my lord, fundamental submissions are, my lord, complaint is first of all delayed, my lord, because 15ನೇ ತಾರೀಕಿಗೆ ರಾತ್ರಿ 9:00 ಇನ್ಫಾರ್ಮೇಶನ್ ಬರುತ್ತೆ. December 15. Complaint is lodged at 17/12 at 5 PM.
ಈಗ ಪೋಕೋ ಮೊಬೈಲ್ ನೀವು ಅನ್ಲಾಕ್ ಮಾಡಿಲ್ಲ, ಯಾಕೆ ಅನ್ಲಾಕ್ ಮಾಡಿಲ್ಲ?
Regarding other things, my lord, whatever grounds I have, my lord, I put it last.
ಅಲ್ಲ, the investigation papers reveal that everything
No,
is
your
fine.
lordships have it, my lord. I know the other day I have submitted, my lord. Those things I can't get away, my lord. I can't go with that. I can't tell, my lord.
then
That is
no-
there on your last records.
ಈ
But my grounds are legal
ಪಾಸ್ವರ್ಡ್
grounds,
ಕೊಟ್ಬಿಟ್ಟು
my lord.
ಅನ್ಲಾಕ್ ಮಾಡ್ಕೊಡಿ.
Correct. ನಾನು legal grounds na submission ಮಾಡ್ಬಿಡ್ತೀನಿ. Thereafter,
Yes.
first ground is, my lord. Of course, ultimately I got lead to lordship, my lord. And it is only 482. All of us know it can't, my lord. It's not a getaway or getting a Xerox. No, your lordship's, my lord, application of mind, whatever it is, propriety, all the majesty. You can't get away with that. But my submission grounds, my lord, 1, 2, 3, 4. My lord, 15/12, my lord, is the complaint lodged at 9:30 in the night. Complaint is lodged on 17/12/2023 at 5 PM. In between, what happens is, my lord, authorities along with, my lord, some police officers go there to the school, my lord. They meet the parents. They meet the children.
One clarification, sir.
Yes.
All these phones were seized from you.
Of course, I can't say no
Alva.
because they are already there on record. my lord.
They're already, it was seized from you.
That I can't, my lord, for
Correct.
everything I can't.
ಅಲ್ಲ, ಒಂದೇ ನಿಮಿಷ. ಇದು ಎಲ್ಲ ಕನ್ಸರ್ನಿಂಗ್ ಇವ್ರೊಬ್ಬರದೇ ತಾನೇ?
ಅಲ್ಲ, ಅದನ್ನ ಅವರು ಹೇಳ್ಬೇಕು, ಮತ್ತೆ ಯಾರ್ದಾರ ತಂದು ನಮ್ಮ ಕೊಳ್ಳಿಗೆ ಹಾಕ್ಬೇಡಿ.
ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ಅಲ್ಲ, ಫೋಟೋ ನಿಮ್ದೇನೆ ತೆಗ್ದಿರೋದು. ಎಸ್. These articles were sent in this crime. I'm really surprised. How many mobile phones you have? Redmi, Samsung, MI, ಆಮೇಲೆ OnePlus, Poco.
I don't
Why-
think
why
a
do you
teacher,
have so
how
many
can
mobile
a
phones?
teacher dare to have so much? I don't believe.
ಅಲ್ಲ,
I do not know whether.
ಅಲ್ಲ,
ಎಷ್ಟು
ನಿಮ್ಮಿಂದ
ಜನ
ಸೀಸ್
ಇದೆಯೋ
ಆಗಿದೆ.
ಗೊತ್ತಿಲ್ಲ.
Why did you have so many mobile phones? And each mobile phone contains at least 8,000 images.
That, my lord, I can't say regarding it. It will be probably, I don't know what defense. At this stage, I can't say, but my submission is,
I told you
teacher
that-
normally my lord, does not have these.
No, these are things. If these are even seen prima facie, you appear to be a pedophile.
ಅದು ಬೇರೆ, but legal grounds I am.
Yes.
Second, one point. Secondly, my lords, keeping apart delay, my lords, what is done is, normally, your lordship, Lalit Kumari, my lord, any number, your lordship have allowed number of, my lord, petitions.
Yes.
Even recently also, my lord, my colleague. Vasant
No, no
Kumar,
problem. Don't worry about Lalit Kumari.
Your lordship knows, I did not, all points that are there, Lalit Kumari also put it in that order, allowed it by saying, my lord, materials or what seizure, whatever, it can't be done, my lord, before, my lord, lodging the complaint.
Yes.
Here, what is being done is, they spend 2 days they go there, they get it from the lips of, my lord, parents, teachers, ಮತ್ತೆ teachers, ಅಲ್ಲಿ ಪಬ್ಲಿಕ್ ನವರು ಆಮೇಲೆ ಇವನ ಹತ್ರ ಹೋಗ್ತಾರೆ, ದೇ ಆಸ್ಕ್ ಹಿಮ್ ಅಂಡ್ ಹಿ ಸೇಸ್ ನೋ ನೀವ್ ಯಾರು ನನ್ ಕೇಳೋರು ಅಂತಾನೆ. ದಟ್ ಸಬ್ಮಿಷನ್ ಆಲ್ಸೋ ದೇ ಟೇಕ್ ಫ್ರಮ್ ಹಿಸ್ ಲಿಪ್ಸ್ ಆಸ್ ಇಫ್ ಈಸ್ ಅಡಮೆಂಟ್. Keep everything, then my lord complaint is lodged. Would it be as good as investigating before the?
Correct.
Would it be? That is first thing that I want.
I'll answer that. Don't.
Of course, my lord. This is one aspect.
157 irade.
Next is my lord 65B. 65B, of course, you will.
65B certificate ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಕೊಡು. During the trial ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಕೊಡು.
Earlier
That
we
would
was,
not
my lord,
vitiate.
earlier we was, my lord, it has to be at the first instance, then your lordship have already told by saying it can be done as well. Evidence stage nallu that has.
Yes.
Yes. I can't, my lord, argue like raw voice or whatever it is. But point number one is there is a delay, concoction. My lord, they go, my lord, fundamental ground is, my lord, can, my lord, FIR this type, my lord, after correcting all that from himself, my lord, as good as the ಮತ್ತೀಗ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದಂಗ ಆಯ್ತಲ್ಲ. ನೀವ್ಯಾರು ನನ್ ಕೇಳಲಿಕ್ಕೆ ಅಂತ ಅವ್ನು ಹೇಳ್ತಾನೆ ಅಂತ ಇವ್ರು ಬರ್ಕೊಂಡು ಆಫ್ಟರ್ 2 days ಲಾಸ್ ದ ಕಂಪ್ಲೇಂಟ್. ವಾಟ್ ರಿಮೇನ್ಸ್ ದೆನ್? ವಾಟ್ ರಿಮೇನ್ಸ್ ದೆನ್?
Another mobile phone, POCO. What remains ಅಂದ್ರೆ ಅದು ಓಪನ್ ಮಾಡ್ಕೊಡಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ.
This is all, my lord, I wanted to. And Lalit Kumari, my lord, even now stands as, even now stands.
Lalit Kumar is not a
I
panacea.
know all, my lord.
Sir, Lalit Kumar is not a panacea to all ills. No.
How you ತಗೊಂಡಿದ್ದೀರಾ? I know, I have read that. In the other day, the lordship said, even it can be done at the, after charge sheet also.
That 65B, sir.
ಮಾಡಿದೆ 65B. I know, let's 65B. So therefore, my submission is, as good as the accused statement ಆದಂಗ ಆಯ್ತಾ ಅಂತ ನಮ್ದು. ಅವನ ಬಾಯಿಂದ ಬರ್ಸಿ, ನಾನೇ ಮಾಡಿದ್ದೀನಪ್ಪ, ನಾನೇ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ, I don't think. And plus recovery is almost the way it is looking at, ಆಮೇಲೆ ಇದನ್ನೆಲ್ಲ ಸೇರಿಸೋದು. ಆಮೇಲೆ ಯಾ ಟಿವಿ ಯಾ ಚಾನೆಲ್ ಒಂದು ವರ್ಡ್ ಇಲ್ವಾ?
ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಇದೆ ಸರ್.
No, at the complaint, my lord, for
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಯಾವ ಟಿವಿ?
ಅಲ್ಲಿ FIR ಇರುತ್ತೆ, ನಾರ್ಮಲ್ ಇರುತ್ತೆ. Because all of us are aware, TV9, TV3, TV4 ಒಂದು ಇಲ್ಲ.
ಈ ತುಂಬಾ ಟಿವಿಗಳಿದೆ ಸರ್, ಗೊತ್ತಿಲ್ಲ ಯಾವ. ಎನಿವೆ ಟಿವಿ ಅಂದ್ರೆ ಸಾಕು.
Lord, even look itself, Lord, according to you.
What look?
ಅಲ್ಲ ಈ ಕಂಪ್ಲೇಂಟ್ ಓದಿದ್ರೆ
Complaint.
ಬಿಟ್ರೆ ಯಾವ್ದೋ ಅನ್ನೋದು ಏನೂ ಇಲ್ಲ, ಯಾವ ದಿವಸನೂ ಇಲ್ಲ, ಪೇರೆಂಟ್ಸ್ ಹೆಸರಿಲ್ಲ. ಅಫ್ಕೋರ್ಸ್ ಲಾರ್ಡ್ ಪೋಕ್ಸೋ ಆಕ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಹೆಸರು ತೋರಿಸ್ಬೇಡಿ, ವೆರಿ ಗುಡ್, ನೇಮ್ಸ್ ನಾಟ್ ಟು ಬಿ. ಪೇರೆಂಟ್ಸ್ ಹೆಸರು ಇಲ್ಲ, ಯಾರ ಹೆಸರು ಇಲ್ಲ, ಸ್ಕೂಲ್
ಪೇರೆಂಟ್ಸ್ ಹೆಸರು ಪೋಕ್ಸೋಗೆ ಏನ್ ಸಂಬಂಧ ಸರ್?
ಅಲ್ಲ ಅಲ್ಲಿ ಯಾರ ಕಡೆಯಿಂದ ಅಂತನೂ. ಆಮೇಲೆ ಅಲ್ಲಿ ಇನ್ನೊಂದಾಗಿದೆ, ಇಫ್ ಐ ಆಮ್ ಪರ್ಮಿಟೆಡ್ ಟು ಲಾರ್ಡ್, ಒನ್ ಮೋರ್ ವರ್ಡ್ ಐ ವಾಂಟೆಡ್ ಟು ಆಡ್. ಅಲ್ಲಿ ಏನಾಗಿತ್ತು,
ಇರ್ಲಿ, ವಿಲ್ ಕನ್ಸಿಡರ್ ದಟ್ ಪಾಯಿಂಟ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಸೆಡ್, ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಡನ್.
ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಲಾರ್ಡ್. ಇಲ್ಲಿ ಹಿಂದೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪೇಪರ್ ಅಲ್ಲಿ ಸುಮಾರು ಸಲ ಬಂತು, ಟಿವಿನಲ್ಲೂ ಬಂತು. ಆ ಏರಿಯಾದಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಈ ಯಾವ ಸ್ಕೂಲ್, ಮುರಾರಿ ಸ್ಕೂಲ್ದಲ್ಲಿ ಆ ಗಟಾರನ್ನ ಕ್ಲೀನ್ ಮಾಡಿಸ್ಲಿಕ್ಕೆ ಮಕ್ಕಳು ಉಪಯೋಗಿಸಿರ್ತಾರೆ. ದಟ್ ಹಸ್ ಕಮ್ ಇನ್ ದಿ ಬೇಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬೇರೆಯವ್ರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಬಂದಿದೆ. ರೆಫರೆನ್ಸ್ ಅದೇ ಹೇಳಿದ್ನ, ಅದ್ರ ಬಗ್ಗೆ ಇದೆಯಾ? ಐ ಡೋಂಟ್ ನೋ ವೈ ದಿಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಡನ್.
Why this has been done now?
ಅಲ್ಲ why no?
Sir, you're taking photographs of girl children changing clothes, and why this has been done?
If I am permitted to read one line, my lord, at page 23, advocate for accused argued that there was an incident of employing residential students by the principal for cleaning the septic tank so and so regarding ಇದ್ರ ಬಗ್ಗೆ ಟಿವಿ ಚಾನಲ್ ತೋರಿಸಿದ್ರು ಅಂತ ಬಂತು. ಇಟ್ ಮೇ ಬಿ, ಬಟ್ ಈ ವಿಷಯದಲ್ಲಿ ಒಂದು ಟಿವಿನಲ್ಲಿ ಅಲ್ಲ ಒಂದು ಹೆಸರು ಹೇಳ್ಬೋದಾಗಿತ್ತು, ಇಂಥ ಟಿವಿನಲ್ಲಿ ಇಷ್ಟೊತ್ತಿ ಬಂದು ಫಿನಿಶ್.
We'll answer it. You have a point. We will not disappoint.
I leave it to that.
Yes.
And in the event, my lord, if flashes were to, my lord, thereafter all observations made shall not have, ಏನ್ ಹೇಳ್ತೀರಾ? I don't know. This court is supposed to be, my lord, the flood with full 482 and champion of 482 ಅಂತ ಈ ಕೋರ್ಟಿಗೆ ನಾವು ಕರಿತೀವಿ. We believe, my lord, we believe. And we leave to last, whatever best. But as an accused, my lord, forgetting, my lord, at the first look ಅನ್ನಿಸ್ತದೆ, ಒಬ್ಬ ಟೀಚರ್ ಆಗಿ ಇಂಥವೆಲ್ಲ ಮಾಡ್ತಾನೆ, that is one aspect of matter. But legally speaking, would such a complaint, my lord, would it, my lord, make them to go for investigation? And what remains then for me? What remains? ಇಷ್ಟೆಲ್ಲ ಆದ್ಮೇಲೆ ಇನ್ನೇನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್? That is all my wanted. I leave it to you.
Heard the learned senior counsel
Grateful.
SP Kulkarni appearing for the petitioner. The learned HCGP has placed on record the original papers of investigation. The same is taken into the file reserved.
Very grateful for patient hearing.
Yes. This requires, sir. ಅಷ್ಟೊಂದು ಮೊಬೈಲ್ ಫೋನ್ ಇತ್ತಲ್ಲ. Yes.
Nothing more.
appearing for the petitioner, seeking for an adjournment.
Huh?
Kindly have this matter
Folk-
next week, members.
POXO case, ma'am.
POXO case.
Pokso,
Yes, ma'am. Kindly have this matter next week, members.
in settlement,
Not for settlements, ma'am.
ಮತ್ತೆ?
15 years.
Senior has engaged in the other court, my lords.
Oh, yesterday's met.
Sorry.
List on 9-9. Yes, next.
Much obliged.
In serial number 8, there's an interim order, my lords.
Defamation and vigilance angle. Yes.
Private complaint which is given for disproportionate asset, cognizance taken. There's a challenge to the cognizance, order of stay. Because the order of stay is given, then you go and file a case for defamation. This is the sum and substance.
Yeah, who is the petitioner in the companion petition?
That's it. Companion
Respondent B.
petition only.
First
it is
petition,
you.
madam.
Alla, 8.1 ಅಲ್ಲಿ.
For the advocate. For the advocate.
ಅಲ್ಲ ಇದು 8 ಯಾರು? ಪ್ರಕಾಶ್ ಎಂ ಪಾಟೀಲ್ 8 ಅಲ್ಲಿ.
I appear for the respondent in the first matter, madam. Respondent in the first matter.
That is Amritesh.
Yes, ma'am.
You still want to insist on that?
But I'll seek instructions.
ಎರಡು ಕಾಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು.
Yeridilla. My lords, the other matter which they have sought for, please look at the order of stay, my lords. We have produced it. That's a case of disproportionate asset where cognizance was taken by the court and they approached in filing a 482 against that. My lords, the interim order which is granted in that case, my lords may know annexure D.
13, case of 13 is it?
Disproportionate. How do?
ಅದೇ.
How do? My lords, can I just point out the sequence, my lords? An advocate.
What is defamation? Oh, this.
My lords, I'll just point out this. My lords. My lords, one day, I'll just explain what has happened, my lords. An advocate would file a private complaint. In his private complaint, he says a senior Shirastidar and the Shirastidar's wife together amassed wealth to the tune of 5.14 crores. This is the allegation, disproportionate asset. My lords, sworn statement done, cognizance was taken on a private complaint. Now, once cognizance was taken, they would file a 482 petition against the taking of cognizance, and there's an interim order granted in that case. My lords may kindly now notice annexure D, my lords. The interim order, on what point they got an interim order, my lords. 69, page 69, in criminal petition 3575 of 2024. The learned, my lords, could I just point that out at page
There is
70?
154, 193 here.
Because it's on a private complaint, sworn statement, and the
ಅಲ್ಲ,
cognizance
154, 193 ಅಲ್ಲಿ ಬರುತ್ತೆ.
doesn't come at all. And on that basis, my lords, a stay is granted. Then, my lords, they go and file a defamation case against the advocate.
ಅಲ್ಲ, and 17A also in disproportionate is not applicable.
ಇಲ್ಲ. ಎರಡು ಬರಲ್ಲ. Both the points on which, my lords, the interim order granted was, so, my lords, they get this stay, all right. Stay ಸಿಕ್ಕಿದೆ ಪರವಾಗಿಲ್ಲ. ಮತ್ತೆ ಹೋಗಿ defamation case.
ಯಾರು ಸ್ಟೇ ಸಿಕ್ಕಿದೆ ಅದೇ ತುಂಬಾ ಶೇಕಿ ಅದ್ರ ಮೇಲೆ ಡೆಫಮೇಶನ್ ಬೇರೆ.
ನಾನು ಅದು ವೆಕೆಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ನೀವ್ ಯಾರು ಸರ್?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೌಮ್ಯ.
ನೀವು ಕಂಪ್ಲೇನೆಂಟಾ?
Respondent
Yes.
no, Swami.
Complainant means the advocate,
Oh,
Sandeep.
the second. 8.1.
ಪ್ರದೀಪ್ ಕುಮಾರ್.
Yes, my lord.
ಓ ಅದ್ರಲ್ಲಿ ನೀವ್ ಹಾಕಿರೋದಾ?
ಹೌದು ವೆಕೆಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹಾಕಿದ್ದೀನಿ.
The same private
To be
complaint,
heard.
my lord, had given certain complaints to the High Court also. High Court Vigilance Committee, my lord, has conducted an investigation, my lord, and they have said that there is nothing forthcoming as so far as the Shirastadar is concerned.
Okay.
Having not satisfied, my lord, he goes ahead and files another private complaint, against which, my lord, we have obtained a stay order. Thereafter, my lord,
Thereafter you go and file a defamation case. Thereafter, not me. You filed a defamation case.
And also the day
Why did you become so touchy about it?
the FIR was filed on the day.
ಮನೇಲಿ ಹೇಳಿದ್ರ ಹಾಕಿ ಅಂತ ಡೆಫಮೇಶನ್.
Maybe, madam. I cannot say.
Then that is, he cannot override those
Yes, ma, husband and
directions.
wife. So wife goes and fights.
Wife's directions cannot be overridden, so he has filed defamation.
My lord, defamation filed by the wife. Husband says, wife, ಹೋಗಿ ಒಂದು defamation ಕೊಡಿ ಅಂತ.
Oh, you're shooting from your wife's shoulder. Okay, yes.
My lord,
Wait, was it needed? Why all this?
my lord, I'll seek instructions, my lord. On the point of defamation, I'll seek instructions.
And this 154.
affidavit also is not there, but even that.
Affidavit illa, that's okay.
Private complaint,
No,
own
even
statement.
otherwise, no, even otherwise, the complainant, my lord, has given certain complaints to the High Court also. There has been an investigation done by the.
You will answer, on that lines you will answer. All right.
And he says.
You are on defamation ಅಷ್ಟೇ ಅಲ್ವಾ? ನೀವು ಅದು ಬಿಡಿ ಹೋಗುತ್ತೆ. Yes. ನೀವು ಇದು
ನಾನು vacate, stay order.
ಮಾಡಿ ವೆಕೆಟ್ ಮಾಡಿ. Yes, first
I'll seek instruction.
get rid of that. ಇದಲ್ದೇನೆ ಡೆಫಮೇಷನ್ ಬೇರೆ ನಿಮ್ಗೆ. ಏನ್ ಡಿಫೇಮ್ ಆಗೋಯ್ತು?
Lord, the
ಸ್ಟೇ ಕೊಟ್ಟ ತಕ್ಷಣ there is a determination on merit, is it?
Lord, may I make one submission, my lord. This, the series of events started from 2019 onwards, my lord. Whenever there is a change in the district judiciary, the head of the district judiciary
Where are you working?
in Hassan, my lord. And every new district judge gets a complaint and the copies are marked to the Honorable Chief Justice of India. Every now and then it has become the trend, my lord. And every time he and the wife have to come before the Vigilance Committee, answer their, this one.
This is not the first complaint.
No, my lord. They keep giving complaints
Who
after
keeps
complaints.
giving?
My lord, at the instigation
Hello,
of the,
who keeps giving?
my lord, the advocate who is RTI worker. Who is,
You're
surprised.
ನೀವಾ? Oh.
In my petition, clearly stated on earlier occasion also, he is giving several such complaints on which inquiry was conducted and there was nothing
on
forthcoming against. Why to not this private complaint is filed again.
All
That
right.
is the difficulty.
Defamation is not the one that is the remedy. You can argue on merits and get it closed. You seek instructions with regard to that. I will take this on 4th. Vacating stay le ತಗೊಂತೀನಿ. We will answer your vacating stay. Yes.
Both the petition.
List the matter on 4th in the fresh matters list. Interim order subsisting in both these cases shall continue till the next date of hearing. No, he may have a point,
Let's
but
see, my lord. Let them explain
because
how. Yes.
that's all right. Because every time, how many times do you register a crime when there is
Probably
nothing?
let them just explain the
My
whole
lord,
thing.
one difficulty is this, my
Ultimately,
lord.
Yes, I'm
sorry.
My lord, I applied before the district judge to give me copies. They say under RTI, they say it is before the Honorable High Court, we can't give the copies and it is an administrative, on the administrative side. So I am, for the learned magistrate while taking cognizance, has also looked into those documents that these are documents which are not made even good, given, available to me.
Well,
That is the difficulty in, I am.
we'll answer all that. But defamation is not the remedy.
Please.
Nothing is, no defamation has yet come about unless there is some observation in the petition. Yes, that he will take some steps. We'll take it on 4th.
Please.
We'll dispose both on 4th. You ready?
Oblige.
LOC. ಇನ್ನೊಂದು
Shanti
ಮೂರ್ತಿ ಡಿ ನಾಯಕ್ ಇದ್ರಲ್ಲ.
Bhushan is there.
Yes, yes. ಶಾಂತಿ ಭೂಷಣ್ ಸರ್.
Probably if my Leonard friend client had.
ವಾಪಸ್ ನಾ ಹೇಳ್ದೆ, you should not have come to India.
Milord, if you would have let her eat the finger chips or French fries, probably this complaint would have not raised. That is what is stated, Milord, in page 5. And watching. Let him go, Milord.
ಏನ್ ಹೇಳಿದಾರೆ? ಎಲ್ಲಿದೆ ಅಫಿಡವಿಟ್?
Put it, I filed, Milord, in there.
ಮೇಡಮ್ ಯಾವ್ದು ಕೊಡಿ? ಇದು
Page number 2, my lord. I filed, my lord, 21/8, my lord, 21/8,
when are you coming back, sir?
my lord, after 6 months, my lord.
6 months.
1 year ಆಗುತ್ತೆ ಸ್ವಾಮಿ, ಯಾಕಂತ ಹೇಳಿದ್ರೆ
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ 2 to 4 ಗೆ ಸ್ಟೇ ಇದೆ, 1 ಗೆ ಸ್ಟೇ ಇಲ್ಲ.
ಇವ್ರಿಗೆ ಸ್ಟೇ ಇಲ್ಲ. No.
ಇವ್ರಿಗೆ ಸ್ಟೇ ಇಲ್ಲ.
Quay the petitioner.
Only 2 to 4.
Quay the accused 2 and 3. Finding no allegations against 2 to 4. Further proceedings will run so and so 2 to 4. Quay 2 to 4 till the next date. Very clear in granting interim orders. You cooperate with the investigation.
Please, I'll copy. Practically, investigation is completed, my lord.
ಅದು complete ಆಗಿದೆಯಲ್ಲ?
Your lordship, if your lordship may turn to, for a moment, my lord.
Yes,
turn to-
affidavit ga?
No, page 5 of the petition, para 13, 3 lines.
One minute,
After
page
3.
5 of the petition.
Please. I'll just point out two things, my lord, just to the after delivery. And if your lordship may turn to page 9, page 9, my lord, for a moment, my lord, page 9, line number 6. When she,
ಎಲ್ಲಿ ಅದು ಪ್ಯಾರಾ
page 9, my lord, it's para 21, page 9.
Internal page 8, my lord.
I'm sorry, internal page 8.
When she was not talking on phone, she would spend time watching Pakistan dramas. That is the
I just wanted to point out that ಓದ್ಬೇಕಂತ ಹೇಳಿಲ್ಲ ನಾನು. Lighter note, I just thought bloody read it.
Lighter note.
ಅಲ್ಲ ಎಲ್ಲ ಓಕೆ, ಕ್ಲೀನಿಂಗ್ ಯಾಕೆ? 498 ಇವ್ರ ಮೇಲೆ ಮತ್ತೆ ಇದು ಹಸ್ಬೆಂಡ್ಗೂ ಸ್ಟೇ ಮಾಡ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲ, ದಿಸ್ ಇಸ್ ಫ್ರಿವಲಸ್. ಏನಿದೆ ಚಾರ್ಜ್ ಅಲ್ಲಿ?
498 ಮಾತ್ರ ಇದೆ.
ಅದು ಗೊತ್ತು, ಒಂದ್ ನಿಮಿಷ. ನಾವು ಸಮ್ಟೈಮ್ಸ್ ಹಸ್ಬೆಂಡ್ ಅಂತ ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್, ಅಲ್ಲೂ ಏನೂ ಇರಲ್ಲ ಅದಕ್ಕೆ. ಡಿಮಾಂಡ್ ಆಫ್ ಡೌರಿ ಎಲ್ಲಿದೆ ಅಲ್ಲಿ?
General allegation.
Huh?
General allegation.
Absolutely general. Yes, you fly back. It's stay ಮಾಡಿದ್ರೆ you can go, nobody will. LOC ಇದೆಯಾ?
LOC ಇದೆ ಅದೇ.
LOC ಯಾಕೆ?
Originator.
ಯಾರು?
DCP.
That's what I also asked.
For the asking LOC, what is this? LOC is being used as a weapon like this. What is the offense against the husband, even tell me?
In fact, I think that the Supreme Court also, my lord, has clarified this issue, saying that
He
issuance
is-
of LOC.
He is crying foul, saying that she asked me to clean bathrooms, wash vessels, and she was watching television. And in turn, the allegation is 498 against him.
Supreme Court also said within 498A,
And she
issuance
was
of
with
LOC should
Total
not be
misuse
granted.
and abuse.
He was with me about 6 years in America, my lord.
ಅಲ್ಲಿ ನೀವೇ ಮಾಡ್ತಾ ಇದ್ರ ಎಲ್ಲ?
ಎಲ್ಲ ನಾನೇ ಕೆಲಸ ಮಾಡಿ ಅವ್ರು ಸುಮ್ಮನೆ ವಾಚ್ ಮಾಡ್ತಿದ್ರು ಟಿವಿ.
ಆವಾಜ್ ಹಾಕೋಣ. Yes. The petitioners are before this court calling in question registration of a crime in crime number 90 of 2024 registered for offense punishable under so and so. This court on 29/7/2024 had passed the following order. Interim order of stay was granted qua accused 2-4 on the score that it would run foul of the judgment of the apex court in the case of Kashkan Kaushar. The learned counsel for the petitioner has moved the matter for consideration of an interim order qua the husband, accused number 1, on the ground that he is losing his employment in the United States of America on the score that the CCB na,
ಇಲ್ಲ, ಬಸವನಗುಡಿ women police.
that the jurisdictional police have asked a lookout circular to be issued against the petitioner only for the offense of 498A that is pending. Therefore, he is unable to travel back to the United States and is on the verge of losing his employment. Therefore, the matter is taken up. On a perusal at the complaint so registered by the wife, the allegation is that when the wife delivered the child, because of high blood pressure, the husband did not allow her to eat French fries, rice and meat. ಅದೇ ತಾನೆ?
ಹೌದು.
Rice and meat.
And page
and
9.
all other
And page 9, ma'am.
and all other trivial allegations. The husband cries foul throughout the petition that during the stay of the two in the United States of America, the wife throughout sat watching television and asked the husband to clean the vessels and mop the house, which he has diligently done. Despite that, he is now facing loss of employment due to the filing of the case under section 498A of the IPC. The averments in the petition would meet the averments in the complaint, as the complaint is as vague as vagueness could be. In that light, permitting any investigation against this, the husband as well, would become an abuse of the process of the law and putting a premium on the act of the wife in alleging that she was not given to eat French fries at the relevant point in time. Therefore, there shall be an interim order of stay of all investigation, qua the husband even. In the light of the interim order so granted, the petitioner, light of the interim order so granted and the triviality shrouded in the crime, shrouded in the allegations that are leveled against this petitioner, I deem it appropriate to permit the petitioner to travel beyond the shores of this nation in the light of the affidavit that he has filed to secure his employment, to keep his employment secured, that he would not vanish due to the frivolous allegations made by the wife on the complaint. The frivolous allegations made in the complaint, sir, in the complaint. The Bureau of Immigration.
The Lordship may observe that, my lord, the originator to intimate the Bureau of Immigration.
Therefore, in the light of the interim order, the originator, the jurisdictional police shall forthwith intimate to the Bureau of Immigration with regard to the travel of the petitioner and not interdict him during his travel to the United States of America. The petitioner is bound by the contents or undertaking in the affidavit, and he shall cooperate with the investigation. Yes. Therefore, said observation. The application ಹಾಕಿದ್ದೀರಾ ಏನು?
Application.
ಅಲ್ಲ ಸಾರಿ, ಅದು ಎಲ್ಲ ಇದೆ ಐ ಎಲ್ ಮಾಡ್ಬಿಡಿ.
Great.
ಕ್ಯಾನ್ಸಲೇಷನ್ ಇಲ್ಲ, ಆಮೇಲೆ ನೋಡೋಣ. ಅದು ಬೇಡ, ಅದು ಹಂಗೆ ಇರಲಿ. ಇದನ್ನ ಸಪ್ರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡಿ ಸಾಕು.
Great.
ಪರ್ಮಿಷನ್ ಇಲ್ವಾ? ಕೈ ಹಾಕಿಲ್ಲ, ಬರಲ್ಲ. ಇಂಟರ್ವ್ಯೂ ಆರ್ಡರ್ ಕೊಡಲ್ಲ.
Permission to fly.
Permitted to fly. Yes. ಅವ್ರು ರೆಸ್ಪಾಂಡ್ ಇದ್ದಾರ?
I am for the respondent. Serial number 10.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number 10.
10 ಅಲ್ಲ, serial number 40 ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್. Served unrepresented, huh?
No, she has appeared almost 10 times, my lord, she has sought.
Deepika and this call.
Yes. She appeared on 3/8. From 3/8 onwards, my lord, she has been taking time. 3/8/23.
23.
Yes, if your lordship would see the order sheet, 3/8, then
But anyway,
24/8.
14% adrinda. Yes, then Supreme Court I was not heard of. We'll see, we'll post this in the fresh matters list on
Tuesday.
on 28th, yes, Wednesday.
Agboth.
28th.
Lordship may kindly record that it was listed, because this is not a 230 matter.
That I will do, yes.
Yes.
Not now, out of turn, I'll record it when it reaches.
Yes, yes.
You need not wait for it, we'll record.
I have another matter.
Yes, next. Yes, Bharat Kumar.
My lords, I appear for the respondent, please.
For the petition.
On the last date of hearing, that is
ಒಂದ್
yesterday.
ನಿಮಿಷ. 9 ಆಗಿಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. 9 ಆಯ್ತಲ್ಲ ಈಗ ಅಲ್ವಾ? ಅವೆಲ್ಲ ಎಲ್ಲೋ ಕರೆಕ್ಟ್, ಸಾರಿ ಸರ್. ಎಸ್ ಸಮರ್.
NDPS laws. You see, the primary allegation, my lords, is that of attempting to consume.
Consumer.
Attempting to consume, my lords.
Attempting to consume.
50A non-compliance, and that's the reason, my lords, the investigation has proceeded. But on 30th of November 22,
You ready?
Please.
We'll take it, not today. We'll take it on 3rd September.
please.
Yes, list on 3rd September. Yes, next.
Petition 130.
I appear for the respondent.
Yes, Bharat Kumar.
On the last date, my lords, yesterday, my lords were pleased to pose a question that what is the avocation of the respondent?
There is no.
No avocation.
No, I am a
No
coffee
source of
estate owner,
income.
my lords.
ನಿಮಗೆ ತಾನೆ ಅವಕೇಶನ್ ಏನು?
Coffee estate owner.
ಅದನ್ನೇ ಕೇಳಿದ್ ನೀವು ಪ್ಲಾಂಟೆಡ್ ಕೇಸ ಅಂತ.
I am a coffee estate owner, my lords. It is not a planted case. And all the grounds which are urged are question of facts, please, my lords, by the petitioner. And there was only one question.
Before the
There is
consent.
no document produced before the.
Evidence.
Statement.
Lead
Without
evidence.
sources of income. 85
Anyway,
lakhs.
your time we'll see. List on 3rd September. Yes, next. 3rd September, correct.
In the caption of fresh matters, please.
Fresh matters, yes, sir.
Date may fix minutes. Awaiting service of notice from the respondent number 2.
Post immediately after service of notice upon the second respondent. Interim order there? Yes.
Date may fix minutes.
2nd September. Yes.
Records for called last.
According, yes. Put it into the file, madam. Yes, next.
Section 9 of KPA Act, ಮತ್ತೆ 21 of Birds Act to 419, 420 this. Incident happened in the second week of.
First time ಬರ್ತಾ ಇರೋದಾ?
Sorry,
First time ಬರ್ತಾ ಇರೋದಾ?
Records are already submitted.
second time. 2020 ನಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು.
Accept notice as why to get the records. I have not said. ಎಲ್ಲ ನಾವೇ ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ಕಳಿಸ್ಬಿಟ್ರೆ ಹಂಗೆ. Who is the complainant?
ಪ್ರಶಾಂತ್ ಅಂಬರ್ಗಿ.
ಬರ್ಲಿ. ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ?
ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ವಾಪಸ್ ಕೊಟ್ಟಿರಿ. Emergent notice to the respondent number 2. Returnable by 12th. Yes, next.
Please, my lord, I appear for petition, my lords. In the last date, notice was issued to R1, but R2 was pending. If my lords may recollect, it's regarding the rejuvenation of the Ila Lake, that 35 acres of lake which we have rejuvenated. And trespassing and other section was imposed on me. It's like I did my fundamental right of doing protecting of the environment and nature, and I was alleged with this section. And series of communication was there, my lords. In fact, the officers also visited from time to time when I was doing the work. It's not that it was not at their knowledge. Only thing was that the committee was not established during that time. The DC has written the letter to the KDDC and that the committee was required to give us the in principle approval. But the committee was not there until today also it is not there. And I'm still doing some of my activity on instruction of the officer because if my lords may recollect, since last week, there was a heavy rainfall in the entire Bangalore city. And because of this lake, the entire surrounding was safe. And because of the rejuvenation work, and I'm one of the.
What's your name?
Durgesh Gupta. Kirtana is there.
He's also on record?
Record my lord, but he's an AOR from Delhi. He's taken pro bono interest in environmental matters.
Oh.
This my lord on the last date.
We'll hear it, yes.
My lord.
The R1 may be permitted to accept the notice for R2 because they both are the who the R2 was not served. R2 notice is not issued yet to R2. At least that may be.
That we will do.
R2 notice agirilla inadvertently na process kattidivi. R2 is a government official, so I pray that.
I'll accept notice.
SPP is directed to accept notice for the second respondent. List the matter on 10th September. Interim order subsisting shall continue till the next date of hearing.
There is no interim order.
There is an interim order.
There is an interim order.
Interim order nane kotte. She had appeared.
It is
last-
And she has appeared, your lordship has directed me to look into it, look into the issue. Seems to
No,
be,
I granted.
yes,
it
yes,
will-
no, your lordship has asked me to look into this issue because
There is an interim.
There is an interim order, my lords. Actually, it's a state responsibility,
Yes.
directive principle of state
8/8/2024.
policy.
literally this seems to be more than what he is speaking.
ಹೌದಾ?
If the state do that, I would have not come in picture.
Not only
I am
the, not
awarded
only
by
him,
the-
not only him, including the complainant to file
File
the
it,
complaint.
get it.
Including the complainant to file the complaint. There-
Right, sir.
The only person from India who's been awarded by BBC are the best champion of the,
Now, maybe my
awarded
lord,
by the
my-
New York Times. I've did the activity. It's not like that. I've not done earlier for
Wait, sir,
Bangalore.
wait, yes.
What my
Almost
sub-
40
my-
lakes I've rejuvenated.
My submission is, your lordship permit us to investigate.
Hmm.
We will let him cooperate with investigation.
Hmm.
There seems to be something more than what is,
You get,
Maybe-
you
maybe
get
for his
the-
own-
Get the papers, we'll see.
like maybe I've looked into papers, my lord, paper, I received the papers, but
Hmm.
there are some lacking in the papers and I spoke to the SP today.
Hmm.
And I've asked SP to entrust the investigation to the inspector and look after this matter. If your lordship,
You get the complete info and tell me investigation is necessary for reasons 1, 2, 3, 4, I will grant.
the only issue is that now police are handicapped because nobody has cooperated till today,
You,
including the
you
complainant.
tell me, I'll post it on 3rd then. It's on 3rd in the fresh matters list.
It's like Bar Association organize one event, say health camp, and tomorrow the,
Let him come up.
I am not saying
Person-
that, I am not saying that he is committed a mistake, but I'm only saying that there seems to be something more
We'll
than what
see,
is.
sir. 3rd, interim order have continued. Yes.
much obliged.
We have the petition. Malaj, the allegation is that Malaj, accused number 1 and 2. Malaj, there's an IA for dispensation, a typed copy of charge sheet and order sheet.
Yes, sir.
Malaj, on the
Huh.
matter. On the matter, Malaj, accused number 1 and 2, Malaj, are the ex-employees of the complainant. They have been alleged to steal 6 computer hard disks, Malaj, which contains the design protected product name.
Who is the
footnoted-
respondent?
A4 man,
Complainant.
complainant. man.
Complainant.
Notice ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ.
Notice agila, interim order, Malaj, if I may, maybe. Malaj, I've been charged under section, Malaj, 420, 120.
Correctly charged, sir. Wait. Yes.
Malaj, if I may submit, Malaj, there's only one design certificate, Malaj, in page number 70.
Then notice to the respondent complainant returnable by the 18th of September. The interim order subsisting. shall
Malaj, there's no
continue-
interim order in this matter.
There is no.
There is, sir. Subsisting shall continue till the next date of hearing.
Malaj, 15 and 16 also. Malaj.
15 and?
16 arising of this same charge. sheet.
Same, yes. There is, sir. ನೀವು ಇರಲಿಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಅವತ್ತು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು defer until the next date of hearing ಅಂತ.
ಇದೆ, yes.
For petitioners in this case, my lord.
ಅದು interim order dated, earlier order continues ಅಂತ ಮಾಡಿ ಅಷ್ಟೇ.
My lord, Juvenile Justice Board has not furnished the certified copies, my lord, yet. We had filed one.
What is this? ಎಲ್ಲಿ ಅವ್ರು ಜಗದೀಶ್? Last time I told you. Certified copies ಕೊಡಕ್ಕೇನ್ ಪ್ರಾಬ್ಲಮ್? ಇದಕ್ಕೂ ಒಂದು ಕೇಸ್
Alala, the issue is the JJ board apparently sits on one day. And without the consent of the chairman, they are not allowed to issue certificate copies. And today morning, the officer called me and said, now the officer has signed, my chairman has signed and copy is ready. In fact,
We'll
he
list
called,
it on Tuesday to say it is infructuous. Yes.
copy is, I believe, my lord, it is ready.
But
Chitradur-
furnish the copies.
It's
List
ready.
on Tuesday in the fresh matters.
But your lordship may actually, they give some direction, my lord, because if it is a,
ಹಾಗಾದ್ರೆ on Wednesday.
Yes, my lord.
In the fresh matters list. You take it, but we will direct.
My lord, there is stay on NBW.
NBW. Interim order subsisting shall continue to the next date of hearing.
Great.
Next. Correction.
It's a disposed of matter, seal number 18.
Disposed of.
Please, madam,
ಏನ್
filed an
correction ಏನು?
application for correction. This is a case where the petitioner had challenged my sale deed registration on the ground that he had contended that the writ petition or.
Oh, this is a senior citizen.
Not
No
my
minutes, no
lords.
minutes.
This petition was filed against an order.
All right, ಗೊತ್ತಾಯ್ತು.
Arise.
ಹಾ.
My lord,
What correction ಆಗ್ಬೇಕು?
ಇದ್ರಲ್ಲಿ
It's in
we had
page-
petitioner had filed an writ appeal. Even in the writ
Writ
appeal
appeal is rejected.
rejected.
Correct.
Even in the writ appeal, the same finding has come at para 3.5.
How can you now change
Correction
it,
in,
sir?
I filed the writ appeal on the basis of
filed
this
much before.
order.
Application was filed much before. I understand now correction may not be possible in this
Who has filed the application?
respondent number 4.
You have filed.
Because it says that I had filed contempt. I never filed contempt due to suo moto. And it says, the judgment says.
What is the correction to be done, sir?
So in
So they are seeking a correction to delete respond number 4
page
and add.
number 7 and in page number 11, my lords, 2 lines. In
Was the application pending when the order was passed?
it was pending, my lords.
When this order?
No, my lords. After the order passed, they have filed the application based on the order, my lords.
Writ appeal.
Writ appeal, not writ
Writ
appeal.
appeal ಅಲ್ಲ. Writ petition ಅಲ್ಲಿ order ಮಾಡಕ್ ಮುಂಚೆ was the application pending?
Correction, my lords.
Yes.
No,
Judgment ಆದ್ಮೇಲೆ.
Did you make a mention of the correction then?
so after the order was released, I filed this application.
Why? There is a
Because-
mistake in the order, is it?
It's just one factual mistake, my lords.
In the order?
May I just point out?
Yes, sir.
It says contempt petition was filed by respondent number 4. my
Forget
lords.
it. What is the factual mistake in the order? Tell me.
That's only minor things, my lords. I'm not saying it affects the final order also.
What is that minor?
It's that I have never filed contempt petition, my lords, and the
Oh,
sub
that's the only thing, is it?
and one more thing, the only 2 things are, my lords, this and during the pendency of the contempt petition, sub-judice registered sale date. That sale date was registered before contempt. That's all, my lords. Nothing
We'll
else is not
correct
going.
those things.
It is not
I have no issues.
finding nothing.
ಏನಾಗಿದೆ writ appeal ಅಲ್ಲೂ same finding ಬಂದ್ಬಿಟ್ಟಿದೆ.
You know, I think because of
That
doctrine
is
of
the problem,
merger,
my lord.
my lords,
Because now what happens, there is a order of writ appeal with regard to the very same para 3.5, my lords.
if I may make one submission,
I'll
my
make it.
no,
No, there, from
notice
there
was
it has
never
to come
issued,
down.
my-
Oh, notice was not
notice
issued.
not issued.
But ಇದ್ರು ಅವರು ಕೋರ್ಟಲ್ಲಿ, that's a different aspect. Page number 6, my lords.
ಅವ್ರು ಇದ್ರೆ ಅದು ಗೊತ್ತಾಗುತ್ತೆ.
ಅವ್ರು ತಗೊಂಡಿಲ್ಲ ಇದ್ರು.
ಅಲ್ಲ, ಯಾರಿದ್ರು? ನಾನಿದ್ರು.
Client ಇದ್ರು.
Client
ಇದ್ರು, advocate ಇದ್ರು.
Client.
Para 3.5, my lords. Last 3 lines ಕೆಳಗಡೆಯಿಂದ.
Number 18.
After the decision of the writ petition, contempt petition was filed by respondent for against the non-compliance of order.
Contempt petition ಹಾಕಿರ್ಲಿಲ್ವ ನೀವು?
Suo moto contempt petition for another direction where they had the government had to implement Kaveri system in line of the act, my lords.
How does that have any bearing, sir?
It will not
Does
have.
not have any bearing,
Then
my
why
lords,
are
that
you-
they should not misuse this.
Misuse ಮಾಡಿದಾಗ move ಮಾಡಿ.
Then they let
My
them
lords,
make
my
a
lords, I
point.
understand the technical difficulty because of doctrine of merger and all, but if I-
Nothing. Those observations will not come in the way of anything.
Yes.
ಏನಾಗುತ್ತೆ?
I
ಏನೂ
leave
ಆಗಲ್ಲ.
to my lords, my just, it could even be
They are all
dismissed according that.
No, because writ appeal ಅಲ್ಲೂ ಅದೇ ಆಗಿದೆ. What is this?
Well, my application could be dismissed on that ground after recording the fact, my lords. But however, because technical difficulty
see.
don't be
ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡಿ.
in fresh matter.
ನಾಳೆ ಬೇಡ. Tuesday fresh matters list.
Much okay.
Next.
408, 420 and 123B, my lord. At 7 o'clock, 41A notice is given, 8 o'clock I was arrested.
ಅದೇ ಅವತ್ತಿತ್ತಲ್ಲ ಅದೇ ಅಲ್ವೇ?
ಹಾ, ಅದೇ ಅದು ಪಾಸ್ಪೋರ್ಟ್ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ. ಇದು
ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಿದ್ದು.
ಹಾ, ಏನ್ ಪ್ರಾಬ್ಲಮ್?
ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಫಾರ್ ವಾಷಿಂಗ್ ಅಂಡ್ ಇಲ್ಲ ನಾನು ಪಾಸ್ಪೋರ್ಟ್ ರಿಲೀಸಿಗೆ ಅಂತ ಕೇಳಿದ್ದೆ. ಅವಾಗ ತಾವು ಸಮನ್ ಮಾಡಿದ್ರಿ ಈ ರೆಕಾರ್ಡ್ ಟು ಸಿ ವೆದರ್
ಪಾಸ್ಪೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ವ ಈಗ?
ಅಂದ್ರೆ ಆರ್ಡರ್ ಆಗಿದೆ, ಅಲ್ಲಿ ಐ ಹ್ಯಾವ್ ಟು ಸಬ್ಮಿಟ್ ದಿ ಆರ್ಡರ್.
We'll hear it. Entry ಮಾಡಿ ಇದೆಯಲ್ಲ?
amendment that may be considered.
What amendment?
I am seeking for a declaration that my arrest is illegal. That declaratory relief I am introducing.
Petition amend ಮಾಡಕ್ಕೆ ಏನಂತ? Yes. For the reasons indicated, so and so application IA 1 of 2024 is allowed. Petition is permitted to file an amended petition. Subject to objections, additional objections from the hands of the respondents, if any. Next. Interim order subsisting shall continue till the next date of hearing.
Here, my lord, in this matter, investigation is stayed. First week.
Huh?
Layout, my lord, there is a
List on,
misappropriation.
one ನಿಮಿಷ. List on 3rd September in the fresh matters list, yes.
No, 4th, my lord.
Right, 4th.
Please.
Yes, next.
4th.
For the petitioner. The petitioner is the warehousing corporation and the victim before this court.
This is the case where the this is the case where the complainant is the respondent number 2 and the accused is respondent number 3. Yeah, and
Accepting a B report, my lord.
the trial court
On cooperation of the complainant.
on the
Oh, ಆ matter ಇದು.
Please, ma'am.
Yes, again, fourth.
Yes.
List on fourth. The fresh matters list, yes.
for the respondent whose counsel, my lord, permitted to file a memo with 2 documents.
Wait.
Complaint is said.
Lata Sharda Tanuja.
Vimala.
Mala, sorry.
Across the counter
ಏನ್ across the
tablet.
counter?
cocaine tablets available.
ಯಾವ ಟ್ಯಾಬ್ಲೆಟ್?
That tablet,
ಹೇಳಿದ್ರಲ್ಲ.
ಗಾಂಜಾ ಹೇಳಿದ್ರು.
Ganja and
that
cocaine also
tablet,
available.
that tablet name is Lapros. It is
Lapros.
Lapros. It is a prohibited drug and sold on prescriptions by the doctor,
Correct.
by the medical shop.
It's a painkiller.
Lapros. It's a narcotic.
Is that a narcotic?
It's a painkiller
It's a narcotic. drugs.
given to cancer patients.
Narcotic.
It's a
drugs.
sedate, narcotic ಅಲ್ಲ.
It's a given.
Narcotic ಅಂದ್ರೆ ಏನು?
Schedule,
And there
schedule
is
ಅಲ್ಲಿ ಇರ್ಬೇಕು.
there is another tablet called Mandrix. Both are being taken by him.
Those are all sedatives. Sedatives given for certain purpose.
It is
Lapros is for cancer patients.
Cancer.
only on prescriptions it is being given.
Of course, for prescription. ನೀವು ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ಇಲ್ಲ ಅಂತ ತಾನೇ ಬಂದಿಲ್ಲ ಮೆಡಿಸಿನ್ ಈಗ.
ಹೌದು.
ನೀವು ಅದೆಲ್ಲ ಬಿಡಿ, ಜುವೆಲ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತ 301.
ಇಲ್ಲ ಏನಿಲ್ಲ ಏನಾಗಿಲ್ಲ.
This complaint is more revealing.
ಇಲ್ಲಿ ನೋಡಿ ಸರ್.
ಓ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದೀರಾ?
ಕಂಪ್ಲೇಂಟ್
ಹಾಕಿದ್ದಾರೆ.
ಸರ್
ನಾನು ಮೇಲ್ಕಂಡ ಮೇ ರೀಡ್.
ಒಂದ್ ನಿಮಿಷ, ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಮರ್ಡರ್ ಬಗ್ಗೆ ಹೇಳ್ತೀರಾ?
ಏನಿಲ್ಲ ಹೇಳೋದು.
ಇಲ್ಲ ಅಲ್ಲ?
ಏನಿಲ್ಲ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಎಸ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
That's all.
ಅಷ್ಟೇ. ಅಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ಒಂದು ಕಡಿಮೆ ಒಫೆನ್ಸ್ ನೋಡ್ಬೇಕಾಗಿತ್ತು. ಮರ್ಡರ್ ಹೇಳ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
304 ಬಿ ಬರುತ್ತೆ.
ಬರುತ್ತಾ?
ಬರುತ್ತೆ.
ಕನ್ವರ್ಟ್ ಮಾಡಿ.
Rash and negligence.
Rash and negligent. Husband pushed the wife and she died because of.
Yes.
Sir, she has died because of coronary thrombus.
No. That is, if
sir, myocardial infection.
Vikram Hospital had given that certificate, I would have agreed with your lordship. But it is some third doctor who is not at all.
ಅಲ್ಲ ಇದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಜ್ಯುವೆಲ್ಲರಿ ಸಿಗುತ್ತಾ ನಿಮ್ಗೆ?
Jewelry ನಮ್ಗೆ ಬೇಡ. Even if they give the jewels, we will not withdraw this case.
I'm quashing it. Where
My lord, my submission is only this, my lord. My submission is only this. On that particular day, he pushes her, she succumbs to the injury, she dies. The patient is taken to Manipal Hospital. If Manipal Hospital had given this certificate, and if it was a
patient was taken to Manipal Hospital.
Manipal Hospital.
Manipal Hospital ಎಲ್ಲಿದೆ?
Earlier, ಇಲ್ಲಿ ಇದ್ರದ್ದು Vikram Hospital. Now it is changed as we have Manipal Hospital. Earlier,
Manipal Hospital.
Vikram
The
Hospital.
body was kept in Manipal Hospital till 8 o'clock. One doctor is involved. I have stated in my objection statement.
ಇರ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. ಅದೆಲ್ಲ 7 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಜ್ಞಾನೋದಯ ಆಗಿದೆ ನಿಮ್ಗೆ.
Statement of
Yeah,
objection, para 12,
because of the-
something more which
my
is
lord,
revealing.
ಒಂದ್ ನಿಮಿಷ.
She
Now, this you are taken to which hospital?
Manipal Hospital.
Where is the certificate there?
Certificate I have produced at Manipal Hospital there.
ಅದು ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ದೇನಾ?
ಇಲ್ಲ, it is not of Manipal.
ಒಂದ್ ನಿಮಿಷ.
33. Page number 33. ಕೆಳಗಡೆ ಸೀಲ್ ಹೊಡೆದಿದ್ದಾರೆ ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಅಂತ. Villas Road.
All right.
Earlier it was Vikram.
Vikram has become Manipal, is it?
Yes.
Vikram has become Manipal.
Yes, Kamath sir.
Investigation is necessary. Investigation has to be done by the police. And already she has been, her statement, Lata's statement has been taken. Other witnesses' statement has been taken by the police. By then, she has approached this honorable court and taken a stay. That is the crux of the fact.
ಈಗ ಎಷ್ಟು ನಿಮ್ಗೆ 91 years?
Presently 91 years, 89 years. Yes. 91 years.
Earlier
And he is
provisions
not in a position to move around also unless some support is there.
earlier provision was 201 for screening of the offense. Now it is under the new act 238.
How does that make a difference?
She has screened the offense.
No,
Petition
how
number
does
2.
that make a difference?
No, the petitioner after petitioner number 2, daughter, after the incident was completed, has covered everything. Doctors have been told not to reveal the fact for various consideration. Police have to
Why did you
investigate.
not mention even the smallest thing in the complaint?
About what, my lord?
ಅದೇ jewelry complaint ಮಾಡಿದಾಗ
ಹೌದು.
ಯಾಕೆ ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ?
She was under threat and fear, my lord.
ಅದು 7 ತಿಂಗಳ ಹಿಂದೆ
Allah,
threat
she
and
was under threat and fear. IQ of a person varies from person to person. Some people who have got good IQ, they will immediately.
IQ ಗೂ complaint ಕೊಡಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
Intelligence. Try to understand. ಈಗ ಮಕ್ಕಳು ಸ್ಕೂಲಲ್ಲಿ ಫೇಲ್ ಆಗೋದು ಯಾಕೆ? ಓದ್ಬಿಟ್ಟು 5 ನಿಮಿಷದಲ್ಲಿ ಮರ್ತು ಹೋಗ್ತದೆ. ಹೆದರ್ತಾರೆ ಎಕ್ಸಾಮ್ ಬರೀಲಿಕ್ಕೆ.
ಓ, ಅದು ಗೊತ್ತಿರಲಿಲ್ಲ ನನಗೆ.
I am a student of psychology. That's what I am
ಮರ್ತು
telling.
ಹೋಗ್ತಾ ಇತ್ತಾ? ನಿಮಗೂ ಮರ್ತು ಹೋಗ್ತಾ ಇತ್ತಾ?
ನನಗಿಲ್ಲ. I am a student of psychology.
Psychology, okay.
And where is mental capacity of each person? She was under fear.
Of course,
She
that
was under threat. Now, after giving this complaint, she has not pursued this complaint till now about the jewels, about what I have submitted today. No action has been taken. Police called everybody, verified. Truth came out. Then the brother-in-law came. Brother-in-law discussed with the police. After everything, this fellow petition number 1 confessed. Yes, I pushed her.
Where is that?
Police report only there. If a police report is called out, everything will come up.
Investigation
Whatever.
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ? ಎಲ್ಲಿದೆ? ಕೊಡಿ ಎಲ್ಲ ಕೊಡಿ.
There, after police recording everything, my lord, then they obtained anticipatory bail. Once they took anticipatory bail, they did not cooperate with the police. Then they took a stay.
ಕೊಡಿ. 31st dictating. Yes.
Obliged.
Next.
31st, I may not be there, my lord, the CA.
Dictating ನೀವು ಇರ್ಬೇಕಾಗಿಲ್ಲ. Yes. No arguments, only dictation. Further hearing ಅಂತ ಹಾಕ್ಬಿಡಿ. ಅವಾಗ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀವಿ. List on further hearing. Next.
Obliged, my lord.
Appeared for the petition. In pursuance of the direction, also I appeared before the police. Submitted list of documents. A forensic copy of the what is the document and also appear before the police. Ask for the direction.
ತಗೊಂಡ್ರಲ್ಲ?
ಅಲ್ಲ ಅರೆ ಒಂದೇ ನಿಮಿಷ. ಕಂಪ್ಲೇಂಟ್ ಒಂದು ಸ್ವಲ್ಪ ನೋಡ್ಬಿಡಿ ಸರ್.
ಏನ್ ಕಂಪ್ಲೇಂಟ್?
ನಾವು ಅರ್ಜಿ ಮಾಡಿದ ಕಂಪ್ಲೇಂಟ್. ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 26 ಮೇನ್ ಪಿಟಿಷನ್.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆಲ್ಲ?
ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಓ, ಇದೀಗ ಬಗೆಹರಿಯಲ್ಲ. Yes. Third.
In the meanwhile, they should not file charge sheet.
List on third. Don't worry. You are before the court. Yes.
ಅಲ್ಲ ಸರಿ.
He is the complainant.
I am apprehending because appearing all documents.
ಹಾಕ್ಲಿ ನೋಡೋಣ. Don't worry. Yes.
Sir, next. Date.
List on third. ಅಲ್ಲಿವರೆಗೆ ಹಾಕ್ಬೇಡಿ. Jagdish.
He wants us to investigate it by.
CBI.
Pardon me, sir.
CBI ಬೇಕಾ? FBI ಬೇಕಾ?
ನಾನು ಯಾವ್ರಿಗೆಲ್ಲ ಅಬೇಟ್ ಆಗಿಲ್ಲ. ನನಗೆ ಇದು ಅಬೌವ್ SP ಮೇಲೆ ಕೊಟ್ಟು ಯಾರಿಗೆ ಕೊಟ್ಟರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಐ ಆಮ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್ ದಿಸ್ ಆಸ್ಪೆಕ್ಟ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಐ ಸಬ್ಮಿಟೆಡ್ because jurisdictional police I am not believing.
You want CBI or CIA?
No, I don't want it for us.
All right.
It is not a case such in nature.
All right.
Much.
ಏನ್ ರಾಮಚಂದ್ರ ಅವರಿಗೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Interim order.
Yes. List on 11th, interim order subsisting shall continue till the next date of hearing. Next.
Serial number 21, interim order will be extended.
That will extend.
Here for the respondent, Lokayukta Lordship.
And this is regarding, my lord, sanction by an incompetent authority as on the date of, my lord, passing the impugned order. Rule was not amended. Rule was subsequently amended, my lord. Commissioner became the appointing authority.
Here for the respondent, Lokayukta, kindly grant short accommodation for hearing.
Please, what did he say? Sanction not by the competent authority. My lord, 17 to 20, my lord. Oh, this, yes. 17 to 27 to 13:3. Yes. All right. But ಮೂರೇ ಡೇಟ್ ತಾನೆ?
ಅಷ್ಟೇನೆ, ಮೂರೇ ಡೇಟ್. As on that date,
17 to sanction granted.
yes, madam.
27 to rule amended.
Draft 13-3 finalized.
Final notification.
Till 17 to 2024, Chief Executive Officer was.
Yes, next. List on 19th.
For the respondent, my lords, I pray for an adjournment, my lords.
Now, predicate offense has been quashed. And thereafter, the supplementary complaint also, my lord, ended in the B report and
ಈಗ interim order ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದೆ. Wanted to dispose it.
Heard the learned senior counsel M. V. Sheshachala appearing for the petitioner.
My lords,
Learned counsel
I am permitted to file objections.
objections. All right, ಕೊಡಿ ಅವ್ರ copy. Counsel for the petition, respondent seeks to file statement of objection, same be filed before the registry. List the matter on 20th.
In 25.1 also I will file that objections. 25.1, my lords.
Sorry?
25.1, serial number 25.1 also I will file the objections.
ಎರಡು ಹಾಕ್ತಾ
Yes,
ಇದ್ದೀರಾ?
my lord.
ಆಯ್ತು, file it before the registry.
Yes, please, my lord.
Registry will file.
Please.
Yes. Interim order subsisting shall continue till the next date of hearing.
Please.
Next.
Appearing for the petitioners, my lords. What's one aspect, my lords, that the complaint discloses, my lords, that the day of complaint, my lords, and the offense, he states that the speeches that have been made. Lords, he gives a complaint on 4/7/2022. Lords, the speeches that have been taken place, my lords, are on 29/6/2022.
That's all right. They are a matter of record in this digital world.
Lords, but there has been no offenses, my lords. There is no,
Well
it
said.
is just a protest, my lords.
List on 2nd September. In the fresh matters list. Yes, next. ಇದು ಕೊಟ್ಬಿಡಿ ಅವ್ರು ವಾಪಸ್.
Appear for petitioner, my lord. The petitioner is seeking execution of NBW.
Yes, sir, why?
Not accommodation, man. My instruction, my lord, he has been arrested. And
Will
I'll
impose
confirm, my lord.
impose costs on this man who is not executed.
ಆಗಿದೆ ಅಂತ ಅವ್ರ senior
List on
ಹೇಳಿದ್ರು.
Tuesday in the fresh matters list.
Please.
Yes, next. Amar. Post interim order ಇದೆಯಾ?
ಇಲ್ಲ.
Post immediately after service of notice upon the respondent.
Please, date next week or week after next, my lords.
Immediately.
Only on second prayer, my petition survives. The first, my lords, has clearly indicated that there may
Yes.
not be any date.
Immediately, yes. Next. ತಗೊಂಬಿಡಿ. ಮೇಡಮ್ ಆಮೇಲೆ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗದೆ ಇರೋದು 2:30 ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ ನಾನು. Yes. Being spoken to ಯಾಕೆ ಮೂವ್ ಮಾಡೋದು? ಮೊಹಮ್ಮದ್ ಸುಲ್ತಾನ್.
My lord, in this case, my lord, the honorable court, while granting the interim order, while dictating, it has stated that as per the
Mobiles
interim
ಬಂದು
prayer-
immobile ಆಗಿದೆಯಾ?
ಅಂದ್ರೆ interim prayer ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ದೇವೆ ಅದನ್ನ ಇದ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. But unfortunately, the word unfreeze or defreeze has been left in the interim prayer, in the order typing.
In the light of further. Deep freeze ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು?
It is there.
ಎಲ್ಲಿದೆ ಹೇಳಿ?
It is in the page number 13.
No, as prayed for, I have
As
passed a
prayed for-
detailed order.
No, my lord, as prayed for ಅಂತಾನೆ ಇದ್ ಮಾಡಿರೋ. It is not the petitioner, it is the petitioner's father. FIR has been filed against petitioner's father, my lord. And my clients are even like Prestige, and they are actually, I could not do my company works.
No, the intention was not to defreeze the account at all. I have stayed the mandamus ಏನಕ್ಕೆ ಹೇಳಿದ್ ನೀವು? Direction.
No, my lord, it is not.
Harassment. ಯಾವ್ದ್ರಲ್ಲಿ ಬಂದಿದೆ ಇಲ್ಲಿ?
Against the father of this petitioner, a FIR been filed. And that too, my lord, if you look at the.
Yes, has little history, correct ಅದು?
Yes, my lord. That is undoubtable. You have mentioned the registration of the crime.
Sunil
itself
Rao
is
appear
doubtable.
ಆಗಿದ್ದಾನೆ.
Yes, my lord. There is already a check bounce case, and thereafter, after 4 years of the check bounce case been pending, They filed this crime, my lord.
NVJ ಚೆಕ್ ಮಾಡಕ್ಕೆ
Page number 13 in the interim prayer para, my lord.
ಇದು NVJಗೆ ನೋಟ್ಸ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ ಏನ್ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಈಗಲೇ ಮಾಡ್ಬಿಟ್ಟು ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ. ವೇಟ್,
Yes.
ಲೆಟ್ ಮಿ ಸಿ ದಿ ಡೈರಿ ಆಫ್ ದಿ ಸ್ಟೆನೋಗ್ರಾಫರ್. ಎಸ್. Post immediately after service of notice upon the second respondent, entry order will continue ಮಾಡಿ. Same order, 407 ನಮ್ಮದಲ್ಲ. Oh, sorry, second. So. ಅಲ್ಲ ಯಾವ್ದು ಮೇಡಮ್ ಇದು 230 ಮೂವ್ ಮಾಡೋದು ಎಕ್ಸಂಪ್ಷನ್ ಲಿಸ್ಟ್ ಕೊಡು ಲಿಸ್ಟ್ ಆಗಲ್ಲ. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರ್ movement, no representation. List on 30th. Next. The matter was moved to be taken up at 2:30. There is no ilwa. A list on 30th ಅಂತ ಮಾಡಿ. ಅದೇನ್ ಹಾಕ್ಬೇಡಿ. Yes, next.
Madam, my lord, an article of a newspaper, my lord, at page 70. The complaint comes to be filed. The article at page 70, my lord.
Page
70, my lord.
70.
70. A complaint comes to be filed at page 17, my lord, by an individual.
1 minute, sir. Page 70.
70, my lord. An article, newspaper article is being published. On that, my lord, a complaint comes to be filed.
Now, who has filed defamation?
My lord, page 17, my lord, a complaint. A resident of Bangalore at page 16 is the cause title, my lord.
Class action.
19, my lord, at para 3, page 19 at para 3, my lord.
But you could not keep quiet, is it? Huh?
But,
Therefore, respondent. Yes. Emergent notice to the respondent, returnable by the 20th of September. Till such time further proceedings shall remain stayed.
Much obliged.
Next. ಇದು 30th. ಅದು ಲಿಸ್ಟ್ ಆಗಿರಲಿಲ್ಲ ಇವತ್ತು. ಡೇಟ್ ಎಲ್ಲಿದೆ? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ?
Yes, I am special PP.
We'll take it on 30th. This was date given, it was not listed, so it is, I've got it listed, that's all. Should not escape.
What is the interim orders maybe?
List on 30th, interim order shall continue to the next date.
Hearing for respondent number 2.
All right, we'll hear you all.
It's not maintainable for the reason that.
Petition is not maintainable.
The reason, earlier they filed 482 for quashing.
FIR.
During FIR stage.
Ah.
Now the charge sheet is filed on the cognizable stage.
So?
Not let them withdraw and
No,
file
no.
first petition. It's my
ಆ ತರ interim order ಇದೆಯಲ್ಲ ಇದರಲ್ಲಿ.
An application for amendment came to be filed.
Interim order ಇರೋ ಕಡೆ application for amendment.
ಅಲ್ಲ, that has been granted.
Withdraw ಮಾಡಿ ಹಾಕೋದ್ರೊಳಗೆ ಏನಾದ್ರು
Amendment has been granted, the petition has been amended.
That's the other petitions also.
No, wherever interim orders are there, I am not disposing the petition with liberty. Interim orders ಇರೋದೆಲ್ಲ amendment. ಇಲ್ಲದೆ ಇರೋದೆಲ್ಲ fresh petition. Yes. But this will take it on 30th. Yes. Sir is appearing, is it?
Please.
Interim order may kindly be continued.
Interim order will continue. Yes. Next.
7.
Our decision, my
ಇದು
lord.
ಇವತ್ತು ಬಂದಿರೋದ? ನೀವು ಮೂವ್ ಮಾಡಿರೋದ?
I moved it, my
Ah,
lord.
yes,
Fresh matter, my lord, cover decision against accused one.
ಯಾಕೆ 2:30 ಮೂವ್ ಮಾಡಿದ್ರಿ?
Lord, I
ಏನ್
mentioned that.
ಅರ್ಜೆನ್ಸಿ ಇದೆ? ಟ್ರಾವೆಲ್ ಮಾಡ್ಬೇಕಾ?
Lord, no, my lord. There is warrants is issued except these accused, all other accused it's been quashed. my lord.
Epidemic Diseases Act.
Please, man.
Yes.
Page 91.
8990, my lord. Quashed against accused number 1.
ತೊಳಿ ಸೇವ್ ಮಾಡ್ಕೊಳ್ಳಿ. Yes,
That's all.
for withdrawal. Moved for withdrawal.
Please, my lords.
Memo ಕೊಡಿ. Memo ಕೊಡಿ. In terms of memo. Yes.
Obliged.
Orders interlocutory ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. Admission orders ಕರೆದ್ಬಿಡಿ ಅಷ್ಟೇ. ಇನ್ನೊಂದಿದೆಯಾ?
331.
330?
ಚಿಲುಮೆ ಮ್ಯಾಟರ್ ಮೇಡಮ್.
Huh?
ಚಿಲುಮೆ ಮ್ಯಾಟರ್. ಯಾಕೋ ಇನ್ನ
Okay.
ಟೈಮ್ ಬಂದಿಲ್ಲ ಅದಕ್ಕೆ. Another day ಹಾಕೋದು. Can't.
What? Today, first list and second
No, I
list will take
understand.
some time. ಅದೆಲ್ಲ admission ಎಲ್ಲ date fix ಮಾಡ್ತೀನಿ sir. Orders and interlocutory I'll call.
Please.
Admission will fix dates, yes. ಒಂದು ನಿಮಿಷ ಇದು ತಗೊಳ್ಳಿ. ಅಲ್ಲ ಆರ್ಡರ್ಸ್ ಮುಗಿಸ್ಬೋಣ ಫಸ್ಟ್. ಯಾವ್ದು ಕೊಡಿ.
I invite your lordship's attention to another 4 petitions, my lord, where the interim orders has been granted a similar case. my
Which one, sir? Which one?
lord. Writ petition,
ಕೊಡಿ. Give that.
the similar case, my lord. 4 other writ petitions, my lord.
ಮೇಡಮ್ ಕವೆ ಇದು ನಾಲ್ಕರದ್ದು ನೋಡ್ಬಿಟ್ಟು ಐಡೆಂಟಿಕಲ್ ಎಂಟ್ರಿ ಮಾಡಿಕೊಡು ಟ್ಯಾಗ್ ಆಲ್ ದೀಸ್ ಪೆಟಿಷನ್ಸ್ 19th.
Yes. The stay may be granted, my lord, the compliance. of-
Next, what is office objections?
I'll comply, my lord.
The order shall take effect only after compliance with office objections. Next,
Much.
post immediately after service of notice upon the second respondent. Enter order there.
It is.
Continue. Same order, same order. Cold.
For the petitioners.
Yes,
The parties have settled the matter.
settle the matter. What's the offense?
It's under 402.
Huh?
406,
420. Parties are present?
On number 2, my lords.
When do you keep
It is
them
settled.
present? Wednesday?
We'll file compromise in
File it, yes. List on Wednesday.
interim order may be.
List on Wednesday at 2:30 PM to report settlement. Yes. Interim order subsisting, continue order. Yes, next. Post immediately after service of notice upon the respondent, same order, same order. Interim order, continue ಮಾಡಿ.
That's serial number 34, Millers. Millers had posted this matter because before the trial court, it's
Yeah.
tomorrow, Millers.
Interim order ಇಲ್ವಾ?
In interim order, ಇಲ್ಲ, Millers. Senior.
I represent, my lord, the council. I'm sorry, my lord, I am.
Millers, I've already served the other side. Mr. Siddharth from Kumar and Kumar Associates. They have been served yesterday. They are representing the same complainant in the trial court proceedings in civil matters. And Millers, initially when they filed the similar complaint, B report is filed. We filed similar complaint, charge sheet is filed, Millers.
If your lordship should kindly have, my lord, page number 30 for one short moment, my lord. I'll just show your lordships, my lord, how fraud was played on police. Page number 30, my lord, the original complaint. If your lordship should kindly see, the complaint is in the gate anadhikarigalu kelagade in the Prabhavati avara maga Shashi Venkatama avara maga Narasimha so and so. ಇದಾದ್ಮೇಲೆ ಅವ್ರನ್ನ ಕಂಪ್ಲೇನೆಂಟ್ಸ್ ಆಗಿ ತೋರ್ಸೋದೇ ಇಲ್ಲ. ಮೇಲೆ ಇನ್ಸರ್ಷನ್ ಮಾಡ್ತಾರೆ ಎಸ್ ರವಿ ಕೃಷ್ಣ ಅಂತ. ಇದಾದ್ಮೇಲೆ ಫ್ರಮ್ 2000 my lord 13 there are civil cases.
ಏನಿದೆ ನಾಳೆ ಕೋರ್ಟ್ ಮುಂದೆ?
Millers, trial court ಮೇಲೆ execution proceedings ಇದೆ. They are
Execution proceedings are there, my lord. What has happened is,
Millers,
what has happened
filed a
is,
suit for permanent
now my lord, in the execution proceedings, one second, Siddharth, 1 second. In the execution proceedings, my lord, the moot question is who is in possession of the property. This charge sheet is, my lord, filed as if, my lord, to aid them in the execution proceedings, totally saying that they are in possession of the property, we are the trespassers. My lord, we hold sale deeds. We are all sale deed holders. Kata is in our name. Encumbrance certificates are in our name. Kindly see, my lord, column number 15 of the charge sheet. Virtually a title certificate. My lord, with this, my entire execution proceedings is lost. This is what they are trying to do. If your lordship could kindly have, my lord, the column number 17.
Who is in possession of the property?
We are in possession of the property. That's what precisely is their case also. Now, my lord, an execution petition comes to be filed.
No, one
Saying that
moment.
because,
Where do they,
because,
where, 1 minute, sir.
Millards, may
Shyam
kindly be
Sundar,
annexed.
sir,
yes, yes, my
you are
lord.
better here, not on VC.
I am sorry, my lord. Today I had to attend another matter, my lord, on NCLAT, my lord, through VC. That's the reason I had to come to office.
All
I
right,
just-
yes.
Annexure, we know that.
If
there is
your
latest
lordship
law
should
that is
kindly have, my
operative in
lord, page
YC.
number 42.
No,
Page number 42. my lord.
complaintally, do they say that they are in, you are in possession of the property?
They, in fact, yes, my lord, and their case is that we have trespassed. This is what is their case.
Where
And
is
charge
the,
sheet, my lord, is filed.
where is
and
that, sir?
If my lords may kindly
My
have, my
lord,
lord,
Yes, Sandeep, where is it?
there is a difference.
Page 30.
complaint,
In
my
fact,
lord, is
in
on
proceedings now, I have been given police
page number
protection now.
30.
Sir, who is in
My-
possession of the property?
We are in possession of the property, my lord. Respondent 2 is in possession of the property through an order passed by the trial court where a police protection order is passed and I have been, I have been given protection by the police.
Millards, if I
I
may
will
clarify,
place all of
Millards,
this record
they are
for
a
long.
site owner. In my land is 1 acre of big piece of land, Millards. It is numbered as 2/3B. They claim to be site owners in 2/3D. There is a dispute in identification. They had
If I
filed
may
suit for
please-
injunctions, Millards, decreed
My
in
lord.
their favor. Executions are filed. I have filed a comprehensive suit for declaration. I had an interim order of
No, my
status
lord,
quo for
that-
more than 7 years, which was operative. What has happened is, unfortunately, one of the parties died. His husband had withdrawn the suit. The suit filed a application for restoration. That is being pending.
Now what is the urgency for
Plus,
tomorrow?
after more than 1 year, after filing of
The
complaint,
execution
now charge
proceedings,
sheet has
my
been
lord.
filed, which they filed before the executing court to claim that they are in possession in order to get an order for police protection to enter into possession, Millards.
This is what, my lord, is precisely, my lord, they are doing. As my lord,
We'll take it on Tuesday.
Absolutely not so, my lord. If I may be given
It's
an
a limited
opportunity
protection,
to
Millards, that
enter
let them not press this.
Limited protection of what?
Millards, let them
My-
not rely on this for claiming of possession, Millards, at least.
No,
If
how
tomorrow
can-
before trial court, Millards.
we have to answer
There is an order
447.
passed
We
by
cannot do that.
the court.
Yes, list
There
on
is not
Tuesday in the,
passed by the Supreme Court.
list on Tuesday in the fresh matters list.
My lord, I may be permitted to file wakalat. My only grievance is.
No
my
mentioning, please wait.
lord, They served a copy. They served a copy
File
yesterday.
it, sir.
The party was
Yes.
traveling, my
List
lord.
on Tuesday in the fresh matters list, yes.
Grateful.
Grateful.
1 minute. Siddharth, is it?
Siddharth.
Please, please.
Learned Counsel
Abhinav.
Siddharth undertakes to enter appearance for the respondent.
Abhinav, my lord.
Abhinav R. Undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. Next.
Grateful, man.
35.
It's a matter wherein, my lords, the complainant and his family members' accounts. has
Office
been
objections, accepting the submission of the council, office objections stand overruled. List on Tuesday in the fresh
freezed.
matters. list.
Urgency is, my lords, complainant's bank accounts has been freezed along with his family members, my lords. They have-
Tuesday, yes.
Kindly. Great.
Sorry. Admission matters, Allah, ಯಾವ date, madam? Yes.
Serial number
11th.
38.
9th.
Serial number 33. Serial number 38.
List to serial number
64 mention reporting settlement.
40 is, it will come in fresh matters list on
Lord.
28,
List
that
to
I've
serial
already
number
said.
Serial number 33, like filing wakalat and objections. Serial number 33.
Registry file ಮಾಡಿ. Madam.
My lord, list 2, serial number 64, reporting settlement. Parties are present.
Serial number 38.
My lord,
Admission matters which have not reached 18th and 19th.
lord, reporting settlement, my lord, reporting settlement.
ಈಗ ready ಇದಾರಾ?
Idare, my lord. Parties are present, my lord.
Yes, admission matters, please don't mention no other date, 18th and 19th.
List 2, serial number 64.
67 the matter.
ಯಾವ್ದಾದ್ರು ಅಷ್ಟೇ, ಅವತ್ತೇ 18th and 19th. Yes, next.
Interim order.
Offense ಏನು, settlement?
My lord, 420, 504, 506, 120B, my lord.
All right, yes. Where,
Parties are present, my lord. Complainant is.
serial number ಯಾವ್ದು sir?
64, my lord. 64. 64.
Settlement ಯಾವ್ದು serial number?
64, my lord. List 2, serial number 64. Sorry, my lord.
Yes, ಕೊಡಿ ಅದು. Where is the memorandum, settlement?
Yes, my lord. There is a, it is produced as part of the petition.
Yes.
They've entered into a 64. At page number
Page
144.
142, my lord.
At 144, your lordships will
142.
find the terms of settlement, my lord.
44 is it?
144,
142, my
para
lord.
7.
Annexure J.
1 minute.
There was a suit, my lord, and this was a compromise petition filed in the suit.
Madam, page 144, clause 7. Clause 7, there are a few sub-clauses.
Yes, sir.
Really, you stop at clause D. Same. Yes, sir.
Serial number 50, POXO.
Settlement, POXO.
POXO, the last time only did access.
9. Yes, same matter.
50. 50.
Idara, ಎಲ್ಲಿದ್ದಾರೆ? No, I know, I am aware of, we were waiting the respondent's presence. Srinivas.
Respondent, my lord.
Sir. ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ವಲ್ಲ ನೀವು?
ಇಲ್ಲ, ಅದು orders ಗೆ reserve.
ಅದಾದ್ಮೇಲೆ ಇನ್ನೇನ್ ಮುಗೀತು ಅಂತಾನ?
ರಿಸರ್ವ್ ಆಗಿತ್ತು ಆರ್ಡರ್ಸ್ ಗೆ, ಅದಾದ್ಮೇಲೆ
ಆಗಿರೋದು ಗೊತ್ತೇ ಇಲ್ವಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಅಲ್ಲೇ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಬಂತು,
ಆಯ್ತು.
ರೀಚ್ ಆಗಿಲ್ಲ.
Wednesday will finish it. Yes.
Yes, sir.
My lordship, admission matter.
Huh?
48.
My lord.
Still number 48?
POXO Act, my lord, for settlement, parties are.
9, sir. No. Now with the latest Supreme Court judgment, very difficult to settle it.
Age.
9. Age ಆಗ್ಲಿ ಏನಾದ್ರು ಆಗ್ಲಿ. 9. Yes.
My lordship, 37th matter.
Separate ಇಲ್ಲ. Or 18th and 19th, all matters.
Okay.
63, my lord.
79,
my lord. Further.
My lord,
63, kindly.
my lord,
ಅದೇನ್ ನೋಡ್ರಿ?
Refer to mediation, my lord, 63.
my lord.
One. ಏನ್ ಬರ್ದಿದೆ ಮೇಡಮ್? ಚೆಕ್
My lord.
ಸುಲ್ತಾನ್. ಫ್ರೀಸಿಂಗ್ ಬಗ್ಗೆ ನಾನು ಬರ್ದಿಲ್ಲ. I also don't remember.
No, my lord, even Advocate Sunil Rao was present. He argued the matter.
Defreezing.
Tomorrow may be taken. Tomorrow.
ನಾಳೆ 2:30 will take. ಈಗ ಅಲ್ಲ, ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಮತ್ತೆ 2:30 ಹಾಕ್ತೀನಿ. ಬಿಕಾಸ್ ಈಗ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿರುತ್ತೆ. The chief's order that beyond 4:30 no list should be, no matter should be adjourned.
My lord.
Still number 79, my lord. Further hearing, my lord.
Further hearing dates, madam. One minute, further hearing,
79.
ನಿಮಿಷ.
Interim order maybe.
My lord.
1 minute.
May I refer to mediation.
ಇದರಲ್ಲಿ ಯಾವ್ದು ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಇಲ್ಲ. 18th, 19th ಹಾಕಿರಿ. 18th and 19th, 2 days. ಅಲ್ಲಲ್ಲ, ಕೆಲವು ನಾಟ್ ಟು ಟೇಕ್ ಕೋರ್ಸಿವ್ ಅಂತ ಇರುತ್ತೆ, ಅದನ್ನ ಎಂಟ್ರಿ ಮಾಡರ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಡಿ. ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ಹಾಕಿ. ಆಮೇಲೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆನ್ 30th ಹಾಕಿರಿ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 30th.
Interim order maybe.
ಎಂಟ್ರಿ ಮಾಡರ್ ಎಲ್ಲದ್ರಲ್ಲೂ ಎಕ್ಸ್ಟೆಂಡ್.
My lord, one submission, my lord. Serial number 61, my lord. This matter is pertaining to the special bench matter, my lord.
I know, we will call it on 30th only,
60.
along with the other case. ಬೆಳಿಗ್ಗೆ ಹಿಯರ್ ಮಾಡಿದ್ದು ಅದೇ ಅಲ್ವಾ?
Yes, my lord.
ಸೇಮ್ ಮ್ಯಾಟ್ರ್
It's pertaining to same matter.
ಅಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ ಅಥವಾ ಸೇಮ್ ಸಬ್ಮಿಷನ್?
It's there's an argument, my lord.
ಆಯ್ತು, ಫೈನ್.
63. 63, my lord.
30th, sir.
63 may refer to mediation, my lord. 63 mediation.